the question is the question has a presupposition that, first of all, man's morality gets to judge God. How could God do this or that? Well, first of all, as a human being, you don't get to put your morality above God's morality. That's number one. Number two,
claiming to care about people, claiming that this is a humanitarian effort. Just over the break, Christy, who's with us now, sent me some pictures, which I haven't been able to send to the team in time, but it's absolutely shocking. I don't even know if we could air these pictures. They're so grotesque. Christy, go on and please tell us what you've been seeing over the time that you've been covering this. I think we've lost your sound there. Or can I just not hear?
Can you hear me?
Yes, we can. You're back on.
Okay, perfect. So from the humanitarian perspective, the things that we've witnessed in the last 2+ years since Biden decided to open up the borders, I have seen the dead bodies. I was just now showing Maria and sending her some of those photographs. We've been up to what I was talking about is the Mexican highway. So these are particular areas where the coyotes will usher in women and children who are earmarked and already sold to buyers in the United States of America. In those, they trick them up in areas where they don't want to get caught. And then there's these staging grounds. They're very difficult to get up to some of these places. Me and my team, takes us sometimes an hour and a half to 2 hours just to hike up to these locations. And that's where you'll find the remnants of the rape trees. And I'm going to show you really quick what a rape tree looks like. I won't show the other graphic pictures. But this is, for your audience, this is just one of what a rape tree looks like. You'll see the shackles buckled to the trees. They take ropes or chains and they tie them through those shackles, and they tie the women and children down to the ground, and then they violently, repetitively gang rape them. When they're done, I will show you and send you some the other aftermath pictures. They then take their bras and their panties and they throw them up into the tree, and it's a trophy. And that signals to the next group that will be bringing in, this is how many women and children we got to rape into submission. And then we've actually captured coyotes' phones. We've downloaded them to the buyers throughout the United States of America. They are then taken down to the side of the road and the highway where they're put on transport, and then they're shipped to their different locations, all the way as far as Baltimore, New York, Ohio. We've seen almost every single state.
That is... I'm sick. I feel sick to my stomach, Christy. This is just, where are all the people talking about humanitarianism now? Where are all the people actually fighting for basic human rights for these people, who are saying, yes, bring more in, bring more in? Are you aware that this is happening? Are you aware of the rape trees? I mean, this is absolutely shocking to me. That this is what should be in the mainstream media. The fact that there are camps where military-aged men are being brought illegally, the fact that women and children are being mistreated like this is what the mainstream media needs to see. I wonder how the left would respond if they saw that.
Well, it doesn't fit into their narrative, does it, Maria? This is political. This is not about the safety and security of not only American citizens. This is not about the safety and security of the illegals trying to come up for a better way of life. This is an agenda-driven mission, period. And, me and my team, there's some of the things that I can't even describe to you what we've seen. Some of the footage we have, little babies decapitated, their bodies thrown on the side of the banks of the river, men being gutted where their organs are literally laying out on the side because they didn't pay the cartel. This is time and time again. A woman who fell to her death and entangled in the barbed wire because her husband and the coyotes were bringing her over the fence. This goes on all up and down the border, let alone the bodies that are strewn through the desert or on Texas ranchers' property. And they can't even bury them anymore because it's overwhelming the system. This is what they don't want.
The synonyms of what you know as public and private. Thing I'm going to give you is going to be an equal and opposite. You have synonyms that mean similar, and then I'm going to give you antonyms that means opposites. And every phrase that I give you is going to be there's going to be an equal and opposite anonym. Synonyms mean same, antonyms mean opposite. Okay? So the term, the word public, Public, the antonym for the public is private. Okay? You have the public, then you have the private. And one cannot exist without the other. To see one, you must know the other exists. To know one, you must know that the other exists. If you see one, you're seeing both of them. You just have to know that. Because the contracting that comes from these two phrases is 90% of your problem. Let's go further into this. The word public has other synonyms that refer to the status of public. Now again, if you pay real close attention and you take you out what you call a piece of paper and you write on that piece of paper the word public and you draw a line under it, I want you to write these terms down. I want you to get them into your psyche. I want you to begin to unravel this spell of Leviathan that has all of us perplexed about how do I use my commercial activity or energy? How do I do? You got to know. You got to know. You got to know. And I'm going to show you the magic in this. I can tell this to you all day. If you take a pen and a piece of paper and write it down, you're actually doing something that's going to lock into your psyche, because subliminally this will stick with you. And once you have read it from your own hand, once you have spoken it out loud into the universe, once you analyze this internally and externally, it's going to be very hard for these Luciferians to get you back on the plantation, especially those of you that have been studying your Moorish heritage. Okay? So, these phrases, every time you see, let me back up, not every time you see, every time the word public is used, these words need to come to mind first before you act. Okay, first word that's synonymous to the public is illusion. Yes. What do you mean? The public is real, isn't it? In commercial activity, illusion. It has the appearance, but it is an illusion. First phrase is illusion. Here's another phrase, debtor. Someone says public, you're supposed to know it's an illusion, and they're talking about debtors. That's the second synonym, debtor. The third is a compound word, limited liability. If they're talking about the public, those that are in the public have limited liability. Limited liability. Limited liability. That's another synonym for public. Anything that's in the public has limited liability. That's why people in the public always are getting in trouble, because they got limited liability. Just write these down, let them get into your psyche. Here's a fourth synonym. Anyone that's in the public, when you're identified by the court as being the public, you're also being identified as an illusion, a debtor, limited liability, and you're also fourth synonym, you're irresponsible. Yes, the public is irresponsible. You can't think for yourself. You need the government to give you food, clothes, and shelter. You're not responsible if you're in the public. You're irresponsible. Write these things down. You need to see them, say them, conform it to your frontal lobe, because this is what it is. It ain't up for debate. Do your own research on what I'm giving you. I'm here to give you facts. Those that are in the public are irresponsible. Now watch this. I'm going to give you three phrases that are synonymous with the public. Anytime someone in the public does anything, they're doing it under opinion. That's one phrase. They're doing it under opinion. The public deals with opinions. The public also deals with presumption. Opinion, presumption. What's the next one? The next one is testimony. All right, the public deals with opinion, presumption, testimony. Every time you see the word public, you need to know it's an illusion. They're talking about debtors, limited liability, they're irresponsible, and it's based on opinion, presumption, and testimony. That is what the public is in commercial activity. Okay? Here's a couple of more phrases to go with that. Those that are in the public cannot act. Why they can't act? Because it's based on opinion, presumption, testimony. They're irresponsible. They're limited. They have limited liability. They're debtors, and they're an illusion. That's why they can't act. Oh, yeah, it's starting to sink into some of you guys, but keep writing because I need you to get this. I need you to clean up this paradigm. I need you to know this. We all need you to know this. Okay. Give you another one that identifies you or is synonymous with the public. Consumers. If you are using the word consumer, you are a consumer. You're in the public. If you're unsure where you are, am I a consumer? Yeah, okay, well, I'm in the public, okay? These are synonymous with the public. Here's another phrase, a series of words, if you understand. Those that are in the public, if a judge has to deal with them in any capacity, the judge is then immune. So if they identify you as the public, then the judge automatically has immunity. Why? Because you're consumers, you cannot act, it's based on opinion, presumption, testimony, you're irresponsible, you have limited liability, you're a debtor, and you're an illusion. That's why the judge has to have immunity. Starting to make a little more sense to you now, isn't it? Got some more for you, those of you that need some cleaning up. Okay, here's a couple of other words that are synonymous with the public. Argument. If you are making an argument, best believe you've just been classified as the public. Now watch this. Because you're arguing also in the public, that means you are in dishonor. Damn. Right. These are synonymous with the public. Well, why am I in dishonor? Because you're arguing. The judge got to be immune because you're a consumer who cannot act. It's based on opinion, presumption, testimony. You're irresponsible. You have limited liability. You're a debtor, and you're in the illusion. You're in the illusion. And here's another one. This is the final one I'm going to give you dealing with the public. Now, keep in mind, all these phrases I'm giving you, I'm going to give you the antonym, the opposite of what it means in the private. The last one I'm going to give you is procedure. Everybody in the public can only deal with procedure. Procedures. All court cases that deal with any entity that's in the public, they're basing their opinion, presumption, and testimony on procedure. Why? Because people in the public, they're arguing. They're in dishonor. The judge has to have immunity. He's dealing with consumers who cannot act. They're based in opinion, presumption, testimony. They're irresponsible. They have limited liability. They are a debtor because they're part of the illusion. That's what the public is. That's what it has always been. Every time you are in contract, you're either public or private. And if you don't know who you are, ignorance of the law is no excuse. Now, let me help you out because these are all what we're talking about that are attributes of the public. Now, let's talk about the attributes of those in the private. Okay. The private, a synonym that describes the private is Unlike the public that's in an illusion, the private is real. It's of substance. It's real. It's based on your, excuse me, it's based upon your elodial estate. You know, we're talking about the sentient soul of an individual that comes from the Most High. You're real. Your substance. That's one indication that you're private. Another one, keep in mind, the public is dealing in illusion, and they're also talking about debtors. So the private must mean that you're a creditor. Whoa. Creditor. I'm real. I'm a creditor. If I'm in the private. Let's go a little further. The public said that you're an illusion, debtor, and you got limited liability. So in the private, when it comes to liability, the public has limited liability. The private has full liability. Uh-oh. The private has full liability. The public has limited liability. I know the light bulb should have went off with some of you guys when I went through this earlier this week, but we're doing a recap. The private has full liability. Why? Because you're real, you're a creditor. That's why you're fully liable. Here's another one. Remember, the public is an illusion. They're a debtor. They have limited liability, and they're irresponsible. So that must mean in the private, you are responsible because you got full liability, because you're a creditor and you're real. Responsibility. You're responsible in the private. Now, remember them phrases I gave you about this under opinion, presumption, and testimony? I'm going to give you two things that are synonymous to that in the private. What is the actual opposite of opinion, presumption, and testimony in the private is facts with an S, and truth. See, everybody's based on opinion, presumption, and testimony in the public. But when you're private, they're dealing with facts and truths. Now watch this. Remember you learned in the public that you cannot act? Well, opposite to that in the private, you're there to serve others. Serve others. See, when you're in the private, you serve others. You can't say you're private and you're not serving others. You can't say you're private and you're not dealing with facts and truth. You can't say you're private if you're not responsible. You can't say you're private if you don't want to be fully liable. You can't say you're private if you're not a creditor because you're real. You're more. Hope you get it. We're going to go a little further. The public is also identified through consumers. So if I'm private, I'm not a consumer. I create asset goods. Ooh. Wait a minute. The private has to create? Of course they do. They're creators because they're real. They're creditors. They're fully liable, and they're responsible. They're dealing in fact and truth. They're serving others, so thus for you must create asset goods. You ain't creating.
This Creditors in Commerce classroom session, hereinafter session, is the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in this session as applied to the recipient's own personal transactions, cases, or controversy, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in this session. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in this session is relevant to your transaction or that the outcome thereof will be depicted as in this session. The discussion of ideas or procedures in this session is not exhaustive of the subject being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in this session, and the fact that you may not be aware of these issues may have an adverse effect on the outcome of your procedure. It is the responsibility of each party to understand his own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. This session may be redistributed privately by any recipient to another recipient requesting them, conditioned upon the fact that this notice is provided therewith. If you have any questions, you may contact Brandon by email at harmony@creditorsincommerce.com or by telephone at 702-866-9077.
Thank you for coming. Welcome to session 21 of Creditors in Commerce at the Living Temple. Actually, I had a few announcements. I don't remember them.
Where's your seminar in Chicago?
Well, yeah, there's the seminar in Chicago. All the information's on the website. No class on the 15th. That's not what it was. Oh, how many here are on the Monday night downloads with Jack Smith? Okay, I highly recommend getting on those. They're only $2 a week. Information for that is also on the website. Go to the resources section and top link, Jack Smith Monday night downloads. Highly recommended. Yeah, we have a Tuesday and a Wednesday night call now. 7 p.m. Pacific on Tuesday and 6 p.m. Pacific on Wednesday.
One Wednesday was extremely great.
Was it? Nice. Yeah, Kevin, he's on it. Who? Kimmery? Nice. Okay, since I don't remember my other announcements, I guess away we go. Alrighty, tonight I wanted to discuss a private international remedy demand. We've talked about the commercial process and getting results as far as making something happen, compelling some kind of performance. And we're going to start with step one tonight with this particular process. And this particular process is in relation to a debt collector, a third-party debt collector. So it's a unique process, but the nature of it and the structure of it can be formatted in such a way to work with any situation. Okay? Let's see, the documents are on the website, on the private network. They're not up on the Google group yet. From now on, all the documents, I'll put a zip file on the Google group. Right there, there's actually a files section in the Google group, but it will only be the files discussed in the classroom in that particular file section. Everything else will be in the private network. There's actually a plethora of materials available on the private network that are not available on the Google group. And for those of you who have actually logged into the Google group and seen the home page of the Google group, you'll see that right at the top, a big giant link to the private network and a big giant message on how to get onto it. Okay?
Finally got on it.
Oh, did you? Yeah.
Ryan sent me 6 emails.
So, let's see, I think I had something in relation to that. Nope. Alrighty. Alright, so this particular process, now, this is a 3-step process. And all commercial processes where you're making a demand for some kind of a remedy, you want to use a 3-step process. Okay? We won't go over step 2 and step 3 tonight. I'll save that for next week. but each commercial process, such as this, an international remedy and demand, is step 2, notice of fault, opportunity to cure. Step 3, notice of default, and actually step 4, enforcement, which you're going to be setting up your enforcement from step 2, where you're putting them on notices. Here's where I'm going to go if you do not perform within the next 10 days. Okay, because your notice of fault, opportunity to cure is saying, hey, I gave you so much time, whether it was 10 days, whether it was 30 days, to perform. You haven't. Here's your last chance before you're in default, and I move towards enforcement. See, once you've gone to step 3, which is the notice of default, certification by your witness of their default, you now have certification of their agreement in the contract, so you can now move forward with your enforcement because you have their agreement to move forward on enforcement. Okay, so I'll actually read through this just to give you an idea of the nature of it. I like this one. Actually, Gordon put this together. I've made some modifications to it. Is Gordon in here? Okay. So I've made some modifications to it. This particular process, because it's for debt collectors, we didn't actually make this process to be done through a notary. Okay, now I am going to do this same process and develop samples that will be a process through a notary. However, because there are so many that have difficulty with getting notaries, which now we've got a couple, I know, in this area that are doing processes and no presentment. And for those of our listeners and viewers in Canada and the UK, they have difficulty getting presentment because all the notaries are attorneys or solicitors or whatever you want to call them. Okay, so this is titled Respondent's Private International Remedy Demand. Okay? In the upper left-hand corner is the information of who this is coming from. Now the title is Private International, meaning between jurisdictions, from one jurisdiction to another jurisdiction, remedy and demand. So the address and name in the upper left-hand corner is a private address or an address from what we in the previous classes have called jurisdiction A. So it says John Henry Doe, uppercase, lowercase, the number and the name and the street, no abbreviations. No BLVD, no ST, no, you could do P.O. Box, but I don't recommend it. Because remember, post office sits on the fence. They're kind of both sides, but you would still have to make it a non-domestic address. And the way we do that is I also have the full name of the city, no abbreviations, the full name of the state, no abbreviations. Did you know capital C, capital A is a federal jurisdiction? Yes. It is not a state or the Republic of California. It's a federal zone, okay? And I put the zip code on here, but I put it in brackets. Those of you who did the class on Admiralty, remember what it means to put something in brackets. It's not there. Underneath that, I put non-domestic without the U.S. What's the significance of that? You're outside the jurisdiction of the democracy. Has anyone tried to do the mail thing yet? Non-domestic? Have you done it? 3 cents?
Yeah, it's going out. I'm waiting for the class to come back in. I have a question on that.
Already? Can we, hold on. A very important question, okay. Well, there are, again, there's several people I know in the first series of classes we did who did the non-domestic mail. Now, I don't use the 3-cent stamp if I'm doing a commercial process because I send the mail registered. Why am I sending it registered? As opposed to certified. Remember, this is not going through a notary, and this is specifically why I made this process not through a notary. If we're going through a notary can work on both sides. They can work in the democracy and without, or with the United States or without the United States. So they can send the mail certified because they're acting as an agent. They've already taken it from one jurisdiction, they brought it into their jurisdiction, and they're doing the mailing. Whereas if this is coming from me at a non-domestic location, I am not going to use certified mail. Certified mail, benefit and privilege. Registered mail specifically is geared towards this type of transaction. It's interesting. What color is the registered mail sticker? It's red. Okay? What does red signify? Private. Okay? It's specifically for one jurisdiction to another. I've sent registered mail, no problem, to Puerto Rico. I've sent registered mail. You could pretty much probably send registered mail anywhere. Okay? So, in the upper right-hand corner, registered mail number, identifying the registration of my claim. So I have registered mail number and the registered mail number underneath, in parentheses, United States Postal Service. Okay, respondent's private international remedy and demand. Underneath that, notice to agent is notice to principal, notice to principal is notice to agent, and in parentheses, applicable to all successors and assigns. I don't know how many of you, see, I've done commercial processes with debt collectors in the past, and a lot of times they like to play hot potato. They're like, oh, I don't want to deal with this guy. And they pass it off to someone else, and then they pass it off to someone else, and I keep doing my process, and they keep running for the hills. Eventually, it was funny, I did this with a franchise tax board debt, and it ended up back at the franchise tax board because the debt collectors didn't want to deal with me doing the demands. They didn't want the liability, so they passed it back. They're like, hey, you keep it. We don't want it. We're not going to collect on it.
Did it get paid?
What's that?
Did it get accepted and paid?
Did it get accepted and paid? No, not by the debt collectors. They just passed it off.
Did they unconditionally accept your,
Did they unconditionally accept it?
the franchise board?
Well, they accepted it the first time.
Oh,
Right? When they didn't return my payment initially, they accepted it. So, it's all contract. Can you enforce your contract? Okay, respondent. Now, respondent in this particular letter, the respondent is who the debt collector is trying to collect from. Now, the debt collector sent the notice to an entity which is in jurisdiction B, signified by the name in all capital letters. Now, if the process were being done through that entity, would it be an international remedy and demand? No. That's why, again, registered mail, non-domestic address. But the respondent, all capital letters, John H. Doe. Alleged creditor, Debt Collectors, Inc., DBA, DCI Law Offices. Now, I think I made that name up, but there may actually be a company out there called Debt Collectors, Inc., and they may actually have a DBA called DCI Law Offices. I don't mean to offend. Alleged account. This is the account number that Debt Collectors, Inc., DCI Law Offices put on their alleged invoice or statement. Alleged amount, $125,000. Okay. The next subtitle, in all capital bold, offer of performance / conditions precedent. Number one, this offer of performance is based on conditions precedent which must be fulfilled and is made with sincere intent of extinguishing any alleged debt, duty, obligation, liability, and the like, intended as obligating respondent, John H. Doe, all capital letters, hereinafter respondent in above referenced respondent's private international remedy demand, hereinafter presentment. Number 2. Now, hereinafter, why do we do that? We're defining it. Now, so from this point on, when I use the word respondent with a capital R, it has a special definition. When I use the word presentment with a capital P, it has a special definition. Remember the Constitution? All the capital letters in there? It wasn't because they were writing fancy. But they didn't define any of those words because those words were to be defined later. They could define those words in the U.S. Code or in any other statute because now it's up to the interpretation of the Constitution. But because we use capital blessings, capital liberty, we can make those, the word blessings and the word liberty, the word state and the word citizen mean what we want it to mean. But we didn't define it. Notice, definitions are missing from the Constitution. Very rarely do I write a contract without definitions in it. Especially if I'm going to be using, if I don't use capital words in a contract unless I've defined those as in hereinafter. So I've given a clear distinction. This guy, John H. Doe, all capital letters, respondent. I've given a clear distinction that this private international remedy demand is presentment. Those words, terms are now defined. Number 2. Concerning this offer of performance, certain conditions precedent must be completely, unambiguously fulfilled by, quote-unquote, debt collector and or, quote-unquote, alleged creditor. In accord with Fair Debt Collection Processes Act, and in brackets, 15 U.S.C. 1692 et sequita, whereby verification is required of an alleged amount due. See, typically, we don't use code. In this particular case, what we're doing, and Title 15 is interesting because Title 15 is one of those sections of the U.S. Code that's actually positive law. So, we may not be in the jurisdiction where Title 15 applies, but the debt collector and the respondent are. Whereby verification is required of an alleged amount due. Advisory note. The term verification is defined in Black's Law Dictionary, 6th edition, as confirmation of correctness, truth, or authenticity by affidavit, oath, or deposition. Affidavit of truth of matter states an object of verification is to assure good faith in averments or statements of party. The term verify is defined in Black's Law Dictionary, 6th edition, to confirm or substantiate by oath or affidavit, particularly used of making formal oath to accounts, petitions, pleadings, and other papers. The word verify, when used in statute, ordinarily imports a verity attested by the sanctity of an oath. It is frequently used interchangeably with sworn, to prove to be true, to confirm or establish the truth or truthfulness, to check or test the accuracy of or exactness of, to confirm or establish the authenticity of, to authenticate, to maintain, to affirm, to support, to second, back as friend. Cite omitted in parentheses. So, doesn't this sound a lot like what we're asking in a conditional acceptance? Aren't we asking for verification? Right? This offer of performance is made in good faith and is condition precedent on verification of an alleged debt. Conditions set forth are as follows. A, true, correct, complete, and not misleading copies of all assignments, negotiations, transfer of rights, novation, and the like, which unambiguously delineates that debt collector is the current owner, assignee, holder in due course, entitlement holder, which absolutely evidences alleged creditor's full and complete disclosure, including but not limited to any and all implied and or express written contracts and or any and all consent with any such agreement of a novation. B, please produce all relative commercial instruments, contracts, whether implied or express, which contain exchange of consideration and which contains verified, bona fide signature of respondent. Remember, this process is for a third-party debt collector. Do you have a contract with them?
They're third party, you know.
Do they have any verification that the debt is valid?
No.
Depends on whether the first person is private or non-film.
What do you mean? Who's the first person? The person who assigned the debt? Ask that question again.
You've got the debt collector.
Here, put it on the mic so that people don't get all upset.
Debt collectors collecting.
Turn it on, turn it on, turn it on, turn it on.
Debt collectors collecting for someone, who's that party? Private or not private?
Well, if they're a debt collector, they're a corporation, right? They may
That's
be.
what I'm asking.
They may
Is
be
it a
collecting for
corporation or
an
not?
international entity, but
Right.
makes no difference.
But they're a corporation by definition?
A debt collector?
No. The party they're representing, the debt collector's representing.
More than likely.
Okay.
I mean, now, if it were a private party, could a private party, like, for instance, if I hired a debt collector to go collect, I could give them a verified statement of the debt. I could have multiple parties who have firsthand knowledge of the debt sign verifications of the debt. Now, they have a substantiated debt. They'd actually be under the guidelines of Title 15. Whereas 99.99999% of the time they're not. Please provide an absolute evidence of an equal exchange of a benefit for valuable consideration, including but not limited to an exchange or detriment, in parentheses, implied contract, unconscionable, adhesive, or otherwise. D, please produce any absolute evidence of any series of external acts giving the objective semblance of agreement. E, please produce any and all documentary evidence between respondent and debt collector and or alleged creditor that debt collector and or alleged creditor rely upon for making a presumptive claim. Can they produce that?
No.
Not unless you sign something with them. Please produce all relative commercial instruments and or notices, declarations, publications which clearly and unambiguously delineate that respondent was fully and completely apprised of all rights, duties, obligations, liabilities, costs, fees in advance or subsequent to the alleged incurrence of alleged debt, and where there has been full disclosure of all relevant terms and conditions. G, please complete and return debt collector disclosure statement. That's this 7-page document we're going to send along with it. Where was I? Please complete the return debt collector disclosure statement regarding offer of performance. H, please produce a certified copy of any and all verified judgments relative to this instant matter. Number 4, respondent expects a response regarding this offer of performance within a reasonable time of receipt of this offer, which is hereby set at 30 days, excluding the day of receipt. All responses shall be directed to the respondent at the address delineated on last page of this instrument. Respondent does not waive timeliness. However, if additional time is needed, debt collector and or alleged creditor must make a request in writing before the expiration of the above 30-day time period prescribed in number 4, setting forth the debt collectors and/or alleged creditors' reasons for requesting such extension of time with good cause shown. All such requests for extension of time will be fully considered by respondent. Either the granting thereof for good cause shown or the denial thereof, however, such grant or denial is conditioned solely upon the decision of the respondent. What have we done there? Basically, if they send any response that we consider frivolous, we can deny it. It's up to our discretion whether or not we'll extend their time or not. Right, because we're actually asking for a specific response. We're asking them to answer these 54 questions, which are by Title 15 required. Wait till we get into these. Number 8. Wait, am I on number 8? Yeah, number 8. Respondent also expressly includes with this offer of performance a debt collector disclosure statement regarding offer of performance attached hereto and made a part hereof by this reference. To ensure debt collector and/or alleged creditor clearly and conspicuously make all disclosures in writing in accord with the Fair Debt Collections Act, in brackets 15 U.S.C. subsection 1692 et sequata, and in accord with the applicable portions of the Truth in Lending, Regulation Z, 12 CFR, that's probably supposed to be, it's CRF on here, so read carefully before you use any documents. Section 226 et sequata. Debt collector disclosure statement and request for production of documents requested herein must be fully completed and received by respondent who will certify receipt or non-receipt within the prescribed 30-day time period of the debt collector and/or alleged creditor's receipt of this offer performance if debt collector and/or alleged creditor wish to have their claim considered by respondent. Now, if we were making this a process through a notary, we would change that paragraph ever so slightly. Instead of, where was it? Production of documents requested herein must be fully completed and received by respondent, would be fully completed and received by notary witness, notary public, whatever, because the notary public, in this statement, we would have stated that the notary public is going to certify their non-response. Number 9, debt collector and/or alleged creditor also tacitly consent and agree that both debt collector and/or alleged creditor have an absolute duty and obligation for preventing this alleged account from damnifying the respondent in any way, shape, or form, including but not limited to slander of credit upon debt collectors and/or alleged creditors' failure/refusal to timely respond will constitute their tacit acquiescence, thereby making tacit procuration that no bona fide, lawful, verifiable claim exists, past or present, thereby consenting and confessing judgment. Respondent reserves all rights and defenses, including but not limited to. Now, before I go into rights and defenses included but not limited to, slander of credit. What are we setting up here? Well, if they do, we're going to have a claim now because we've got their agreement not to slander the credit. So if they pursue a path of slandering credit, we now have their agreement to our enforcement against them in regards to that. Okay, so rights and defenses that we reserve, including but not limited to: initiating a counterclaim against debt collector and/or alleged creditor, filing a claim against the bond or insurance contract of any responsible party, including but not limited to debt collector and/or alleged creditor, all principals, agents, assignees, employees of debt collector and or alleged creditor whose acts, actions, omissions result in any type or kind of tort damages, slander of credit, and the like against the respondent. Sound good? Yeah. Okay. Privacy Act notice. The written communication, or this written communication, constitute respondents' due process notice for being heard, absent compliance with all requirements set forth herein. Debt collector and or alleged creditor are barred from using any defenses of immunity from prosecution for debt collectors and or alleged creditors' acts, actions, and omissions, including its/their principals, agents, assigns, employees, and the like. 11. By this notice, debt collector and or alleged creditor, including their principals, agents, assigns, employees, shall comply with the provisions of the Privacy Act of 1974 as lawfully amended at 12 U.S.C. Section 3401 and the Right to Financial Privacy Act of 1978 as lawfully amended at 5 U.S.C. Section 552A and the Third Party Summons Act, Special Procedures, 26 U.S.C. subsection 7609 for assisting the respondent in keeping inviolate certain constitutional protected privacy rights and guarantees and from preventing encroachment thereon. And all those code quotations, all in brackets. Now, throughout this entire document, every time we've referenced code, we've put it in brackets. Why would we do that? This is an international claim, right? Why would we want to joinder our international claim with United States Code? Isn't that a lower law form? Isn't this a superior or paramount law form? This is contract, the highest form of law. Statute comes under contract, and only, remember, we talked about in previous sessions, the only time law is in the courtroom is when? When you bring it there. So do I want to bring those laws and codes into my contract? No, I'm just making reference so that they know what they're violating over in their jurisdiction. Number 12, by this notice, debt collector and or alleged creditor, including but not limited to principals, agents, assignees, employees, shall comply with this demand. Debt collector and or alleged creditor shall provide respondent with a copy of any express written authorization from respondent whereby debt collector and or alleged creditor authorized for disclosing, divulging, sharing any type or kind of information with any third party in any manner, as well as by means of communication, any information, documentation, data, property, effects, and the like regarding respondent. Debt collector and or alleged creditors. Failure, refusal in providing said foregoing demanded authorization constitutes admission and stipulation that debt collector and or alleged creditor are in violation of, including but not limited to, Privacy Act. Number 13, debt collector and or alleged creditor possesses neither express written authorization nor consent from respondent for using, revealing, disclosing, divulging, sharing with any third party any secured information, documentation, data, property, effects, and the like of respondent. 14. Respondent's private international administrative remedy demand regarding offer of performance is binding upon every principal, agent, assignee, assignor, employer, employee, and the like regarding the subject matter set forth herein and herewith, and each and every principal and agent is A, barred from providing any credit reporting agency any derogatory credit information regarding the above referred debt. B, prohibited from contacting any other third party regarding the above referred alleged debt until debt collector and or alleged creditor have established the existence of a bona fide, lawful, verifiable claim in substance and in fact, and until such alleged debt is verified as indicated herein and herewith. Advisory note. Fair Debt Collection Practices Act, 15 U.S.C., subsection 1692 et sequata, states in relevant part, a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt, which includes the false representation of the character or legal status of any debt, as well as the threat to take any legal action that cannot be legally taken, all of which constitute violations of law. 15 U.S.C. subsection 1692, paragraph E, subpart 8 states, communication or threatening to communicate to any person credit information which is known or which should be known to be false, including failure to communicate that a disputed debt is disputed, is a violation of subsection 1692E. 15. Until the alleged debt is verified in accord with the Fair Debt Collection Practices Act and said verification is set to respondent, whose information is enumerated on the last page of this instrument, each and every contact received by respondent and any and all information which is not removed from the credit reporting agency constitutes harassment, slander of credit, defamation of character, creating a false public record by use of mails and wire communications with intent to obstruct lawfully communicated information, and are subject to liability for damages as well as statutory damages, including any and all legal costs or fees incurred for each and every violation. Number 16, due process is guaranteed for respondent at debt collected and or alleged creditor's Office of Risk Management and is codified in 18 U.S.C. subsections 4, 241, and 1963, and at 15 U.S.C. 1692 et cetera, and elsewhere. Respondent makes this good faith offer of performance with sincere intent to give debt collector and or alleged creditor fair consideration and ample opportunity to provide respondent with absolute verification of debt in accordance with the terms and conditions set forth herein and herewith. Failure/refusal to comply with the terms and conditions set forth herein and herewith will result in debt collector and or alleged creditor's waiver of any and all alleged claims and will be followed by a second witness, fault in dishonor, followed by a third witness, default in dishonor, executed this blank day of blank month, blank year. Respondent, John H. Doe, all capital letters. Authorized agent for respondent, signing, all rights and defenses expressly reserved. All responses to be directed to John H. Doe, all caps, and the address. Something to add, my friend? Okay. Now, the debt collector disclosure statement. My mic is dying. Starting to distort a bit. You want me to drop the volume, you mean? On the microphone or on your... How about now? Still? Well, then, okay. I mean, how about now? Can you still hear me? It might be the battery's going dead. Okay. I got batteries. Let me change my battery real quick. Uh-oh. What did I do with the document? There it is. Okay. We'll be able to whip through this pretty quick. This is just 54 questions, which every debt collector is dying to answer. Debt collector disclosure statement regarding offer of performance. The statement and the answers contained herein may be used by respondent if necessary in any court of competent jurisdiction. Notice to agent is notice to principal. Notice to principal is notice to agent. Applicable to all successors and assigns. Has the same information as on the first one, respondent, account, alleged amount, alleged creditor. Notice, this debt collector disclosure statement is not a substitute for nor the equivalent of the herein above requested verification of record, i.e. confirmation of correctness, truth, or authenticity by affidavit, oath, or deposition. Black's Law 6th edition regarding the alleged debt, and be completed in accord and must be completed in accord with the Fair Credit Reporting Act at 15 U.S.C. subsection 1681 et sequa, and the Fair Debt Collection Practices Act at 15 U.S.C. subsection 1692 et sequa, and the applicable portions of Truth in Lending, Regulation Z, at 12 CFR Part 226 et sequa, and demands as cited above offer of performance. Debt collector must make all required disclosures clearly, accurately, conspicuously in writing regarding the following. Number 1, name of debt collector. Number 2, address of debt collector. Number 3, name of alleged debtor. Number 4, address of alleged debtor. Number 5, alleged account number. Number 6, alleged debt owed. And number 7, date alleged debt became payable. Number 8, regarding this alleged account, what is the name and address of alleged original creditor if different from debt collector? Number 9, regarding this alleged account, if debt collector is different from alleged original creditor, does debt collector have bona fide affidavit of assignment for entering into alleged original contract between original creditor and alleged debtor? And we even put on there yes/no so that they could just circle it. Circle it. Yes or no? We don't want any confusion. We want them to know we just want a yes or a no here. We don't want to hear you walk in circles. Okay? Just answer the question. Did debt collector purchase this alleged account from the alleged original creditor? Yes or no? If applicable, date of purchase of this alleged account from original creditor and purchase amount. Why is that significant, Gordon?
By law, you can only collect what you paid for the debt. So when you consider that, how many debt collectors are out buying debt from banks? You think?
Pennies on the dollar.
Pennies?
10 cents on the
I can't imagine they're paying anything. It seems to me they're probably buying it for nothing more than a piece of the pie. It's possible, but I wouldn't, if I was a debt collector, I wouldn't want to buy anybody's bad credit card debt, would you?
That's why when
There's billions of debt, so how many millions of dollars you want to invest in debt that's not likely collectible? So you're in good standing. You really are. Listen to what he has to say. This stuff is very interesting. Yes.
That's why when the franchise tax board passed the debt to the collector, and I started contracting with the debt collector, they very quickly sent it back. Do you think the franchise tax board gave them their money back? No, because they didn't pay anything for it. It's a commission deal. We collect, we get to keep a portion of what we collect. So how much did they pay for it? Nothing. So that's all you owe by law. Number 12, did debt collector purchase this alleged account from a previous debt collector? Yes or no? Date of purchase of this alleged account from previous debt collector and purchase amount. Number 14, regarding this alleged account, debt collector is currently the A, we give them multiple choice even, is either A, owner, B, assignee, or C, other. Please explain. What are the terms of the transfer of rights regarding this alleged account? That's number 15. Number 16, if applicable, transfer of rights regarding this alleged account was executed by the following method. Give them multiple choice. A, assignment. B, negotiation. C, novation. What's a novation? Do you have a definition stored up? What's a novation? New.
Contract.
It's just a replacement of a debt with another debt.
Right.
Real simple.
Number 17. If the transfer of rights regarding this alleged account was by assignment, was there an equal exchange of consideration? Yes or no? 18. What was the nature and cause of the equal exchange of consideration cited in number 17 above? If your answer was yes, explain. If the transfer of rights regarding this alleged account was by negotiation, was the account taken for value? Yes or no? 20. What is the nature and cause of any value cited in number 19? If your answer was yes. 21. If the transfer of rights regarding this alleged account was by novation, was consent given by alleged debtor? Yes or no? What is the nature and cause of any consent cited in number 21 if your answer was yes? 23. Has debt collector provided alleged debtor with the requisite verification of the alleged debt as required by the Fair Debt Collection Practices Act? Yes or no? Date of said verification cited in number 23 above, which provided alleged debtor. Was said verification cited in number 23 above in the form of a sworn or affirmed oath, affidavit, or deposition? How many of you have ever gotten an oath, apposition, or deposition from a debt collector?
Never. Never.
I don't imagine you ever will. Number 26. Verification cited in number 23 above. If your answer is yes, was provided alleged debtor in the form of oath. They just got to circle one. Oath, affidavit, or deposition. Number 27. Does the debt collector have any knowledge of any claims, defenses regarding this alleged account? Yes or no? 28. What is the nature and cause of any claims, defenses regarding this alleged account? Number 29. Was the alleged debtor sold any products/services by the debt collector? Number 30. What is the nature and cause of any product services cited in number 29 above if your answer was yes? Number 31. Does there exist a verifiable, bona fide, original commercial instrument between debt collector and alleged debtor containing alleged debtor's verified, bona fide signature? Yes or no? 32. What is the nature and see if I can get this right. What is the nature and of any verifiable commercial instrument cited in 31 above, if your answer was yes? Does there exist, number 33, does there exist verifiable conclusive evidence of an exchange of a benefit or detriment between debt collector and alleged debtor? Yes or no? 34. What is the nature and cause of this verifiable conclusive evidence of an exchange of a benefit or detriment as cited in number 33 above, if your answer is yes? Number 35. Does any absolute evidence exist of verifiable external acts giving the objective semblance of agreement between debt collector and alleged debtor? Yes or no? What is the nature and cause of any external acts giving the objective semblance of agreement as cited above in number 35, if your answer was yes? Have any charge-offs been made by any creditor or debt collector regarding this alleged account? Yes or no? Have any insurance claims been made by any creditor or debt collector regarding this alleged account? 39. These are all yes-nos. Have any tax write-offs been made by any creditor or debt collector? Yes or no? Have any tax deductions been made by any creditor or debt collector regarding this alleged account? Yes or no? 41, have any judgments been obtained by any creditor or debt collector regarding this alleged account? Yes or no? 42, does the debt collector and or creditor purport to have and to hold a verifiable contract where an equal exchange of consideration exists between the debtor with the debt collector and or the creditor? Yes or no? 43, what is the nature and cause of this verifiable contract cited in number 42 above if you answered yes? Number 44, does the debt collector and or creditor purport to have and to hold a verifiable contract which purports to have a bona fide signature of debtor? Yes or no? Number 45, does the debt collector and or creditor purport to have and to hold a verified contract which purports to have bona fide signature of alleged debtor, which the debt collector and or creditor has first-hand personal knowledge of and will verify under oath, affirmation, deposition, under penalty of perjury? Yes or no? 46, if debtor and or creditor purport to have and to hold, I feel like I'm doing a marriage thing. If debtor and or creditor purport to have and to hold a verifiable contract which purports to have a bona fide signature of debtor, please produce a true, correct, and complete copy of said contract and verify under oath, affirmation, deposition, under penalty of perjury that debt collector and or creditor has first-hand personal knowledge that the debtor's signature appears thereon, or state the nature and cause why the debt collector and or creditor will not produce said contract, which purports to have a bona fide signature and cannot verify under oath, affirmation, or deposition to having first-hand personal knowledge as cited in number 45 above, if answered yes. Number 47, does the debt collector and or creditor have any type or kind of verifiable claim which complies with all the provisions set forth in the Fair Credit Reporting Act codified at 15 U.S.C. subsection 1681 et sequata? Yes or no? 48. What is the nature and cause which debt collector and or creditor rely upon for such claim, and what procedures were implemented in accord with the Fair Credit Reporting Act to investigate such claim, cited in number 47 above, if answered yes? Number 49. Does the debt collector and or creditor have verifiable facts which they rely upon in order to provide credit reporting agency with information on alleged debtor which complies with the provisions set forth in 15 U.S.C. subsection 1681 S2 and which is verifiable in accordance with 15 U.S.C. 1692G? Yes or no? Number 50. What is the nature and cause which debt collector and or creditor rely upon for such verifiable facts, and what procedures were implemented in accord with above said provisions cited in 49 above, if answered yes? Number 51, did the debt collector and or creditor advise the alleged debtor of the numerous rights which he maintains as accorded in the Fair Debt Collection Practices Act codified at 15 U.S.C. subsection 1692 et sequata? Yes or no? 52. What is the nature and cause which the debt collector and or creditor relies upon which is verifiable and clearly and accurately identifies how and when the debt collector and or creditor informed debtor of such right accorded and cited in number 51 above, if answered yes? 53. Does the debt collector and or creditor have any verifiable, articulable facts which they rely upon to furnish the credit reporting agency with unverified, inaccurate, erroneous information in violation of the provisions set forth in the Fair Credit Reporting Act, 15 U.S.C. Subsection 1681D, 1681I, 1681N, 1681O, 1681Q, 1681S, and 1681S2, and the unfair or deceptive act or practices in commerce in violation of 45A of the Federal Trade Commission Act, codified in 15 U.S.C.G. 45AB, and the Fair Debt Collection Practices Act, codified in 15 U.S.C. subsection 1691 B, C, D, E, F, G, I, J, K. Number 54. It's the last question. What is the nature and cause of these verifiable, articulable facts which debt collector and or creditor relies upon for providing unverified, inaccurate, erroneous information in violation of the provisions set forth and cited in number 53 above? If answered yes. If answered no, provide proof positive of verifiable facts relied upon under oath, affirmation, deposition, and under penalty of perjury that verifiable proof of claims exist. Debt collectors and or creditors' failure/refusal, both intentional and otherwise, in completely, unambiguously answering points 1 through 54 above and returning this debt disclosure statement, as well as providing respondent with requisite verification validating he herein above referenced, that should be the herein above reference alleged debt, constitutes the debt collectors and alleged creditors' tacit acquiescence that debt collector and or creditor have no verifiable, lawful, bona fide claims against respondent in above referred alleged account or any and all other alleged accounts not specifically enumerated herein. Debt collector and or creditor, by its their failure refusal to respond and or its their failure to provide each and every verified requisite proof as requested herein within 30-day time period allowed, will constitute the debt collectors and or creditors waiver of any and all alleged claims against respondent and indemnifies and holds harmless respondent against any and all costs and fees heretofore and hereafter incurred, including but not limited to any and all related collection attempts involving the herein above referenced alleged account and any and all related accounts. Declaration. The undersigned hereby declares under penalty of perjury of the laws of the state of California and the United States of America that the statements made in this debt collector disclosure statement are true, correct, and complete and not misleading in accordance with the undersigned's firsthand personal knowledge and belief. And there's a little notice down here at the bottom. Debt collector must timely complete and return this debt collection disclosure statement. Debt collector's alleged claim will not be considered if any portion of this debt collector disclosure statement is not completed and timely returned with all required documents, which specifically includes the requisite verification made in accordance with the law and codified in the Fair Credit Reporting Act at 15 U.S.C. subsection 1681 et sequata and the Fair Debt Collection Practices Act at 15 U.S.C. subsection 1692 et sequata, and which states in part a debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt and the threat to take any action that cannot be legally taken, all of which are violations of law. If the debtor or if the debt collector and or alleged creditor do not respond as required by law, debt collectors and or creditors' alleged claim will not be considered, and debt collector and or alleged creditor may be liable for any and all damages for any continued collection efforts as well as any damnification sustained by respondent. Please allow 30 days for processing, excluding the day of receipt after respondents and CRA's receipt of debt collectors and or alleged creditors' response. So you think they're anxious to answer that? What happened when you sent it out?
I've had the occasion to use this form for a long, long time. And this form is effective as your first impression is of it. I've yet to see it ever be responded to other than tacitly, thereby admitting there is no valid debt and no negatives have appeared on the people's credit reports, etc. You have a question?
Yeah, I do.
Microphone.
Get to that, hang on.
Hello. Quickly, regarding novation, you say it's a transfer of one debt for another. Is it necessarily between two distinct parties?
Debt's a debt. Are you going to agree to a debt?
I'm just asking, is novation necessarily between two distinct parties?
Could be or couldn't be. If it's
So
just
maybe
replacement
not.
of one debt for another.
Okay.
Does it mean two parties, three parties,
One party?
one party?
Okay, that's what I wanted to
Sure.
know.
Yes.
Gordon, quick question. As a certified paralegal, with reference to civil at 3, this appears to be a set of interrogatories. Is that correct?
It would seem so, is it not?
There is a limit on specific interrogatories. I think the number is 35, and then there's an unlimited number of non-specific. And I would ask anybody that is an attorney to check this to see that it isn't violating those limits on specific or non-specific interrogatories. This whole thing is a series of interrogatories.
Can I
it
not
a
make any
private
contract?
Pardon?
Isn't it a private contract?
Yes.
Can I not contract any way I wish? Can I make any counteroffer I wish?
Thank you.
Let's pass the mics around so we can answer any questions.
Sorry about that. Okay, so I'm just trying to stretch things a little bit here. Each one of these collection agencies sends you a letter, which is in essence a contract, and it gives you an account number, and it assigns a value to the debt that they claim they have, or it assigns a value on there, right? Is there any reason why you couldn't OID that amount from that account number for each debt collection agency at the end of the year?
Well, are they not? It's not a contract they sent you. They sent you an offer, have they not?
Yeah.
Isn't it all offer and acceptance?
Mm-hmm.
Got 4 doors with every offer. Do you want to pay something that's not valid?
No.
Something that can't be proved?
No.
Of course, nobody can prove anything, so it gets really interesting, doesn't it? We're headed to a cashless society. Is that good or bad? Looks to me like it's pretty good.
Hold on, before the next question, let's go ahead and switch the video out. All right, we'll take Fred's question. no, we'll
Fred.
transfer the
It's
mic.
not so much a question, Brandon, but getting back to your original private
He loves to make statements.
international remedy agreement, and you defined it as between 2 diverse parties.
Did I say diverse?
Yeah, you did.
Maybe distinct.
Distinct parties. With specific reference to Title 28, Section 297, the circuit courts agreed
Fred,
to...
why do you keep trying to bring code into my contract?
Just hear me out a second.
Okay.
Agreed to send their judges into the freely associated state courts for certain purposes. And then in paragraph B it says they reference these freely associated state courts as countries. So they're distinct countries by that 28 U.S.C. 297. You might want to look into that to add it as a point of law. It's very important.
Well, what's a court? What's a country?
Freely associated compact states in jurisdiction A.
That's a court or that's a country?
No, they're the courts of...
I'm just asking what's a court? What's a country? I'm just asking what those are.
Well, a country is a freely associated compact states that have to have some judicial courts, do they not? They didn't under the Articles of Confederation. They do under the Constitution.
Are you suggesting that the United States was a country as under the Articles of Confederation?
The United States of America was the title of the freely associated compact states in accordance with...
Does that make it a country? Or is it a community? Is it a society?
No, they're countries. They were separate nations under the Articles of Confederation.
Yeah, the state of the Republic of California was its own sovereign nation.
Exactly. But now under jurisdiction B, these circuit courts are allowing their judges to go in to sit on the tribunals in the freely associated compact states, which they're calling now countries.
Well, if the court is an agent of the de facto, which is a foreign trust out of Puerto Rico, is it not a Puerto Rican vessel in dry dock?
So yes, I agree with that.
Okay, so makes sense to be associating those as foreigners.
Well, non-resident aliens.
And those who enter as foreigners.
Yeah.
Okay. Yeah, let's pass the mic over here. I wanted to actually go into something too. I actually remember my announcement now. I'll remember it. I won't forget.
Just a short question. The power of perjury penalty of perjury. I'm sorry, I'm tired. The penalty of perjury. Would you be better off using the full commercial responsibility, or would the penalty of perjury be of a lesser degree in the international contract?
What kind of enforcement are you going after? See, this particular contract, we're holding them inside of their own box that they created, that they relate in, that they do business in. Okay? We're not taking them to the international courts necessarily to get our remedy, but by setting it up in such a way that we can enforce our claim in jurisdiction B right inside the box.
Remember, you're back at offer and acceptance. It's real simple. There's only 370,000 ways to do that. So don't get too hung up on little points, whether it's this or that. Are they even going to begin to, or is anybody going to begin to even fill out such a document? No. Perjury, commercial liability, it doesn't make a difference. Try not to get too caught up in the details. They're important, yes, but relax, let it flow a little bit. You could take that and rip off half that document and be fine. Wouldn't matter if the last 25 questions got involved. They're not going to verify the debt. A debt collector can't. They want to give you your remedy. Government does, and including its agents. Yes.
Even a regular credit card company really couldn't answer basically most of those questions. I mean, literally, you can, instead of debt collector, you can put Visa in there, and
you could put IRS in there.
Remember,
you could put franchise tax board in there. You could put any entity, corporation in there, and then none of them will be able to actually answer any of those questions.
Let's discuss court. You're in court. Remember, we talked about court. What is court? Court is also defined as the residence of a sovereign. What is the residence of a sovereign? That's where you are, wherever you are, you and your retinue. The IRS sends you an offer. You're in court. A debt collector sends you an offer. You're in court. This is nothing but your court record. Whether it be Visa, whether it be IRS that you send this debt collection verification to, isn't it simply a counteroffer? You have 4 doors to go through. You can simply accept that you owe the money. You can conditionally accept you owe the money upon verification. About 54 questions it would be very unpleasant to answer. Or you could go silent, or you could argue, explain, justify, all of those kinds of things. But we want to be in honor, so it's one of the first 2 doors we're not going to accept. So the IRS, Visa, somebody sends you a bill. But also remember what the purpose of law is for. Law is contract, right? We talked that it's contract. So you're making a contract. Is it not to bring harmony with your brother? We're not trying to make their lives difficult or your life difficult. What is the purpose? What do debtors do? What do creditors do? Creditors, do they not work to solve other people's problems? Yes, this is a cute document and can be pretty cutting. But what are you using it for, and why are you using it? Where's your heart? Please, you're the authority. Make things happen for it. Court. So you're in court. the residence of a sovereign, wherever you are. In common parlance, going to court is synonymous with going to trial. This will be your record. But you're going to learn to have to follow that up too. There's your first offer. Is that due process? Is that the law of the land? What is the law of the land? Does anybody have an idea what the law of the land might mean? Black's Dictionary defines it kind of interesting. The law of the land is most clearly intended the general law, which hears before it condemns, which proceeds upon inquiry, and only renders judgment after trial. It's not the Constitution. It's not some document. It's your three-part notice, private international remedy demand, notice of fault, opportunity cure, notice of default, due process. Do you not want to give your brother due process? Of course you do.
Are you not holding court?
Let's get it.
Are you not getting judgment?
Would you recommend, if you had a creditor that had 3 second creditors and themselves all at the same time making presentments, would you use all of them with the letter at one time, or do them all separately?
We've got several offers coming in on the same situation.
It's the same account, and then they have 3 separate second-hand creditors.
Great. Somebody ought to verify it.
All 4 in one letter and send them all copies of it?
No.
Each one is an offer.
It's a separate contract.
Separate all.
Somebody's contact, anybody sends you an offer. They're coming to settle with you. Are you not sovereign? What's sovereign anyway? What is sovereign? I'm a sovereign. Sovereign is defined as authority. Are you the authority? What makes one person better than another? What makes Mo Green of the IRS better than Brandon Adams? Nothing. Just contracts is what brings us all together. Yes?
Basic question. Could you please repeat what those 3 steps are for making a demand for some type of remedy? 3 steps.
For due process, you know, I entitle my documents would be notice, private international remedy demand. A second one is I entitle it notice of fault, opportunity to cure. And third one is notice of default. Because pretty soon we're going to get, these are some of the processes, but pretty soon we're going to get into, you're fending off these different things and you're making things happen for you, but sometimes these people are going a step further and reporting it anyway to the credit reporting agencies. What are you going to do? Aren't they entitled to a little, and we also have some forms for that. You can clean up your own credit, or your straw man's credit, or your ens legis. You can do all that with some simple forms. It's just business. Take them to court. Took Walmart to court, and take wardens to court, and take IRS to court. What's court? It's you. You're the court. Those patriots or those individuals that harangue about judges, my gosh, why do we go see judges? Whenever the private parties can't resolve something, we have to go to the public trustees, judges, policemen. If you and I are fighting and arguing, the policemen show up at the door. Why? Obviously, we're not resolving the matter. You know, Brandon and I had an interesting conversation earlier this week, and he brought up a word that I had never thought about before, and I'm now telling everybody about it, but I won't say anything, okay? He's got a part of a situation. It's a wonderful word. He's going to get into it later, but it's just so good, and it all dovetails into with what you're doing here, so. Hey, now, suspense has just been raised. That's good. Yes.
So again, is that why this is called private international remedy demand, to keep yourself out of the jurisdiction of a court?
Remember, you have a private side and a public side. You keep it out of the court. In common parlance, going to court is synonymous with going to trial. That means in common conversation, we tend to say, well, I got to go to court, meaning going to a building where there's a black-robed judge and some pews and chairs and a big thing, and that's court. But in reality, by saying in common parlance, that's common speech, common talk, people often refer to going to court and going to trial are synonymous, the same, when they're not. So you should learn to speak and say, well, if I have to go to trial, that's your first appellate court when you get drug into, IRS drags you into a federal district court, or you get summoned into the federal district court. If you can understand that that's really your first appellate court, they're bringing you in for a trial and to take before the public. When you stay in the private side, nothing bad's going to happen to you. Now you go to the public. But what are those courts at? We got that gal with the blindfold and the apothecary scale held aloft. And what is she weighing? Claims. Just for claims. That's it. You have essentially, I break it down to keep it real simple for me. We have judges wearing two hats, Article 1 and Article 3. Their administrative side are equity courts where they get to do what they want, and you think, God, they're no good, they're mean, they do this, they do that. No, that's just what happens to debtors. People who whine and cry and complain, they have nothing coming. People who have attorneys have nothing coming. You want to get into a law court, but what do we say law was? Contract. You want to be in a contract court. Why? Because then you have a claim. All you have to do is stand on the claim. You know, Themis is going to stand there. She's got a blindfold. She didn't want to hear you whine about mercy, about justice. Once law was sitting on the bench and mercy knelt a-weeping. Clear out, he cried, disordered wench, nor come before me creeping. Upon your knees if you appear, 'tis clear you have no standing here. Then justice came. His honor cried, your status. Devil seize you. Amicus curiae, she replied, friend of court, so please you. Begone, he shouted, there's the door. I never saw your face before. That's a poem from 1840. This what's going on in the court system today is nothing new. Chancery, equity, it's all the same. You don't have anything coming except what that judge feels like giving you, and that's as it should be. Now, if you come in with a contract or a claim, you're going to come out of there with what you negotiated for. Well, I have one of my students this next week. He gets to go before. He's been invited to come into a court because he's a doctor, and he quit paying on his Harley Davidson. He decided he's not going to pay any more FRN, so he went ahead and discharged the debt. And he's gone back and forth with them he's been to court with them. And he's won, he's got it. He's discharged the debt, they've agreed. But now they've gone to the public side and they're asking for a trial. A trial? Yes, they're going to want to test and see what he knows. I said, well, what do you think? He said, well, he actually called me and said, man, I got great news. I said, what? He says, I just been invited into court. That's what you're going to have to do. You're going to have to adjust your attitude so that you embrace this wonderful game. Now, he's going to be soon going in there. Can he stand on his claim? We're going to find out in a hurry. Now, he's been practicing a lot. Conditional acceptances. Remember what the judge's job is. She's going to judge the situation. There's the opponent right there. I got Bank of America. He's sitting right here. And over here's me. Or I got thousands of Walmart attorneys over here and me. I like that. Because it's fun to have them all there. Because they're going to give you your remedy. What are they going to do for you? I got another student. We're having a real interesting animating contest right now with one of his court cases. And the judge ordered, now this gentleman had to be, he's been learning a little bit, so he ended up in an oral telephonic court hearing the other day. And he remembered to keep his mouth shut when the other party's speaking. Now, Brandon knows this guy, and we're both shocked he could handle that. So, because he's a polemic contemner extraordinaire. This guy can argue wow. He just is good at it. Now, what's happening to him is he sat there when the other side said, yeah, he put in one of his filings and actually answered the thing in what's known as a negative averment from one of the other purported gurus in the business. And it's not a bad one. It's got some good stuff to it, and then it's got a lot of waste stuff with it, but he's got some critical, important things that really... And so here this attorney on the opposing attorney's haranguing, said this, and he'd accidentally put Admiralty on his caption set, etc. And the attorney's going, what's Admiralty? This isn't an Admiralty court. And the judge is going, it's certainly not an Admiralty court. And my student did the right thing. Nobody was talking to him. He didn't say a word. I was really shocked that he deserved accolades for that. Yeah, this is like belongs on Amazing Stories with this guy. He'll love this kind of when he hears us talk about him like this. He kept his mouth shut. And this attorney harangued and jumped up and down. I'm going to have to go back to my office. I got to look up what all this stuff is. I got to do this and that. He still said nothing. Nobody's talking to him. He learned one thing. When you're in court, when you're there with the judge, remember, it's just like a father or a mother. You got two children, and Johnny says, he took my bike and he did this with it, and John and Timmy saying, no, I didn't. And you said, be quiet. He's talking. That's the way it is. That's all it is. Judge is just sitting there trying to get the story out. When the judge finally speaks to him, he almost said nothing, and then the judge finally comes up and says, well, when they're all done, I got to do this, I got to do that, and yap, 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 yap. Judge finally says, well, you got to answer this thing by Friday. His negative averment's got to be answered by Friday, like 3 days away. Do you think the attorneys answered it? Absolutely they did. Sure. They got to go through one of the 4 doors. Whatever it is, you're going to get an answer. Now, they sent like the first day, like Wednesday or Thursday, they sent like 3 or 4 motions. Had nothing to do with answering the negative averment. What did they want? Want an argument. They want to get off that contract. Judge says, you're going to answer that by Friday. Here's our answer. Let's get this guy to argue with us, and let's get off that. Then Friday they sent some more, and I think it's a total like 12 or 13 motions over just a few days. This attorney firm's peppering him, and my client's all upset about it. This isn't right. Look what they're doing. I said, what's wrong with that? They've got a trust fund baby on the other side, has a lot of money wanting to sue him. I said, look at all the bills they get to send that other client. Why are you upset? You're supposed to help them, play your part in this great play. They're billing that other client to death. This is great. The other client's going to learn something. He's trying to collect a couple of $100,000. He's probably going to spend half that in attorney fees. How can the attorney bill unless he has all sorts of motions and things to show what he's done, etc.? All stuff that was probably boilerplate standard right out of the computer. But nonetheless, the show must go on. I said, you got to quit reviling and whining, ladies and gentlemen. You're sovereign. The world's yours. It's all yours. You're going to win every time if you make a claim, if you know how to make a claim. This will be your first start in a little step of one. And it's going to get a lot more interesting. These 2 doctors that are students are doing some really interesting things. They're having a wild time. They're up in Wisconsin with these small banks that are really vociferous about collection. They're just hanging on for dear life, where banks here just, we ain't got time for this, and hire an attorney here in L.A., opening gamut's $10,000 just to go, we're not going to bother for these little things. But over there, man, it's like life and death. And they're having a lot of fun with it. And we're going to find some really interesting things happening shortly with public ratification of your private offer or your private contract. Who do you think the judge is going to side with? The bank or you? Well, he's going to ask you all sorts of questions. He's going to try and trick you. Is that wrong or right? Of course it's right. We can't have a riffraff getting through. Can't. You're going to have to do lots of study. You have lots of learning to do. You must do it. Why not? You're going to get paid enormously well for it. Huge. You can't imagine. And you're going to win every time as you learn to assert your rights, as you learn to do this stuff. And the game's going to kick up a lot more levels. They're not just going to... The creditors are all going to go away with this thing real easy. Debt collection guys, they go away. I haven't seen one answered in messing with this document for the last 8 years. I've never seen a single response to it. Does it mean I won't eventually get one? Maybe well eventually. Can Visa, we had a question here earlier, could Visa, forget the debt collector, can Visa come? I don't know. If you worked for Visa, seems to me you're a debt collector for Visa. Is Visa going to give that employee permission and notarize it and all those kinds of things they can collect on behalf? That can go to Visa, like Brandon tells you, the IRS, anything. But rest assured, your game's going to increase some. These guys up there, it's really interesting. I can pontificate a little bit. They had one bank sending them 2 and 3 delinquencies a day. He called me and said, what do I do? They're sending these things back. It's killing me with certified mail. The bank was sending 1, 2, and 3 notices every single day. I said, they'll get tired of it. Let's give them a couple weeks, but after week 1, if it keeps going, we'll just bundle them up and ship them back. After about 10 days, they quit doing it. Now he's on this other one. He's going in. He's dealing with the utility companies. He's dealing with the banks on this, on his horse trailers, on everything. These guys are just embracing the game altogether. And they're having a little bit of fun with it. Now, they're dealing with the utility company, and the utilities after the 4th disconnect actually got turned off. Good or bad? I thought this stuff worked. Well, he did make an offer that they could pay $50,000 if they want to turn the utilities off. But they turned the utilities off, so what do we really have here? They agreed to pay you $50,000. They turned the utilities off. What are y'all upset about? Kind of like with me. I had to, should I be upset because the guards took the chess set? Nah. How about when the warden says, or when I say, well, where's my other half of the deal, the drug program? Oh, warden changed his mind. Wants to see if you can lean him up. These guys are saying, well, they turned the utilities off. Gordon, what's the deal? I said, what do you mean, what's the deal? Didn't you make an offer and didn't they accept it? Oh, yeah. I said, now you got to go collect the $50,000. They want to see if you can collect it. Are you all going to be ready to do all that? The game's going to go on. You're going to win lots of little stuff lower, and then it's going to increase for you.
What's interesting about his debt, he can answer all these questions in relation to his debt because it's verifiable. He has firsthand knowledge.
Yeah, you do have to be careful. If you go buy a car from a car lot and they carry their own paper, they'll be able to answer that. Not too many of them carry their own paper, but there are a lot of little used car lots and things that do carry their own paper. What's that? Very few. I used to have one that did that. But it's very few. So your game's going to get real interesting, but like Brandon said, 99.999% of the time, the game's yours, hands down, pretty easily. But it is going to get a little interesting for some of it. And you must be ready to be tested. What are you going to do if you go in and the judge starts threatening to put you in jail? I told you the one time about the policeman stopped me on the freeway. I had another incident the other day for being on a mobile phone. I got stopped in Manhattan Beach. Yes, and I said, I have to call you back. I have some activity here. So, and we had, numerous police cars and a lot of blocked off traffic after a while because it was going on and on. It was kind of fun. And the long and the short was they got, pretty excited, and they felt that, if I wasn't going to give a name, that maybe I should be arrested. And I said, well, let's take another tack. How about $500,000? Would you like the name for $500,000? And he did. And of course, the first officer agreed to, $10,000 for 5 minutes to wait till the sergeant got there, and another $10,000 for another 5 minutes. And when I put it on a piece of paper, got her name, she's looking at it, and she says, well, what's my name doing next to $20,000? I says, well, isn't that what you agreed to pay me for holding me here for your sergeant? No. He who does deny admits. Now, these two officers are going to find their lives get real interesting as I get stopped for $520,000. I think that's okay. You want to be arrested? For $1 million, you do. You got to go collect it now. But what's going to happen when I go before the judge? Because there is a court date. Of course there is. Wonder if the judge is as silly as those two. I don't think so. So I think the judge, when he gets the notice of what the use of that name costs, user fee, I got a feeling there's not going to be any situation going on there. And I'm still going to collect $520,000, or I'm going to have a judgment against a couple officers. Do I want to bang them and hurt them? Heavens no. But hey, everybody gets to contract for what they want. It's not what I want to do, it's what they wanted. Right? Huh? Sure, I understand their rules. You shouldn't be talking on the phone when you're driving. Justifiably so. If I had a license and I was under their rules, I think that would be, I'd have to comply. And then what's going to happen? We'll have the whole Manhattan Beach Police Department tuned up after that. Next time any of you get stopped there, don't worry, they're going to understand when you're doing what you're talking, say, oh God, not another one of those. Look what happened to Officer so-and-so and so-and-so. Is it your duty to learn that so you can do it? You think that warden and all that staff members up at a certain prison didn't have like a wake-up call? Man, it got really interesting. Nice. Welcome to the game. You got a little ways to go. Don't expect always immediate results. Stuff like this, you're going to get some great immediate results. They'll quit calling you, quit bugging you. Yes. It was interesting. The officer says, I've got a tape recorder. I'm taping this. I says, great. Why? No. Why would I need a tape recorder? I don't need a tape recorder. I don't need a video. I don't need witnesses. I know what we're going to eventually get to is how to enforce your claim. So you all think, where's my witnesses? I got witnesses. I got this. This is going to be easy. Huh? Oh, I didn't record that. Would have been kind of fun. I could have put it on the iPhone. I should have done that. It would have been a good one. I should have done that. Yes, my error. Now next time that happens, I'll be sure. What's that? That's it. We don't care. It's again, it's like Jack Smith says, Brandon says, the facts are on the moon, where they really are. You're doing 82, and so what? I'm doing a murder case for a guy in Arizona right now. This is going to be real interesting to see how this comes out. I'm quite confident we'll be victorious. He has a trial scheduled for the 13th of July. Now, interestingly, and remember, understand thyself, ladies and gentlemen, because it's not easy to do this. This guy is a 20-year type patriot who, very tough to teach much to, a bit of a polemist. I called him up one day. I says, hey, John, how you doing? He says, not good. I says, why? And he goes, he has some derogatory remarks about his wife. The so-and-so left me. God hates me. So F God and the world. I says, you're having a really bad day. And he's got a public defender for it now. I says, I can understand. So I hung up, and a couple days later on Sunday, I said, well, this is the Lord's Day. What could I do today that would be serve somebody and be in the service of my God? I'm going to try John on. I'll see if I can work with John a little, because, oh, man, this is like, he's so far down, I don't know if he can be redeemed. So I called him up, invited him over with some basic rules, and actually I believe he's going to do pretty good. Now, it's interesting. I said, you've dishonored the court, you've dishonored the judge, you've got an attorney, you got a... Now, this guy's really interesting because the murder was a road rage accident at an intersection. No question that the guy was shot and killed with a gun in his car. He's the driver and doing it. Whether him or the wife pulled the trigger, that's not the issue. Like I said, the facts are on the moon. And he says, Gordon, the guy's under influence. I said, what's that got to do with anything? I said, what's the issue here, John? I just got a question for the state. Do you or do you not have a right to defend yourself if you feel your life is being threatened? Isn't that the issue? Not whether the wife did it, whether the guy was drunk on drugs, and this guy's got an internet site that he loves to do these kinds of things. So it's a pretty wild guy that was doing it. You know, choking people in their car at intersections and things like this. Some real weird stuff. Long and the short, there's all sorts of great facts there that would lead you to believe that, to make an argument. I said, but that's not the issue. What's the issue? The issue is simply, do you or do you not have a right to defend yourself when you feel your life's threatened? Now, if you go to police and you answer all sorts of questions, and man, he did this and he did that, and yeah, we were arguing, driving along, and then it escalated, you know, what is all that? What is that door? Argument. It's hard to stop this arguing. So, here we are dealing with this child. It's really interesting. The other day, to get him in harmony, I says, let's put the termination for attorneys. Got to terminate the attorneys. Any public attorneys, any and all, blah, 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 blah. Got to send the defender's office, notify the court, blah, blah, blah. So we did that. And I said, we're going to ask for an abatement of proceedings pending an administrative proceeding by the defendant to settle the matter. That's an offer to the judge. You think the judge is going to dishonor that? I don't. We're going to see. I've used it in San Francisco, and it was very nice. I think we're going to be very good. And I called him yesterday, and I said, how you coming? He said, I'm afraid to file the stuff. I said, really? Why? He said, because, and now this guy, when he first got arrested, after fleeing the scene, one of the other patriots in the community had filed some paperwork on a bond and got him out with it. Very magical paperwork. Wow. I've got a copy of it. It's really slick stuff. And it was real interesting because he gets out of jail, and he doesn't, and when he first went in, he had some attorneys, and he was a patriot, and I want you to file this, do that, and they quit. So this other patriot guy comes along, files these bonds, files this stuff, and he gets out on that. They put an ankle bracelet on him. And a few weeks later, he knows, I want to get the ankle bracelet off, so he hires a couple of high-powered attorneys. 2 days later, the attorneys say, we have a court hearing. You forged the documents that got you out. He says, no way. Oh, yes, you did. You forged the documents.
Right. Now, the one, and it was just on May 16th. Now, the increases this year are higher than the past, but that's basically due to inflation being higher than it's been in the past. That's not surprising. Hopefully it didn't surprise anybody. You have noticed, I hope. Hopefully you've noticed what went on. If not, you probably haven't, you might wonder why there's less in your bank account these days. That could be part of it, higher costs. What's the annual contribution limits going to be for 24? A self-only HSA can have $4,150. It was $3,850 in 23, or is $3,850 this year, 2023. And family coverage goes to $8,300 you could put in the account, as opposed to $7,750 for 2023. The minimum deductible to have a high deductible health plan for 2024 will rise to $1,600 for self-only. In 2023, $1,500 was the number. And family coverage, that minimum high deductible health plan deductible, has to be at least $3,200. It was $3,000 in 23. Okay. The maximum out-of-pocket expenses for a self-only program has to be capped at $8,050. That was $7,500 in 2023. Family coverage is $16,100. That was $15,000 in 2023. And if you have one of those accepted benefit HRAs, which I'm not really a fan of, but if you do have one of those in your, HR portfolio, then the maximum amount as a available party of interest, is let's say as somebody whose records I want from the bank, in certain cases, in a collection case, and we'll talk about that issue and interpretation. We'll also talk about a case where an IRS agent got so distracted by what turned out to be a very minor issue and misread it to think it was the whole issue in a way that he failed to investigate what was really the big potential questions that never got looked at by the service. And at the end of the day, the taxpayers got out of tax court without owing a single dollar of tax, even though it's pretty clear the judge was a little skeptical that probably should have been the result. Had the IRS actually raised the issues and paid attention to the issues they probably should have been paying attention to. And finally, we're going to talk about the 2024 HSA and accepted benefit HRA inflation adjusted amounts. The IRS releases those. As always, this is the first inflation-adjusted set of numbers we get for a year, and we're getting them this year in May. So let's go to the Supreme Court's case of Pacelli versus the IRS, U.S. Supreme Court case number 211599, and the decision came down from the Supreme Court on May the 18th. Now, we're going to talk about IRC section 7609, because this is what this revolves around. And generally, 7609 was enacted by Congress a few years ago to require the IRS, when they go to a third party and ask, for instance, let's say your bank, for copies of records that relate to you, that the IRS has to notify the taxpayer of this issue and tell the taxpayer that, I said taxpayer, the tax or any party named. So bottom line, if they go, and I should say, the 7609 is really about all of that sort of thing. However, there was an exception. This is where I get in here. In collection cases, let's say that the IRS happens to believe that, you might be hiding your money with, your sister, your brother, whoever. And so they might want to subpoena the bank records of your sister. Now, the question becomes, do they have to notify you? If, in fact, that's not a joint bank account that, is with your sister, but this is an account for which you have no legal obligation or no legal interest is the key. So here comes the question we're going to look at. So we have a delinquent taxpayer who has no legal interest in the accounts or records being requested. Does the IRS have to give notice to, in this case, your sister, that there is a summons being issued, and so that your sister could go to court and fight that, because obviously her personal records are going to be going to, information about her personally will be going to the IRS. The 6th, 7th, and 10th Circuit ruled that no legal interest is required to trigger this exception. Now, this exception in the rule here for notification, generally the theory about it, the theory comes around based on the idea that if a taxpayer has already, now we have an assessment, let's say against them, they're in collection, they owe the tax, they may very well be trying to hide the money. And if notifications are sent out before the summons can be enforced, it's very likely the taxpayer who we're pursuing will quickly move funds out of his sister's account and move them somewhere else and, basically make it very difficult to trace where they're going. So the theory is that in a collection situation, you probably don't want to give advance notice in that situation, so Congress allowed for it. However, the 6th, 7th, and 10th Circuit said that you didn't have to have any legal interest. So that my example there, the IRS is going to go get my sister's bank account records because they believe I may be putting money in there. And so they want to look for things like, is my sister's account being used to pay expenses, which suggests I'm running money through there. And if we start tracing where money came in and out of her account, we may find where my stash is hidden. That's the key. Now, the 9th Circuit Court of Appeals, where I am at and where my clients are at, ruled just the opposite. They required delinquent taxpayer to have some legal interest in the object of the summons for this exception to apply. So in the 9th Circuit, the IRS would have had to have notified my sister. Notice I said would have had to, because obviously that gives away which way the Supreme Court's going. They're going to side with the 6th, 7th, and 10th Circuits and say that, in fact, the question whether or not I have any legal interest, I have any direct ability to reach into that account and transfer things, any direct legal control, doesn't matter for this purpose. That's going to be the key. Now, the Supreme Court took up the case, and Pacelli came, I should say, from the 6th Circuit Court of Appeals. They took up this case to resolve the split, because while the 6th Circuit said, yep, IRS is right, it was a 3-2 split decision of the panel, which opens up the question that, there seems to be some dispute. One of the judges on the panel cited, basically said, hey, wait, the 9th Circuit's got this right. There needs to be this, and so we get into this particular question, right? And the real question is going to come down to one of statutory interpretation. What does the statute say? And that's how the Supreme Court's going to decide this case. That shouldn't surprise people. The Supreme Court, definitely, at least the current court, certainly, and I should say probably the court for about the last decade or so, for sure, has leaned heavily on the theory that, they're going to try to use a statute as much as possible. And we got back, if you go back to the case that we had with the Mayo Foundation case in the Supreme Court, that for tax law told us very clearly, and actually for law in general, we've seen this in other cases, that if a statute unambiguously answers the question of how something should be treated for tax purposes, then we're done. Now, Mayo went and said if there is ambiguity and the IRS has issued regs on that issue, and those regs are not, an abuse of discretion or just, highly unreasonable, basically, that interpretation, as long as it itself is reasonable, even if it's not the only way to do it, that interpretation would have basically be the primary way to follow this. So let's talk about this, because this one's going to just look at the statute. Now, notice 7609A1 says essentially, if there is a summons requires giving of testimony relating to production of any portions of records made or kept or related to the, basically to a person right there, other than the person summoned, who is identified in the summons, then the notice of the summons shall be given to any person so identified within 3 days, etc., so they can have a right to challenge the summons. And that was part of the problem because the Supreme Court had ruled previously that the IRS's summons power was such that they could summons data on taxpayers from people like their bank, and they didn't have to tell the service. They could contact third parties and didn't have to tell the service they were doing this. Well, Congress put in 7609 to essentially clamp down on that and say IRS has to notify people. But they did give us an exception at 7609C2D. And that tells us that this particular rule does not apply to any summons that's issued in aid of collection, and that term will be very important. Then there are two cases. An assessment made or judgment rendered against the person with respect to whose liability the summons is issued, or category 2, the liability at law or an equity of any transferee or fiduciary of any person referred to in the first rule. So basically, those two conditions, we don't have to give notices to any party, beyond the person who we issued the summons to. We obviously have to tell them, we're issuing a summons. That's how we're going to get the data from them. But we don't have to tell anybody else in these collection scenarios. Again, the Supreme Court points out in the part of this decision that obviously a reason for that is in a collection, there's a good chance the other party, when we're in this deep in collections, there's a very good chance the other party's playing hide the money. So we need to have a way to do it without. Now, the facts of this case, basically for 12 years, Remo Pacelli underpaid his federal taxes. Now, the IRS eventually determined he was liable for unpaid amounts of other penalties, and official assessments were made against him totaling more than $2 million. Now, a revenue officer, Michael Bryant, went to collect the money and developed a few leads trying to find assets because, of course, Mr. Pacelli was not exactly, wanting them to find these assets, right? And he found that, where he may have been concealed them, he focused on bank accounts that belonged to his wife, Hannah Pacelli. And he also knew that he'd paid nearly $300,000 toward part of his outstanding tax liability from an account owned by an entity called Dulce Hotel Management, LLC. And they figured that, they might have some control over money in there, that there may be some funds in there you can reach in, because it's not normal, for an entity like this, just any entity, to pay a $300,000 personal tax liability. As well, to further the investigation, he issued a summons under 7602 to the law firm Abraham and Rose, PLC, where the taxpayer had been a client. The firm produced no records in response, saying did not retain any of the documents requested. So he decided to go one step further. Again, looking for concealed records. He issued summonses to 3 banks, 3 big banks: Wells Fargo, Bank of America, and J.P. Morgan Chase. Okay. Now, he issued a summons to Wells Fargo talking about financial records of his wife and Dulce Hotel Management. He also issued summonses to J.P. Morgan Chase and Bank of America, seeking copies of all bank statements relating to Mr. Briselli's and petitioners Jerry R. Abraham, P.C., and the law firm Abraham and Rose, PLC, basically. Now, the IRS did not provide notice of these third-party summonses, but the banks in question did notify their customers that, hey, the IRS just gave us a summons asking for all information, for various information from your accounts. We thought you might want to know. So because of that, the parties filed a motion in U.S. District Court to quash the summons. Now, in this case, they lost on their attempt to quash the motion. Basically, the courts ruled that, in fact, because the IRS, in essence, there was not this statute that required notice and a right to challenge the summons, that effectively the federal government had not waived its sovereign immunity. 7609A1 does waive that immunity against suit to challenge the summons, but they said, but in your case, because you're not covered by the exception, well, you have the exception, I should say, covers you, you don't have the right to go to court and stop this summons from being enforced against the bank, so we can't hear your complaints. Okay. Now, the actual opinion will outline some key issues Supreme Court has been using to interpret a statute. And these are things you should understand because whenever a new tax law comes out, quite often all we have is the statute to work from. So it's important to understand how the service, or how I should say, the courts, in this case, the Supreme Court, who, by the way, when they set out rules in this area, that pretty much controls everybody else down the line in courts. Number one rule that we have is if the text of the law unambiguously answers the question, that's the answer. If you were following along back in early 2021 on my podcast, you would have probably had me when I walked through why I believed at that point the law required that you could not have employee retention credits basically employee retention credits could not be used for wages of majority owner unless the majority owner had no living relatives. Now, a lot of people were really upset about that and said, well, Congress couldn't have meant that. That wasn't what they're irrelevant. If the law itself requires it, that is your answer. By the way, that is the position the IRS eventually took much later in the year on that position. And frankly, I'm very sure that is a position the court would take. They've been very consistent down this road. Also, they will point out, and we had that in the case, I think, 2 weeks ago, but, the courts can adopt absurd laws. I should say Congress can adopt an absurd law. And generally, even if it's absurd, Congress needs to fix it. The courts do not, and the Supreme Court greatly frowns upon courts adding implied provisions if there's no ambiguity inherent in the statute. We're not going to imply things, or for instance, kind of out of thin air, reach out and decide, like some people wanted us to do for the ERC, that, well, Congress intended for owners to be able to use this. So therefore, if the statute doesn't quite say that, it's really meant though, so we're going to add this implied special rule. And it's like, no, you don't add implied provisions absent ambiguity. The court's position has been very consistently that Congress wrote the law. If Congress does not like what they wrote, and quite often they have no clue what they wrote, if they don't like what they wrote, then Congress needs to go change the law. It is not the jobs of the courts to become the legislature's, editors. You go ahead and go back in and fix things like, well, you really didn't mean this, I assume. Tough luck. We're going to assume you wrote it, you voted on it, the president signed the bill, you must have meant this. That's the way this works. Okay. And when we get to the opinion, the Supreme Court, and the majority opinion, majority. There is, all 9 justices agreed with the result. We have 2 justices with a concurring opinion, Justice Jackson and Justice Gorsuch. Justice Jackson wrote the concurring opinion. Justice Gorsuch basically signed on to it. But the majority opinion, penned by Chief Justice John Roberts, doesn't take long to tell us how it's going to turn out. He tells us when he starts the analysis of the decision that, the question presented is whether the exception to notice requirement applies where delinquent taxpayer has a legal interest, only applies where they have a legal interest in accounts or records summoned by the IRS. And he goes straight in to tell us a straightforward reading of the statutory text provides a ready answer. The notice exception does not contain such a limitation. Now, this is important to understand. As I said, the courts aren't going to write text that's not there. Right? We talked about that. We talked about the issue, if you remember, about the abusive CRT, where they were trying to claim that nothing in the law said, specifically that a CRT was covered by the general rule that, the recipient of a gift gets care of a basis. And as was pointed out in that case, by the tax court, it doesn't need to, right? In essence, we don't have to go in there. And the same thing is true here. They have a set of 3 conditions under which, basically, we'll talk about those 3 conditions, if they're met, that allow the IRS to not need to issue the summons and prevents the party who is named who's named or who's been kind of involved in this summons to be able to challenge the summons. Because again, if those 3 conditions are met, you can't go add a 4th one that Congress never wrote. And that's what they're doing. As I say, none of the 3 components for excusing notice in this section mentions a taxpayer legal interest in records sought by the IRS, much less requires that a taxpayer maintain such an interest for the exception to apply. Missing wording. And the court concludes, had Congress wanted to include a legal interest requirements, it certainly knew how to do so, pointing out, additional rules Congress put in other parts of 7609 that did impose special requirements that limited the power of the IRS specifically. They're saying, look, they knew the issue, they knew what was going on, and they chose not to require there to be a legal interest. And if they don't like that, well, they don't say that here, but basically the bottom line is, if they don't like it, hey, run a bill through the House and Senate, get the president's signature, and you can impose that requirement. But the courts are not going to impose it. Now, the taxpayers' Supreme Court should narrowly define the term in aid of collection. They're going to try to argue that that's our ambiguity. They're saying, because again, one of the key issues here is, remember, only if a summons is issued in aid of collection does these 2 exceptions apply. They're saying, well, that's where the legal interest comes in, right? There's no legal interest. You couldn't actually find something, getting copies of the canceled checks from my sister, or in this case, the wife's bank account, doesn't really give you some way to immediately pay off his liability, right? It's not going to directly solve the issue. So it's not in aid of collection. But the Supreme Court basically takes the IRS position that this summons just needs to have a reasonable chance of producing useful information for collection. Not 100% sure, but just a reasonable chance. It's got to be reasonably related, right? Now, as we said, the petitioners want that narrow definition, as the court case says, and they're claiming it has to be an inquiry that only directly advances a collection efforts, right? They contend it does not directly advance those efforts unless it is targeted an account containing assets the IRS can collect to satisfy the taxpayer's liability. And they say the only way a summons issued to a third party will produce collectible assets is if the delinquent taxpayer has a legal interest in the targeted account. In essence, if he has no legal interest in his wife's account, then he can't really reach in there and pay it. He's going to have to ask her or do something else to the side. So in essence, therefore, his wife deserves to be told that the IRS is asking for copies of records on her account. But the court says that does not give fair reading to the phrase in aid of collection, right? According to petitioners, the phrase requires a summons produce collectible assets. But then they go to the American Heritage Dictionary to say aid means to help or assist, right? Petitioner agree, right? Even if a summons may not itself reveal taxpayers' assets can be collected, it may nonetheless help the IRS find such assets. And one of the reasons why you're going to see the courts go this route is, let's remember, the Supreme Court has to consider if they rule this way, the way the taxpayers want, well, this is going to be looked at in courts in other contexts, including other law enforcement contexts, right? Where, we're going to be saying, well, if I can just move it to an account that I don't directly control, then, suddenly all of these special rules could apply. So they said, consider the case where, the IRS investigation suggested that he often uses other entities to shield assets from the service, right? we thought he was using Dulce Hotel Management because we found payments, going from that account for the taxes that we had. That was, wrote on the checks on their account. We knew about that, right? And he also might have access to and use of his wife's bank accounts. So based on those leads, he requested that Abraham and Rose produce canceled checks, wire transfers, credit documents, and all their instruments used by Mr. Pelosi to pay the firm. Whether he maintains a legal interest in those records, as I said, a confounding question, is neither here nor there, right? The IRS could not, of course, use those records of canceled checks and the like to satisfy their tax deficiency. But if they showed money from that third party, Dulce Hotel Management, had been used to pay his accounts there or to pay others through Abraham and Rose, that could aid in collecting funds from the hotel management, right? It appears his funds go in there. They keep paying things for him. It indicates that they are his funds in that case. Or they could identify other alter egos where he might have hidden assets. By the same token, the summonses issued to 3 banks sought records to identify entity whose funds Mr. Pelosi had control over without formal ownership, and the bank accounts of such entities. As with the request issued to the law firm, even if 3 bank statements did not reveal a bank account in which he had a legal interest, they could lead to assets parked somewhere that the IRS could then go after and attempt to obtain, the $2 million he owed them. They said IRS investigators are like any others. They talk about detectives may very well order forensic testing or speak to witnesses to identify a culprit, even if those activities are unlikely in and of themselves to solve the crime. By conflating activities that help advance a goal with activities to accomplish it, basically the petitioners in this case, those seeking to stop it, which wasn't the taxpayer, but in this case his wife, the law firm, etc., ignore the meaning of an ADA, right? Well, the taxpayer argues, a second way, and this is a way that is an issue of statutory interpretation. One of the key issues we were trying to interpret a statute is generally, if the interpretation you're posing of the statute renders other text in the statute superfluous, right, unnecessary, then you're probably getting it wrong. And they're saying, if you don't require a legal interest in the asset, remember there were those 2 ways under collections. We had the statute, the assessment and tax and, things basically for the taxpayer. Or if it was related to just a liability, we could go look at things for we look at it for the fiduciary or transferee. So they're saying, well, realistically, if they don't need interest in the asset, then you don't need those distinctions, right? That's why if the thing is involved, we don't need those distinctions. But the court did not agree. They said the first clause requires an assessment or judgment, while the second only requires liability. The issue that the taxpayers are arguing was the first clause, basically, if you had to have an interest in the account under the first clause, which is what this one came under, right, which was an assessment or judgment, well, that would make sense then why when we got to a transferee and fiduciary that we didn't have to have a legal interest. That was the reason why we needed the second clause to open it up. But, the Supreme Court says, no, you're missing other details. The first clause required an assessment or judgment. The second only requires liability. And there are cases where a liability will arise even though there's yet to be a formal assessment of tax. They're saying those cases exist. Second clause also addresses different entities. The liability case addresses transferees or fiduciaries rather than the taxpayer in this case. So we're looking for that background. So they're saying, and the court said, yeah, that difference may not matter very often, but it does need to be a difference that'll matter very often. It just needs to be a difference. That would matter in some cases. They clearly it does. They also point out it could make a big difference if you had a bankruptcy involved, as then it would go to the bankruptcy trustee. And so, yeah, they're saying, look, therefore it makes sense why there was a difference. Now, finally, the taxpayer argued Congress was concerned about privacy when they adopted this rule. They were really shocked. The Supreme Court allowed this broad investigation by the IRS without notifying people that they were getting records from third parties. They're saying, well, Congress was upset about that. And so because of that, they really couldn't have intended this broad application of this exception, that you should have to restrict it so that, we don't put at risk the privacy of the parties involved, right? But the court said, no, the history argues for the opposite rule. What the court's going to tell us is that, in fact, Congress knew all about how broad the court's interpretation had been. And they said 7209 pretty much goes in and tells us in detail, about some very specific cases where, very limited and specific cases where we can do the exception, and they spell out different criteria. They're saying, so if the court truly wanted there to be a legal interest, right, they would have said so if that was their concern, privacy. They said the fact that they were aware of this and they crafted this provision specifically to give a carve out from their general prohibition where you'd have to notify. Well, they said that indicates Congress that this is not a case of some accidental oversight and ambiguity, but rather, no, Congress is aware of this. And again, remember, Congress, again, as they're going to tell you, they write the law, you need to follow the law. That's what they're, right? Now, they did say, and this is where we get to concurring decisions, because two justices, Justice Jackson and Justice Gorsuch, Justice Jackson pinned it, Justice Gorsuch signed on to it, have a pretty long discussion about how the IRS shouldn't run too far with this decision. That, there are clearly restrictions, even if the legal interest rule is not one of those restrictions, that this does not allow the IRS to conduct, just a wild fishing expedition. Justice Jackson specifically posited a case where, well, we think this guy who's trying to evade paying the tax, we think he's using a lot of fake identities, and that also in doing that, he is using, let's say, 3 or 4 different credit cards with different names. So we know that he uses a particular dry cleaner, right, to get his clothes cleaned. And we're thinking, he might change up the credit card he uses there. So, Justice Jackson posits that the service could ask for every single invoice, every single credit card charge slip, right, from Visa, MasterCard, American Express, that went through this dry cleaner, which would show everybody that went to this dry cleaner. And they could do all of this without ever telling the dry cleaner. That they could do a wildly invasive look at the entire financial details of this dry cleaning operation, because one particular customer who made up a very minor part of their sales for the year, might have used more than one credit card. And she's saying, that would, in her view, and that of presumably of Justice Gorsuch, be a clear overreach. However, the majority decided that this was not the time or the place to talk about the limits of this. They would leave that for a later case. So that's the reason why we have the concurring opinion. But in any event, 9-0 decision says definitely in this case, the IRS does not have to give notice. Next up, we're going to talk about the case of Carson versus Commissioner. This is yet another tax court bench opinion. We've had one of those, another one recently. This one is docket number 23086-25, and it was issued on May the 18th. Now, the IRS went to tax court with what they stated was a hobby loss case involving an activity that was a business for the taxpayers' children's rodeo activities. At least that's how the service viewed the case. However, that wasn't what was really going on, right? And it's not as if the taxpayer tried to hide that fact. The taxpayer, in fact, specifically told the agent what was happening, but the agent nevertheless continued down the, this is a business for the kids' rodeo entries. Okay, we'll talk about how we get there and how the agent really should have been looking somewhere else, but he wasn't, right? And what was going on, as the court makes pretty clear in its decision, it raises a number of questions on its own, but the IRS fouled up entirely by blowing their chance to look into that and rather issuing the assessment and going to court on a totally different theory that once we got to court and the judge paid attention to what the IRS had been told by the taxpayer, said, well, you have no evidence to show even the thing you're alleging, right? You can't tell us how much was really a loss from this activity for the children's rodeo work, right? You can't really tell us that number. And, and you never mentioned this much bigger problem. And we're not going to let you just now suddenly go reopen the exam and come back later and do this. Sorry, you went to assessment. You did all of this. It's too late in the game to do something else. And, it's not fair to anybody. So I'm not going to let you do it. So let's talk about the facts of this case. In 2009, Mrs. Carson's mother transferred most of her property, including a ranch, to a revocable trust that she controls during her life. Now, her mother had received the ranch from Mrs. Carson's grandmother, right? So her grandmother died. It passed to Mrs. Carson's mother. Mrs. Carson's mother sets up a revocable trust, revocable living trust she controls during her life. Now, she is very much still alive. And during her life, if she dies and is predeceased by Mrs. Carson's stepfather, presumably her husband, the property of the trust is to be distributed to Mrs. Carson and her brother equally. If the mother dies before the stepfather dies, then the property of the trust becomes a life estate for the stepfather, and at his death would be distributed to Mrs. Carson and her brother equally. So a fairly traditional revocable living trust estate planning job. Now remember, because it is revocable and Mrs. Carson could just reach in, take all the assets out of the trust and render everything else irrelevant going forward, it's going to be considered a grantor trust, and everything in the trust, all the income, etc. in the trust would be taxable to Mrs. Carson, or her mother. I should say not Mrs. Carson. But then it did something weird. In successive agreements dated in 2013 and 2016, Mrs. Carson agreed with her mother that she, Mrs. Carson, would contribute financially to the ranch. And every year they would then eventually agree at the end of the year how much, if any, cash distributions would be made from the ranch to Mrs. Carson. Okay, this is kind of weird. So Mrs. Carson is paying for the expenses of the ranch. But she only gets money from the ranch if her mother and her agree that she should get some. And they never agreed that she should get any, right? That was going to happen. So from 2014 to 2019, she made substantial financial contributions, I'll get the word out, to the ranch by paying its expenses. Okay? And, the ranch made money by selling cattle. The receipt from cattle sales were reported on the returns of Mrs. Carson's mother, period. So all the income coming in was making income from selling cattle, and all the income coming in was getting reported on Mrs. Carson's mother's return. Mrs. Carson was going to essentially report the expenses for the ranch on her return. She didn't report any income because mom never really agreed to allow any cash distributions, and none was ever made to Mrs. Carson. Now, this arrangement is odd for a lot of reasons. Like, first thing is, it really kind of looks like a partnership, kind of. Secondly, it's really weird because remember, since the ranch was held in a revocable living trust and Mrs. Carson could remove the ranch from the trust at any particular time, it's a really odd partnership where I agree to pay expenses for this ranch. I agree the trust gets to keep all the income, but I get no security whatsoever, right? Tough luck. Mom decides she doesn't like something I did. She decides to disinherit me and, decide the ranch will go to my brother. When I die, she could do that. She could take the money out. She could take everything out of this trust, form a brand new trust. The brand new trust would not give anything to Mrs. Carson. So it's a weird, there's a whole bunch of issues with this structure. Okay. And the court will recognize that. There's also whether related parties are assigning income that is not in line with the economics of the situation, which is also probably a very real question here, right? It's not really in line with what's going on. But unfortunately, the IRS agent was distracted by a bright, shiny object, the rodeo activities, right? Their two children lived at the ranch. They helped in the ranch business raising cattle for sale. They used horses, some which involved to compete in cash prize rodeo. So, they'd use the horses when they're on the ranch, but then those horses would also be used by the kids in rodeos, right? And they perform manual labor for neighbors of the ranch. Okay. Now, here's where it gets and what I think attracted the IRS's attention in 2017 and 2018. The only income report, remember, since Mrs. Carson didn't get any distributions, none of the sale of cattle income ever got reported on their Schedule F. What was reported there was the rodeo winnings from their children, and in 2018, they added a small amount of compensation of labor for working for local ranches. Now, in both cases, the amount of income was minimal compared to the expenses in question. But again, neither year did either ranch show any income from any activity except the children's rodeo winnings and, in the year 2018, $1,867 for compensation for labor performed by the Carson's children for other local ranchers. That was the bright shiny that got the attention. Kind of like those things, remember the old line about the dog, right? You have the dog who's supposed to be checking for stuff, but then always looks up and sees squirrel. Yes, the IRS agent saw squirrel. So we now have squirrel and he wants to chase it, right? Because this looks like, in his mind, he now sees a textbook hobby loss situation where parents have kids doing something, that the kids just want to do. Kids participate in activities. Those activities may be expensive. Maybe they do have some cash prizes. So if there's a little bit of cash prize involved, the parents somehow say, oh, well, little Johnny's competing in whatever we're competing in. And, little Johnny wins $2,000, this year from that. So we're going to say it's a business and therefore claim a deduction for $200,000 worth of expenses that relate to Johnny's competition in, trying to be a professional spelling bee winner or whatever Johnny's trying to be a winner in. Okay. So that's kind of where we go. Now, we've definitely seen cases like that, and we've seen those fall apart entirely, right? It could be the taxpayer's children. It could be the taxpayer themselves doing something. We've seen some cases over the years where they were pursuing auto racing or some other activities where there were prizes awarded, but the prizes were nowhere near being able to offset what they were putting into the activity, which was kind of where we were looking there. So, yeah, we're looking for that activity. Okay, so watch out for the squirrel. Let's get rid of the squirrel. So, in essence, the agent determined that this activity was a rodeo solely. He did that despite being told by Mrs. Carson. She explained exactly what was going on here. Ranch was my mother's, right? It was my mother's. It went into the trust. She and her agreed that I would pay the expenses of this ranch, and mom would decide, how much of the ranch income I would get. Okay, so this whole thing's put in front of the agent, but the agent continues to just view the entire thing as rodeo activity. Okay, ignores entirely the issue about, well, if we accept her story, we got a whole bunch of other things we should raise and a whole bunch of other objections we should raise. Objections which I think reading, what we get in this case, the court probably would have accepted. Okay. So the court said at trial, right? She testified the expenses were mainly related to the ranch rather than the rodeo. The IRS litigating position is premised on the Schedule F expenses being the rodeo activity only. They claim they lost $120,000 per year entering their children in rodeo, when in reality they lost this money primarily by paying for ranching activities. And the IRS never challenged the profit motive of selling the cattle. In fact, profit motive probably wasn't our problem. It was assignment of income, right? Basically allocating income and deductions among two related parties in a way that doesn't reflect what was economically going on. But in any event, the IRS position under Section 183, the hobby loss rule, makes no sense in light of the court's determination that these were ranching expenses related to raising cattle, right? Different problem, right? Now, the court said, and IRS, it's too late to go back and change your story. They said, first thing is, yes, there is some rodeo expenses in there. Almost certainly there are some expenses related to rodeo in there. But because, the taxpayer has detailed records, we already know that. However, she didn't bring them to trial because she, quite reasonably concluded that you weren't challenging the support for her records. So, support for the expenses claim, you were just challenging everything on hobby loss rules. And so proving what expenses related to what part of the activities wasn't something she was ready to produce at trial. And the court said it's perfectly reasonable she wasn't ready. And secondly, they said, so if we try to figure out how much of the rodeo, how many of the expenses related to rodeo, so we could theoretically do a hobby loss on the rodeo activity, the court said the most we could do is what would be rough justice, coming up with some wild guess as to how much of the expenses related to the rodeo. And frankly, IRS, it's your fault that we'd have to do that. So we're not going to go ahead with this. We're going to say, basically, we're not sorting the deductions. So they held that the IRS had waived the right to refocus the challenge on the narrow rodeo activities because, they basically were responsible for the situation where we didn't know which expenses related to rodeo and which didn't. And they held, secondly, they said, look, at the end of the day, because you failed to bring things up, I'm going to hold that the activities reported on Schedule F for 2017 and 2018 were engaged in for profit because, there's no way we can tell from here. And I realize the burden's on the taxpayer, but you specifically outlined the reasons why this problem existed. That was your assertion, and your assertion's absurd on its face. And I don't then have to just assume, well, it must have been a hobby loss anyway. No, I don't need to do that. You do need to have, while your assertion is given basically the presumption of correctness, your assertion is clearly not correct. And I'm not going to allow you to come up with a secondary assertion at this point because, frankly, there's not sufficient information today that you looked into or that you suggested that the taxpayer bring to this case, to make that determination in any way, shape, or form. Now, this is why I said the court now decides to twist the knife a little bit. The court recognizes the presence of possible concerns related to this relationship in question. Yeah, there are a lot of questions about this relationship and the tax consequences of structuring this thing this way. Lots of problems. This is definitely not an endorsement by the court of what, Mrs. Carson and her mother did. However, they said the government did not opt to delve into or raise those issues, and they weren't part of what's before the court. They're not part of the decision. End of game. Sorry, IRS. You lose. Okay? So it's one of those things to watch for. Now, you might think, well, what does this matter? It's just the IRS getting something wrong. But what happened here is something that happens to us in tax practice. I want to point that out. And it's something that I see practitioners do too. This is not just something we see the IRS do, right? We see the IRS do it. They can do it as well, right? What happens is quite often when a tax issue, problem, or matter arises, when we first see it, we form an immediate impression of what the problem is, what the issue is, and how this thing should be going forward. And the problem becomes a couple of problems that we as humans tend to have. And they divide into two categories of things that are very similar, related, but not quite the same. There is the concept of confirmation bias, right? Which is a key issue. Confirmation bias says once we have determined what we believe is the way something works or is, we tend to ignore or explain away quickly any information contrary to that and probably just don't even notice it, right? And overly focus on every little detail that backs up our assumption. Like in this case, that once we discovered the kids are in rodeo, and then we discovered that the amount of their income was small on Schedule F versus the deductions reported on Schedule F. Well, we were focused and the mindset kicked in that, it's rodeo activity. And the fact that the agent was told multiple times about this problematic, let's be honest, agreement between mom and the taxpayer that itself had all kinds of issues, but the agent didn't go there because the agent was now focused on only hearing that this was a rodeo activity. Totally missed the other problem. The other problem is a somewhat related thing, which is completion bias. And completion bias is that once we have a plan of attack, once we have a goal in mind, we tend to decide that's still our goal, even if contrary information comes up suggesting that we really need to change our focus here. In this case, again, the agent, because he was looking at this as solely a hobby loss issue and solely related to parents paying huge sums of money for their kids' hobby and trying to write off against their wages, he's totally focused on that view, missed the fact that, in fact, there was a secondary goal here. Instead of, in fact, you probably should have just ignored the whole rodeo issue and focused more on the bigger problem of what mom the agreement between mom, her mother, the trust, and the whole setup here, because it doesn't look like a trade or business structure that would ever reasonably be entered into by two unrelated parties. So I think there was a lot of problems there, a lot of issues. I think it's very easy. The service could have argued that what Mrs. Carson paid was somebody else's expenses, not hers, and so not deductible on her return. You know, they also could have claimed, and they would have pointed out, that she had no assurance she would ever get anything from the ranch, right? The ranch could disappear from the trust tomorrow and she could do nothing about it. And no rational person would have gone into and said, I'm going to pay this money in for this purpose, right? Secondly, if you even do think somehow she was in the business, then basically the expenses shouldn't have all ended up on Mrs. Carson's return and the income all on her mother's return. That there were other things, gifts, or various other things happening, but it was not a trade or business with a loss deduction on Mrs. Carson's return. I think there's a very, very, very good chance you could have developed lots of ways to attack this structure. But again, the agent was focused on only dealing with one thing. The agent had identified, he already had in his mind what the issue was. The solution to that is to nail him for the hobby loss. You've got all this history of cases where people have done absurd things like this. So you're just so focused there, you didn't see, even though there were red lights flashing and just things that should have gotten your attention, you focused on the other thing. I've seen practitioners do the same thing when they face a client issue. And this can cause problems, not just, ignoring a big IRS problem that you should have seen coming, but also ignoring maybe even benefits to the client or positions that would have been taxpayer friendly because the additional information you got came after you had already committed to your view of the problem and your view of the solution. Always, always be ready to question your assumptions because, we need to understand, be skeptical. Always, make sure that you don't dismiss. If you look at new information, are you currently looking at it from a confirmation bias perspective? That nothing could change your mind, or from a completion bias perspective, I already got this plan to solve this thing, so this is irrelevant. Don't worry about it, right? Or take care of the situation. That was the problem here. It's a problem we see in practice quite often too. Okay, let's talk about the new inflation-adjusted HSA and accepted benefit HSA and accepted benefit HRA limits for 2024. This is Revenue Procedure 2023-23. Right? Now, and it was just on May 16th. Now, the increases this year are higher than the past, but that's basically due to inflation being higher than it's been in the past. That's not surprising. Hopefully it didn't surprise anybody. You have noticed, I hope. Hopefully you've noticed what went on. If not, you probably haven't, you might wonder why there's less in your bank account these days. That could be part of it, higher costs. What's the annual contribution limits going to be for 24? A self-only HSA can have $4,150. It was $3,850 in 23, or is $3,850 this year, 2023. And family coverage goes to $8,300 you could put in the account, as opposed to $7,750 for 2023. The minimum deductible to have a high deductible health plan for 2024 will rise to $1,600 for self-only. In 2023, $1,500 was the number. And family coverage, that minimum high deductible health plan deductible has to be at least $3,200. It was $3,000 in 23. Okay. The maximum out-of-pocket expenses for a self-only program has to be capped at $8,050. That was $7,500 in 2023. Family coverage is $16,100. That was $15,000 in 2023. And if you have one of those accepted benefit HRAs, which I'm not really a fan of, but if you do have one of those in your, HR portfolio, then the maximum amount newly available in the plan year is $2,150 this year, up from $1,950 in 2023. So again, this is just basic inflation adjusted numbers. This is always the earliest ones we get every year, and the others will not start coming until normally October. So it's another 5 months plus before you'll probably hear about anything else. But this gives you the basic numbers for 2024 for health savings accounts and for, if you have one of these, accepted benefit health reimbursement arrangements. Okay. This has been the current federal tax developments for the week of, let's see, this week is the 23rd, right? Or no, 22nd. May the 22nd, 2023, right? It's brought to you by Capital Financial Education and by your state side of CPAs. If you have any questions, you can email me, edzollers@currentfederaltaxdevelopments.com. You can also check for me on the Connect sites for Arizona, New Jersey, Minnesota, Illinois, Washington, and I also do try to watch in if there's anything posted on Idaho's discussion boards, see if there's something there. If there is, I try to answer if I can. Otherwise, hopefully you're having a good week here in tax time. You got through your not-for-profit extensions. It lasts on the 15th. So now we're in that nice summer period where everything now is getting the extended things taken care of as we race to our first due date on September 15th. So you got a little bit of time there, 4 months to deal with it, right? So we're heading toward that. But otherwise, we will be back here next week talking about whatever goes on in the area of current federal tax developments.
Some of you asked me a couple of days ago in the comment section to one of my recent videos if the FDIC has enough funds to cover insured deposits in the worst case scenario. It is true that during the 2008-2009 financial crisis, the FDIC was running low on funds to support failing banks. It is true. FDIC was out of cash then, and there is a possibility that if something similar happens now, of a similar magnitude, FDIC will struggle. For example, news outlets have already started to report that FDIC is going to have to do some juggling in order to make those payouts. We're talking about insured deposits. If all depositors decided to take their money today, the Federal Deposit Insurance Corporation does not appear to have enough money in its insurance fund to pay everybody off. On paper, the agency doesn't appear to have that much cash. The FDIC's funding relies on the insurance premiums that it collects from member banks, or the so-called assessment revenue, and interest earnings on the assets invested in U.S. Treasuries. So those are the two main revenue sources for the FDIC that it uses to pay off depositors if something happens to a bank. By the end of 2022, the latest report published, and I'm assuming that Q1 2023 isn't available yet, the FDIC reported that its deposit insurance fund had only $128 billion in it. So if worse comes to worse, in the worst case scenario, does this mean that insured deposits won't be made whole? Well, according to the FDIC statute, the FDIC can borrow, it does have the authority to borrow directly from the U.S. Treasury without any limits. However, it may choose not to do it. And it happened during the 2008 crisis. It chose not to borrow from the U.S. Treasury. It didn't borrow from the U.S. Treasury. Instead, the insurance agency asked the banking industry to prepay their premiums for the fourth quarter of 2009 and for all of 2010, 2011, and 2012 to increase the FDIC's liquidity. So, does the FDIC have funds to cover all insured deposits in the United States? It does not. There is absolutely no doubt about it. It didn't have enough funds to cover Silicon Valley Bank insured deposits, to be honest with you. But in theory, the agency should have other means to get that cash when necessary. The question here is not so much in what's available to it, but what it chooses to do with those resources that it does have access to. Whose agenda will it lean towards, right? Thank you for watching the video. If you enjoyed this video, do give it a like and consider sharing it. It goes a long way here on YouTube and Rumble. Subscribe to my channels if you haven't already. I would love to have you back for my next one. And if you enjoy reading as much as I do, I recently started a newsletter that you might enjoy for additional content. You'll find everything linked below. I'll see you in my next one.
Cash value is the goal, but she's 72 years old. So we were looking at scenarios for her, mom, we'll call her in this video, but she asked the question, would it make more sense to take this policy out on my adult son instead, who's 41 years old? He, like myself, has no health issues. Does it make sense? It should make sense because I'm much older, and the older you are, the more expensive the life insurance policy is, correct? On that point, when you're older, does that mean that life insurance is more expensive? Yes, and it's especially true if you're purchasing a life insurance policy purely for death benefit. You'd find for a 41-year-old or a 72-year-old, the 72-year-old is going to spend a lot more money for the same death benefit than what the 41-year-old would. What if cash value is the goal, though? And mom says, I don't care about the death benefit. We're already covered there. Cash value is what I'm interested in. Does age still play a role? Meaning, does it make significantly more sense to take a policy out on son, age 41? The answer is maybe. Now, in this particular case, mom's an engineer. She's a software engineer. So I can talk through the benefits of taking out a policy on a younger individual and an older individual, which we're going to go through. I'm going to show you how really to approach a policy when you're trying to find out, do I take it out for myself at an older age or on a younger individual? But with that said, she's an engineer. So if I just tell her what can be done or just tell her how it works, will that be satisfactory? Probably not. Typically, someone who is an engineer, perhaps an IT professional, or anyone who's very analytical or just has experience and wants to see information because they believe what they see, not just what they hear. They want to see the proof here. How does it work? I want to understand how the watch is built. That way I can really use the policy to the fullest degree. So we've got option A, policy for mom, 72 years old, or policy B, or option B, policy for son, 41 years old. The funding she is interested in is as follows: $100K per year for 5 years. That actually is a range anywhere from $100 to $200K per year for 5 years. So a total of $500,000 to $1 million that she would like to funnel into a whole life insurance policy where, again, cash value is the goal. Is the death benefit important? That's a question I'm going to ask, especially for someone who is in their 60s or 70s, because leaving a death benefit to the next generation is valuable to a lot of people. When you look at whole life insurance, even when cash value is the focus, the death benefit often is appealing to individuals, especially those that are interested in generational wealth, because how is that death benefit paid? Income tax free. Now, if you have a high net worth and you exceed the estate tax limits, there are trusts that you can have a policy owned by in order to be passed more tax efficiently, but that is a question for a tax attorney, which is a good topic for another day. But with that said, is the death benefit important? Now, I actually brought this up a couple times throughout the conversation, not asking the same question over and over again because that'd be rude, but I did want to have certainty that the death benefit is not important to her. And she had expressed that explicitly. She said, the death benefit's not important. Okay, so let's look at numbers and focus on the cash value. But here's what we really want to make sure of when we look at a comparison for any two individuals. But when we have an age gap like this, it's very important to make sure it's an apples to apples comparison and that nothing is manipulated. So what we're going to look at here is the same company, the same product, and the same policy design. What I mean when I say same policy design, we're funding the policy with what? $100,000 per year for 5 years. Where is the money going? That is the most important piece when the product is being designed. Here's the premium, $10,000. Here's our paid up additions rider, $90,000. There's a 1090 split. The MEC limit is set at $100,000 for both examples. So that's everything that's the same. What's the difference here? The death benefit will be different. So the death benefit, mom at 72 years old, for a policy with a $100,000 MEC limit. Here's the important piece. For a 72-year-old female, she will need a total death benefit of just about $930,000. That will give her that MEC limit of, guess what? $100,000. For the 41-year-old son, how much life insurance does he need? insurance for a MEC limit of, guess what? $100,000. What do you notice about that? The older you are, the less life insurance you need for the same MEC limit. The older you are, the less life insurance, less death benefit you need to be able to pay in the same dollar amount as a younger individual. Why that is valuable to be aware of is often we think as we get older, it's going to be more expensive. If I'm going to purchase this policy, it's going to cost me a lot in premium to purchase this death benefit. If cash value is the goal, and I want to pay in $100,000, I can do that and have a policy that has the same MEC limit as a younger individual. I'm just going to start with less death benefit naturally. So we need less life insurance, which will help keep the costs low. So we're going to look at an example on that, and then we'll come back and hit a specific question she had on the term rider cost. So let's begin with illustrations here. So we'll begin with mom. We've got mom, age 72. Where's the money going? First off, where's the funding on these stereo instructions? Here you go. $100,000 per year. And if we look at this down here, got $100K per year for 5 years and nothing thereafter. We can scroll down. We're going to look at this on Excel in a little bit too. But there's your funding, $100K per year. So the money is going where? Well, up here is your insurance premium. In green is your paid up additions rider, PU8 rider, which we like to refer to as what? The rider to accelerate the cash value of a whole life insurance policy. This will do the trick. So here's your PUA payment. What do you notice about that and the premium? We're going to look at those two figures. PUA is literally 10x the base premium. So the most aggressive design that we can illustrate with this particular company, this is Guardian, is whatever our base premium is, 10x that per year going into PUAs, with the exception of the first year, where we could go as high as 50x. But we're going 10x year in and year out. In this particular example, a 5-pay for mom at age 72 is the most efficient. Preferred, non-tobacco, which is the second best health class. So when we look at the funding here, 100K goes in. Here's your money column, net cash value. And here's your death benefit, net death benefit. Look at that figure, $930,000. The MEC limit on this policy is just a hair over $100,000. Pays in 100. There's the cash value, 86.9. So what is that? Just about 87% in the first year. Did you think that that was possible for someone 72? A lot of times people do not think that is possible. This really illustrates the importance of policy design. And when a product is designed correctly, you can really push those insurance expenses down, in many cases, regardless of age, and maximize the cash value. What do you notice about year two? At the end of year one, you're at 86.9. If this is you, you're then paying 100K. Cash value at the end of year two is 187,375, meaning you got your 100 back, your 100,000 back, and then a few $100 on top of it. So you did not lose any money in year two. And then from that point forward, it gets better and better. When's your break-even point? Look at that, between years 4 and 5, for someone starting at age 72. So the policy is designed for maximum cash value. We minimize the death benefit as much as we could up front. We minimize it again, actually, in year 8. And this is optional. But if someone said, hey, cash value, Steve, that's what I'm interested in here. What you could exercise is this option. The earliest you could do it is after the first 7 years, has to do with the MEC test. But what we're doing is chopping off the premium, cutting any remaining term insurance, and as a result, you see the death benefit drop. So you give up death benefit, but what you get in return is a little bit stronger cash value growth. Because when you're not paying anything, her out of pocket here is 0, year 6 and 7, that premium was still due. The policy was paying for it internally, and then year 8, we can eliminate it. If we don't exercise this option, that premium is due, up until age 95, because the name of this product is an L95. I can pay into it until the age of 95. But anyway, key takeaway here. When was your break-even point? Between 4 and 5. Year 4, you were close. So keep that in mind. Let's look at the son. First off, there's your break-even. You're at 396 in year 4 for mom. You're at 404 for the son. But what do you notice about the top? There's your premium. There's your PUA. Anything different about those two compared to the last one? The policy on mom? No, they're identical. What is different? This total death benefit is not $930,000. $930,000 for a 41-year-old male with this product will give him a MEC limit of about $40,000 to $45,000. Here we're at $100,000 in MEC limit, in MEC space that is. So we've got the minimum death benefit to be able to fund the policy with $100,000 per year. So the difference with these two is this, which we did not hit on with mom. What this guy is, this target additional benefit, is term insurance that's attached to the policy. This is the cost of the term insurance rider. OYT represents 1 year term, which we're going to go through that in a little bit. We're going to go through details on that. Let's go back to mom actually. So son, $600 for the term cost. Mom, $1,600. There's a difference, huh? So again, we'll go through the term rider thoroughly. Let's look at a side-by-side here. So what we're going to look at is both the non-guaranteed and guaranteed value. So we've got a side-by-side. We will begin with the non-guaranteed values. Mom on the left, age 72. Now this reads minimum premium of $11,000. The son is $10,000. What was the base premium on both of them? Can you recall that? If we go back to the PDFs, you'll see it. It was just over $9,000. So why we have the minimum premium for mom at $11,000 and then for the son $10,000? Sometimes I like to use the word minimum commitment here, is because this includes the premium plus the cost of the term rider. So if I have a policy like this one where I can commit just to the minimum and then add additional funds into PUAs at my discretion, which is a benefit here, she was interested in that because the term rider costs more over here. And that's why it's 11. These questions come up. Hey, what's with the extra $1,000 when I compare and contrast? It's a bigger policy, maybe it's another $10,000, meaning if we're looking at $1 million per year. But that's why that's higher, a little bit higher term insurance costs. But as we look at the difference here, is it a lot initially? No. As time passes, it becomes more drastic. Let's do this. And this is going to show how much more or how much less we have in cash value with the policy for the son compared to mom. 85 and 90. So by age 85, what's your difference there? You've got about $47,000 more in cash value with the policy for the son. So let's do this. Death benefit compared to cash value. And this is if the death benefit's important. Purpose of this, what I want to know, is if I take a policy out on mom, or she takes a policy out on herself, and she passes, how much goes to the son? If he's the sole beneficiary, right? If it's going to multiple individuals, it's a different conversation. But with all that said, if she dies, let's say by age 80, if she would have taken a policy out on her son, that cash value in this illustration has appreciated to 606. However, she died, almost $750,000 is paid income tax-free to her son. Going back to that question, is the death benefit important? We also want to factor in with the death benefit, like what's happening here? This is a lump sum income tax-free check. My peers would argue that, yeah, over here you can access that cash value completely tax-free. That's true if you do everything right and you don't trigger a MEC and such. However, what if he doesn't see the benefit to it after mom passes? We can go over all the pros and cons if it's just not a fit for him. We all have feelings on certain products and strategies. It might be the best thing since sliced bread, but it's just not a fit for us, no matter who's convincing us and such. So my point is, if it's not a fit for him and he wants to exit, what happens? The gains are taxable as ordinary income to the policy owner. This is assuming we made him the owner from day one. Transfer of ownership would be a different potential taxable situation. So having a policy on her, especially if the death benefit is valuable, is cleaner in many respects. It's a lump sum income tax-free death benefit. If he wants to start a policy at that point in time, let's say it's age 85, well, what happens? Well, he can just use those proceeds to begin a policy then. But the point is, seeing numbers, especially for someone who is very analytical, or anyone really, but anyone who wants to see this, it helps really paint the picture to see which one gives you more value. And again, we're not, I gotta remember that this is income tax free. But what do you have here? What age? 91. Okay. It's neat how the insurance companies have this figured out, right? No matter how you spin the illustrations and such. So let's take a look now at this guy. So she had a question, which is around the term rider cost. So the type of term rider that we have attached.
Hey guys, Steve Parisi here. If you enjoyed the content you just saw, please subscribe, like, and hit the notification bell for future videos. If you'd like more information,
a couple of days ago in the comment section to one of my recent videos, if the FDIC has enough funds to cover insured deposits in the worst case scenario. It is true that during the 2008-2009 financial crisis, the FDIC was running low on funds to support failing banks. It is true. FDIC was out of cash then, and there is a possibility that if something similar happens now, of a similar magnitude, FDIC will struggle. For example, news outlets have already started to report that FDIC is going to have to do some juggling in order to make those payouts. We're talking about insured deposits. If all depositors decided to take their money today, the Federal Deposit Insurance Corporation does not appear to have enough money in its insurance fund to pay everybody off. On paper, the agency doesn't appear to have that much cash. The FDIC's funding relies on the insurance premiums that it collects from member banks, or the so-called assessment revenue, and interest earnings on the assets invested in U.S. Treasury. So those are the two main revenue sources for the FDIC that it uses to pay off depositors if something happens to a bank. By the end of 2022, the latest report published, and I'm assuming that Q1 2023 isn't available yet, the FDIC reported that its deposit insurance fund had only $128 billion in it. So if worse comes to worse, in the worst case scenario, does this mean that insured deposits won't be made whole? Well, according to the FDIC statute, the FDIC can borrow, it does have the authority to borrow directly from the U.S. Treasury without any limits. However, it may choose not to do it. And it happened during the 2008 crisis. It chose not to borrow from the U.S. Treasury. It didn't borrow from the U.S. Treasury. Instead, the insurance agency asked the banking industry to prepay their premiums for the fourth quarter of 2009 and for all of 2010, 2011, and 2012 to increase the FDIC's liquidity. So, does the FDIC have funds to cover all insured deposits in the United States? It does not. There is absolutely no doubt about it. It didn't have enough funds to cover Silicon Valley Bank insured deposits, to be honest with you. But in theory, the agency should have other means to get that cash when necessary. The question here is not so much in what's available to it, but what it chooses to do with those resources that it does have access to. Whose agenda will it lean towards, right? Thank you for watching the video. If you enjoyed this video, do give it a like and consider sharing it. It goes a long way here on YouTube and Rumble. Subscribe to my channels if you haven't already. I would love to have you back for my next one. And if you enjoy reading as much as I do, I recently started a newsletter that you might enjoy for additional content. You'll find everything linked below. I'll see you in my next one tomorrow. Take care.
Are you looking for an opportunity to earn a substantial monthly income while helping business owners obtain financing? Then Go Capital's broker referral program is for you. As a registered broker, you'll have access to a variety of business loan and real estate financing programs for clients nationwide. You'll also receive all the training, marketing, and sales supports you'll need to quickly start earning commissions. All this at no cost to you. Why is this such a great opportunity? With approximately 30 million active small businesses in the U.S. and banks limiting access to traditional commercial financing, loan brokers offering alternative funding are in very high demand. You can easily earn over $10,000 in monthly commissions by offering loans from $10,000 to $5 million. Go Capital services include revenue-based loans, equipment leasing, business lines of credit, unsecured term loans, commercial real estate mortgages, and more. With us, bad credit, tax issues, and high-risk industries are not a problem. Whether you're an accountant, banker, realtor, no business owners, or simply want to enter the lucrative field of alternative business lending, our broker referral program is designed for you to succeed. Join the Go Capital team and start earning today.
Week of May the 15th, 2023. Current federal tax developments are brought to you by Kaplan Financial Education and by your state society of CPAs. I'm Ed Zollers, CPA here in Phoenix, Arizona, and we're going to talk to you about some developments that came up this week. We're going to begin this week's discussion by looking at an IRS email that discusses an interesting situation that arises when a PEO, professional employer organization, ends up getting a payroll tax refund that is available to one of its clients, but when the PEO itself has a tax liability outstanding and unpaid. And as we'll discover, there are some risks to using a PEO, and this turns out to be one of them. Secondly, we'll talk about an IRS private letter ruling that dealt with a settlement of a case between a credit union and a class action group involving whether the credit union had given proper notices, and if they hadn't given proper notices about attempting to essentially repossess a piece of property that they had secured note on, that the note was essentially a non-recourse note. Now we're going to talk about whether or not the IRS ruled the 1099 had to, or I should say, the credit union had to issue a 1099-C for cancellation of debt. And I also want to talk about why it's not quite the same question as asking if the individual receiving the 1099-C is going to have to report cancellation of debt income. So we'll talk about the distinction of those two, and also what the IRS ruled and why the IRS said that, yes, the credit union needed to issue a 1099-C in this case. Finally, we'll talk about a piece of news that broke early in the week, reported by Tax Notes today, regarding a IRS decision to change the Schedule K-1 for partnerships for 2023. We're going to be asking for more information regarding debts, and apparently specifically recourse debts, I should say, and specifically looking at issues such as if you have a debt restoration obligation that is, that is basically responsible for some or all of your amount of debt that's being allocated to you, and also if you have a debt guarantee that is creating some or all of the debt being allocated to you on the K-1. So we'll talk a little bit about that, and maybe too somewhat what the IRS may be looking for there. Well, let's start out with that email that came out this past week on May 12th. It is the IRS ECC 2023-19015. And this was in an email response. The IRS basically examined a situation where a PEO submitted a claim for refund on behalf of one of its clients regarding the employee retention credit. Now, this, of course, is what's gotten all the attention right now, but what the IRS is going to rule here would apply anytime that a PEO was filing for a refund of taxes on behalf of one of its clients. We'll talk about what's going to be our problem. The question became, what happens if, when that refund is being issued, the PEO has outstanding, unpaid, overdue federal tax liabilities? The question becomes, can the IRS offset the refund which is being generated by one of the PEO's customers? Can they offset that against that unpaid tax of the PEO? And the conclusion reached is that essentially the IRS does have and plans to use the authority to offset that refund that may go back and tie to the client of the PEO, but they're going to use that to pay off, or to apply, at least pay down, the amount of unpaid taxes by the PEO in that scenario. And I suspect this email, which specifically mentions the ERC, is being written at this point because we have probably somewhere at least one PEO that has this particular problem. And you're going to have some customers that probably won't be happy with the answer. So the key question was asked was, and this appears to be an internal question, which normally it would be, between, let's say, somebody at a service center or somebody who received the claim for refund. They're going to approve the claim for refund, but they've noticed that there's this unpaid liability by the PEO. And they wanted to know whether or not the IRS is authorized to offset that refund. Now, let's remember, professional employer organization comes to employers and says, hey, look, we can take care of all your HR and payroll tax needs. Just, go ahead, hire us. We will be the employer of all your employees. We'll file W-2s. We'll get the payroll taxes paid. Of course, going to charge you for this, and you're going to pay us. We'll probably also provide them with a medical plan, maybe a 401k program. We'll give you HR services that you probably aren't big enough to have an HR department, so we'll cover that for you too. And we'll do all that for you, and obviously you pay us a fee on top of all of this. And the PEO, under special rules, is allowed to essentially file one giant 941 and attach this thing called Schedule R that gives details on each of their clients. But it is still a 941 for the PEO and under the PEO's EIN, because the PEO is the one that issues the W-2s. Technically, they're the employer of the employees. So the question was asked, can we do this? Can we do this offset? And the email goes on to take a look at IRC section 6402A. And it says basically they have the discretion to credit any overpayment against any liability in respect of an internal revenue tax on part of the person who made the overpayment, right? And they note that they had made the decision that for all the COVID credits, not just the ERTC, but also, for the sick pay credit, that, and paid family and leave credit, the COBRA credit, and other things, that they were going to do the offset. So the IRS position had been, let's say you were an employer filing your own 941, you had unpaid taxes. I don't care if they're income taxes or if you're, just payroll taxes, trust fund, not trust fund. You have unpaid federal taxes. Their position was that when that refund is generated, we're first going to offset the taxes that remain unpaid. So the question becomes at this point, what in the world do we do? And it's also true for refundable credits, which most of these are, right? You could get them even if the entire credit exceeded your basic tax liability. So bottom line, we can go ahead, we can do that offset. But now the question becomes, who's the person, right? Is the person the PEO, or is the person the client of the PEO? In essence, whose tax liability could be offset? And generally, 6402, as they noted here, specifically talks about the person that made the overpayment and tax liabilities of that person, right? So the IRS email concludes that if a taxpayer uses a third-party payer, the process for claiming credits differs depending upon the type of third-party payer used. If a taxpayer uses a Section 3402 agent, a certified professional employer organization, or a non-certified standard PEO, that pays wages to individuals as part of services provided to a client pursuant to a service agreement between the PEO and the client. Although the credits are attributable to wages paid to the client's employees, the PEO in this case, our example is a PEO, but the same rule would apply to a 3502 agent or a certified professional employer organization, is the party actually claiming the employment tax in an aggregate amount on a single line on Form 941 filed under its own EIN. If a refund's ultimately issued to the aggregate filer, it's then between the filer and their client. The TPP, in essence, the PEO in this case, is the one that will then have to write a check back to its client, or at least write a check maybe net of whatever processing fee they might have charged to file that particular revised return. The IRS does not issue the check back to the client of the PEO. And we've known that since the IRS came out back in 2021, 2 years ago now, with the basic initial ruling, the notice on how we're going to handle employee retention credits after the 2020 changes, late 2020 changes. And so we've always known that the credit goes to the PEO, and then the PEO has to turn around and decide, and write checks to all of their clients that were part of that refund claim. And they get to decide how that gets done with the agreement. The email notes, the IRS is not a party to these agreements. They are private agreements, which IRS has no right to see, at least not without asking, and showing relevance between the parties. In this case, they wouldn't really need to ask to see it. If you audit the 941s, you're examining the aggregate total of line credit claimed on line 41 used by use the client by client allocation information. The IRS does not issue refunds or make credit adjustments to the client entity themselves, but rather everything goes through that third party payer's payroll tax return. So any credits are a reduced liability of the TPP. Because of that, right, that means that since they cannot itself use the Schedule R information to determine their ultimate tax liability, they couldn't determine what type of refund. There'll be various situations where they could even attempt to figure out how much to give to each individual client. So essentially, the IRS simply gives it to the TPP, and it's up to them, based on their agreement with their clients, to get a refund to them. As a practical matter, as they're saying, they really are giving a benefit to the TPP, because let's say, they owe $20,000 of unpaid income taxes on, let's say they're a C Corp, and they offset, a $100,000 employee retention credit refund, offset 20 of that and only give them 80, they still got $100,000 worth of benefits. Their income tax liability has been paid off. In theory, the idea goes, they would still be probably under their contract obligated to write a check for $100,000 or $100,000 less whatever processing fee they were going to be charging to their customer. But of course, remember, we've got a situation here now where supposedly the PEO has unpaid taxes. That's probably not a good sign. And so they go on as a practical matter to note that, hey, you know what? They understand that the employer may have practical difficulties receiving payments if they have outstanding federal tax liabilities, because it probably means the PEO is in financial difficulties. That's a civil matter between the third party payer and the employer. And frankly, the IRS says, look, you don't have to use the PEO. You've decided to use one. This is one of your risks. That if you have for whatever reason, including a credit nobody saw coming, that you have suddenly a right to against payroll taxes, and Congress decided to run it through there, well, that means that credit is going to first be used to offset PEO unpaid taxes. And you just realize that's a risk. Now, as I noted, this issue is not solely limited to employee retention credit claims. And there should be a number of client concerns if that happens. In essence, this is more than just a concern that, hey, I'm not getting my employee retention credit, which would be a concern, but there are bigger problems you might have. Right? So what are their concerns they may have understanding this, or they should have? Look, they might not receive an ERC or any other credit that they are owed. That's a practical potential problem with the offset. And honestly, you think about this, they're being held indirectly liable or responsible for getting the PEO's tax liabilities paid off because they qualified for a refund. So because of that, hey, that refund, sorry, we're going to take what's effectively a refund that you generated, your employees generated, and we're going to go ahead and use that to pay off these unpaid liabilities that your PEO hadn't handled. And we're just going to do that because that's how we roll. There's a third bigger problem here, and this is probably some of the major ones. If your PEO is unable to pay its federal taxes and we get to the point where the IRS is offsetting refunds against their outstanding tax liabilities, you have to seriously have like major red flags should be flying. This PEO is in financial bad straits. And that's a huge problem because you're still technically liable for the trust funds if that's what they didn't pay. And other things like that. There's a whole bunch of problems. And remember, these people are taking money generally from your account and paying your employees. If they flake out and don't pay the employees, you're going to be on the hook for that as well. So this is a fundamentally big red flag. And frankly, in a case like this, I think once you saw the offsets and people found out about it, that PEO is probably going to go out of business rather rapidly here. And it's probably going to be a nasty situation. So one of the issues you talk about is, what could we do to mitigate risks if we're going to be using, we want to use a PEO because we want that access to the medical program. We want that access to a retirement plan, right? That'll be much less expensive to be run, access to that HR, and it gets rid of our payroll problems, gets the W-2 issued. How, though, do we protect ourselves, or what can a client do to try to protect themselves in a case like that? Well, one thing we need to do is we should investigate any PEO we're using. And the term on the slide here says make sure they have a good reputation. I would say just understand, have they been around a long time? Have they worked with a number of employers? What's kind of the feedback? Has there been anything that could give you pause to think that this company may financially not be in the best shape? Because if that's true, then yes, we have some major concerns about using this PEO. We would like to find some evidence that the PEO is financially stable. That may be easier said than done, but they may have, financial statements that were reported upon by an outside third party. They may have other reports that are done, but some evidence that they're there, that they can offer you evidence about their financial stability, preferably ones that are better than many of our cryptocurrency exchanges claim to offer, showing how wonderful shape they were in. Obviously, this is an easy thing to get, but it is something to look at. One thing you may want to consider, because of these exposures, remember a few years ago, Congress created the Certified Professional Employer Organization, the CPEO. Now, those have to have books looked at by a CPA with an independent report. There are various other things. There's not a guarantee they won't flake out on you financially, but they are basically cleared on showing at least enough financial strength at the time to make it less likely they're going to flake out. So I certainly would consider using a CPEO. And if that CPEO loses that status, maybe because of financial issues, so it's really something to keep an eye on. You're going to insist they maintain that status, and if they ever lose that status, your contract should allow you to move away from them. And it's a practical matter because it's always possible a PEO go out of business, or a PEO could do something that suggests, we may be at risk with our taxes not being properly paid. You need to be prepared to switch to a different PEO if necessary. In essence, tell your clients, you should always have a plan somewhere as to how you would handle it if, for whatever reason, we suddenly became concerned about the PEO and we need to switch to somebody else or take over payroll ourselves. What would our plan be if that happened? It always could happen, and we need to be aware of that. And that is one of the things that just is a responsibility management needs to be working on if they're going to be using a PEO. And finally, we're going to talk about a private letter ruling 2023-19009 issued on May 12th. And this deals with a credit union that settled a class action suit related to alleged defects in their pre-sale notices that they sent out when they were planning to repossess property and essentially seize the security that related to it. So they're going to be seizing it, and we're kind of looking at dealing with that. So how's that going to work, and how are we going to do it? Right? Key issue there. Eventually, the parties settled the lawsuit, and the credit union agreed to write off the deficiencies. And what I mean by deficiency, let's say you owed $20,000 on a car loan, and we discover that, they repossess the car. The car is only worth, they only get $15,000 when selling the car. That's a $5,000 deficiency. Well, to settle this class action suit, which the credit union had been disputing, but the final settlement, they agreed to settle the suit, just get rid of the problem. They agreed to, in essence, just say, hey, look, we'll take the cars. We will agree the car is the car, or whatever is full payment on the property. We're going to say, yeah, we understand we don't have the authority to go ahead and, basically we're going to say that we're going to go ahead and accept your theory that we don't have the authority and seize issue. Because, of course, their clients don't want to pay tax on cancellation of debt income, right? So what they asked for was a ruling that this settlement, and this is what the credit union asked for. Interesting enough, the credit union is asking the question, was this, in essence, they said, we don't believe this is an identifiable event that requires us to file a 1099-C. Now, I say it's interesting the credit union asked this question, because in one theory, you never ask the question, you never ask for a PLR unless you can live with the no answer. Okay. My guess is here the credit union probably suspected the answer is no, but they knew it'd be a big fight with the plaintiff's counsel if they simply said, we don't care what you say, we're going to issue 1099-Cs. So what they did was they included some things, and actually you can see them, and when they talk about this case, they'll tell you about some of the stuff we're going to see in the actual settlement and what they did, where they're trying to set it up to give the best possible chance that the answer will be no. But the credit union still insisted on the letter ruling, which I'm sure they also said, look, if the IRS won't give us a ruling saying we don't need to issue 1099-Cs, we're going to issue them. So I suspect that's where we are. End of the day, the IRS will disagree in this case. They'll say such an event requires a Form 1099-C. Okay? Now, what are identifiable events? Well, there are a few of them here. A discharge of indebtedness under Title 11, the Bankruptcy Code. A cancellation or extinguishment of indebtedness rendered unenforceable in a receivership, foreclosure, or similar proceeding. Cancellation or extinguishment of indebtedness upon expiration of the statute of limitation for collection of that debt. Cancellation or extinguishment of indebtedness pursuant to an election of foreclosure remedies by the creditor. Cancellation or extinguishment of indebtedness rendering the debt unenforceable in a probate or similar proceedings. Discharge of indebtedness pursuant to an agreement between the specific applicable entity, the credit union, and the debtor at less than full consideration. And discharge of indebtedness due to the creditor's decision or defined policy to discontinue a collection activity and discharge the debt. When the first of those occurs, right, assuming multiple of them may indicate that you have this cancellation event, when the first one occurs, that's when you're required to issue the 1095-C or 29C for that year, and you're required to specify that date as the date of the discharge, which can be important under Section 108 for things like where you bankrupt at the time. Okay. Now, as said, the letter requested, as they tell us in private letter ruling, they requested that they be said there's no reporting obligation because the court order that granted the final settlement would not be an identifiable event. Okay? Now, they talk about the facts here. The entities of credit union identified organized in State X. When debtors default on loan, they sent the pre-filled notices. Two of the debtors filed a class action lawsuit, and they allege the defects in the pre-sale notices they sent violated the law, trying to clearly state whether a borrower owed deficiency balance. So essentially, the creditors, and it appears, they don't ever openly state that here, but it appears that they were asking for being not having to pay the deficiency. So that's what the fight is. So essentially stating that these would be non-recourse loans. Now, if that were true, that these are truly non-recourse loans, and there are some number of issues that would arise here, but a truly non-recourse loan When that debt is settled by the creditor taking back the security, since the creditor has no right to get a deficiency judgment, the creditor has agreed to take that asset in full payment of the loan. That means there is no cancellation of debt because the debt was fully satisfied for its terms. They got the car, right? They got the house. Whatever they got, it was fully satisfied. That's how this would work. Okay? The identifiable event here is found in section 1.6050P-12F, and it talks about an agreement between the parties. When the parties agree between them for less than full consideration to take the debt, they're saying, well, we're taking, that's the position here. We're saying, the settlement agreement simply agreed to take the car as settlement, right? That would be it for the debt. Now, the taxpayers are saying, they say, no, right? This is not, right? Their request for ruling contends it does not reflect a motion, but rather is a recognition that the write-off of the deficiency balances was required under state law. The IRS disagrees that the settlement proves that, right? Well, they said where the application is, pre-sale notices may have been a factor in your decision to settle, probably was. Such considerations are typical whenever you settle an agreement. There are many reasons why we might settle a lawsuit. Even if we think if we litigated all the way, we'd win, there's always the risk of litigation, and regardless, there's a cost of litigation. This might be a PR problem for the credit union. There's lots of potential problems here. So bottom line, they're saying that that doesn't really count for this case. And the fact that we approved, the court approved the settlement also doesn't. They had the court actually, claim that they had independently researched it and discovered, and they concluded that state law would have barred collection. But the court said, the IRS said, wait, neither party really wanted the judge to rule otherwise. This was not an adversarial. We didn't have fully briefed positions on both sides. We didn't actually have adversarial proceedings and the judge considering weighing the evidence. This was one where only one side presented evidence, and it was very clear they both wanted the same answer. So this isn't really a judgment, and to be honest, they essentially were going to discharge this regardless of what the state law was. They had agreed to discharge it, and that had been agreed upon ahead of time. So they're saying, now, what you had the judge do isn't going to count for us. That's not going to count for our purposes, right? That doesn't count. Okay. They noted that the credit union vigorously pursued litigation, including contesting class certifications throughout the pendency. It is only beneficial to a settlement agreement with the class members that gave up a disputed claim. The debt write-off is due to the settlement agreement, not due to the court's subsequent order. In essence, you had an agreement, you asked the court to bless it. So that wasn't what caused it. It was a settlement agreement that you agreed to that caused it to happen. So the ruling is solely related to whether the 1099-C must be issued. This is important. This does not mean we've resolved whether or not the debtors need to pay tax on these amounts. That hasn't been dealt with yet. The taxpayers can and probably should, depending upon how good they think their evidence is, argue that in fact this was not a cancellation of debt. The IRS has put on notice with the 1099-C that there might be an issue here, but that doesn't mean it's taxable. It doesn't mean it's taxable unless the client can show they were insolvent. The taxpayer may be totally solvent, not discharged in bankruptcy. Clearly, we don't care. We don't qualify for any exception. It still might be there is no discharge if this truly always was a non-recourse debt and there wasn't a conversion, that took place. And generally, I would say, especially some recent cases have suggested that if a lender decides to pursue a path of, foreclosing or repossessing property, that by the nature of what they did ends up meaning the debt's non-recourse, even though they could have gone another route and had a recourse situation. We had a recent tax court case, I think it was about 2 years ago, that essentially ruled that, hey, that's fine. It was a Duffy case. I remember the history there. But, it's fine. It's still a non-recourse debt and there's no COD. Rather, it's a sale of the property for the amount of the debt. Okay, finally, we have reported early in the week by Kristen Perillo in Tax Notes Today Federal on May the 9th that the ABA section of taxation meeting, IRS to tweak Schedule K1 reporting of recourse debt was the title of her article. And what's interesting here is that at that meeting, Adrienne Mikulášek, sorry, Adrienne, I probably mispronounced your name, IRS Deputy Associate Chief Counsel for Pass-Throughs and Special Industries, was speaking in one of the sessions. And what Adrienne told us was that the IRS has plans to revise Schedule K1 Form 1065 for 2023 returns, not for 22 returns, but next year, the 23 returns. Now, we all know how popular the changes to K1 reporting or partial reporting in general have been recently. I know it was seen to be very popular going to tax basis reporting of capital accounts, especially when we decided that 743B adjustments do not end up in partners' capital, but 734B ones do, and some of the other rules. And then we had the whole K2, K3 situation for the last 2 years. So now we're going to get a brand new thing for change, and we know how much you love change. This change is going to be information requested on the debt allocation to each shareholder, and specifically going to be asking about some breakdowns of the recourse debt portion of it. Remember, currently on the 2022 and earlier K1s, you'd be asked to say how much recourse debt was allocated to the partner, how much non-recourse debt, and how much not qualified non-recourse debt was allocated to the partner. We're going to now have a couple of more things asked about, right? From Ms. Perillo's article, they're going to revise the form to separately report a partner's share of recourse liabilities from deficit restoration obligations or partner debt guarantees. Now, she says that's not just to give us better information, but to make sure the partners are aware that, they are legally on the hook to pay these numbers. Now, I suspect the question becomes, I'm glad the IRS wants to go on this, campaign of making sure partners are fully informed. Seems more like something, the SEC or some securities organization would be more involved with in making sure you're fully informed that you might be on the hook for more than you see here. My guess is part of this is to eliminate a potential defense, at least from penalties and the like, that the taxpayer wasn't aware that, this means by recourse you would have to theoretically pay this under some condition. So they, even if they were aware and even had a letter to them saying, yeah, you'd never need to pay this, there's no situation you would ever need to pay it, they might still have done it for basis because they didn't understand how that was done. So part of it is, I'm sure, to eliminate that. I didn't understand. I didn't know that if I would not have to pay the number, that means it wasn't debt that should be on that line. So I suspect that's part of it. I suspect it's also part of it that the partnerships weren't really great at reporting this stuff, right? Now, when this comes down, and it's supposed to come down in the fall, is what I've been told. Now, again, that could mean anywhere from late September to mid-December. That would still technically be in the fall. I'm going to guess hopefully it's earlier, and hopefully we see this in September, right? And we're going to be looking for the draft instructions, specifically seeing exactly what does the IRS want on these lines, in what form, and how do we determine the parts there. And hopefully they'll give us some guidance in that area, either on the instructions via FAQs or whatever. That could also give us a clue on what the IRS is looking for. It may be also they're interested due to concerns partnerships are improperly handling, how you treat partner guarantees and debt restoration obligations when computing those numbers. I wouldn't be surprised, if part of this is education, part of it is to eliminate the, oh, I didn't know defense. There are various reasons for this, but we do expect it to come. So keep your eye on it. When it comes out, take a look at the draft instructions so we understand what we're supposed to be doing. This has been the Current Federal Tax Developments for the week of May the 15th, 2023. Current Federal Tax Developments are brought to you by Kaplan Financial Education and your state side of CPAs. If you have questions, you can email me at edzollers@currentfederaltaxdevelopments.com. I'm also online on Arizona and New Jersey's Connect sites, along with the Connect sites in Illinois, in Minnesota and Washington to some extent. And I do look in for if something gets posted on Idaho's discussion group. So have access to any of those. You can post something there. And if I see it and I think it'll be of help, I'll try to post something there. Otherwise, we'll see you back here next week for more of what's going on in current federal tax developments.
This Creditors in Commerce classroom session, hereinafter session, is the private exchange of ideas and concepts between the providers and the recipients. The content is not meant as legal advice. The use or attempted use of any idea or procedure discussed in this session as applied to the recipient's own personal transactions, cases, or controversy, or applied to other cases, may or may not result in a favorable outcome or the same outcome as discussed in this session. Each transition or transaction, case, or controversy may be different as a result of unique actions or unique statements made by the parties therein, and each different act or statement in any transaction affects or may affect whether any procedure or idea discussed in this session is relevant to your transaction or that the outcome thereof will be depicted as in this session. The discussion of ideas or procedures in this session is not exhaustive of the subject being discussed. Many ideas and concepts that can affect the outcome of any legal or commercial procedure are not discussed in this session, and the fact that you may not be aware of these issues may have an adverse effect on the outcome of your procedure. It is the responsibility of each party to understand his own transactions and to apply the appropriate and complete concepts necessary for a procedural and substantive remedy thereto. This session may be redistributed privately by any recipient to another recipient requesting them, conditioned upon the fact that this notice is provided therewith. If you have any questions, you may contact Brandon by email at harmony@creditorsincommerce.com or by telephone at 702-866-9077.
All right. I know that a lot of people are really anxious to get going on 1099 OID kind of stuff. And so what we're going to talk about today is money, how it's created and how it moves through the banks. And from your understanding of how money works, you'll understand exactly how to fill the forms out correctly by just reading the instructions that the IRS gives you and not listening to some other person telling you, yeah, and you put this information here and you put this information here, and it seems to be completely contradictory to the instructions. There's a reason for that, because they're doing it wrong. Okay? So first I want to start with a little creditor exercise. Anyone just want to create a short little list? What is wrong with the world? Anyone got any suggestions to put on our list of what's our wrongs?
How about nothing? Money.
Well, nothing will be the background. And we'll let the list of things be the foreground. War? Corruption.
Money.
Debt.
Money, debt.
Choosing unconsciousness.
Unconsciousness?
Yeah.
Conflict. Imbalance.
Hold on. I don't write that fast. Well, I'll read the list. Okay, sorry. I forgot we don't have microphones on right now. All right, so far we got war, corruption, money, debt, unconsciousness, conflict.
Reverse priorities.
Reverse priorities. What's another way of saying that?
Disease.
How about... Actually, I wonder if debt/debtor handles that. Is it being a victim, refusing responsibility? Is that kind of what you mean? Okay.
Yeah, somewhat.
Okay, anything else?
Liberty.
The booty?
Liberty.
Liberty? I'm like, that's what's right with the world. All right, liberty is what's wrong with the world. and stake?
No, liberty and stake. Yes. Liberty at stake.
Okay, so instead of that, how about, so what's the opposite of liberty?
Voluntary
servitude.
There we go.
Okay, so slavery?
Yeah, slavery.
Okay. Alrighty. So we got war, corruption, money, debt, debtors, unconsciousness, conflict, and slavery. That's a good list for now. How many would say that war is wrong with the world? Show of hands. Okay, maybe half the people. How many think corruption is wrong with the world? Okay. How about money? Money. Debt. Okay. Unconsciousness. Okay. Conflict. Okay. And slavery. Okay. Who didn't raise their hand for any of them? Just one? Okay. Alrighty. So those of you who think war is wrong with the world, there's war in your heart. Those of you who think corruption is in the world and think that that's a problem, then you have those feelings about you. Money, I would say that's like an abundance conversation. There's not enough. I would say, what are you withholding from the people around you? Yourself. Debt. If you think debt's a problem, debt is what creates commerce. You can't have interaction without somebody being a creditor, somebody being a debtor. Debt. So those of you who think debt's wrong with the world, maybe you're not being a creditor. Unconsciousness. How many of you feel that you're unconscious? And conflict. I'm sure everyone here has conflict in their heart, or else we probably wouldn't be here. And slavery. Who are you holding in bondage besides yourself? So, you've been charged. Does anybody disagree with the charges? Perfect. Creditors? No? You accept it. You accept it and you pay it. You're a creditor. Okay. So I just wanted to thought there'd be a nice little exercise just to let you know that there's actually nothing wrong with the world. Everything that's wrong is just what's wrong inside. And good news, you have complete power to change that. And then the world around you will reflect it. Okay, so let's see if we can get into money. There's actually a couple documents that I'm sure everyone here has an email address, and you put it on the list. Okay, you'll receive a link that'll have several documents in a zip file to download, and most of the techniques we go over tonight are in those documents. Read them thoroughly, know them. If you want, if you wish to learn about where I'm getting this information. The information is coming from the Federal Reserve and the IRS. That's where most of the information I'm going to present to you tonight comes from. Okay? So it's not some magical place where it may be or it may not be. This is straight from the horse's mouth. The Federal Reserve document that covers this topic is called Modern Money Mechanics. It was put out by the Federal Reserve Bank of Chicago. There's an affidavit on there by a Walker F. Todd, and he was actually an expert witness on money for the Federal Reserve. And there's the code sections from Title 26 of the Internal Revenue Code, 1271 through 1275, which cover original issue and original issue discount. Then there's the instruction sheets for the OID from the IRS. There's publication 1212 from the IRS, which is on OID. And there's also some sample forms in there. Just to give you guys an idea of what the forms look like and what you'll be dealing with if you choose to deal with these documents. There's an example 1099A, an example 1099 OID. When I'm referencing and talking about the documents and we talk about what you do with what, whenever I say copy A, I'm talking about the red scannable top copy. That goes to the IRS usually, well, always. Then the next copy is called copy B for recipient, and that is the copy that goes to the recipient. And copy C, which is the payer's copy. And then same with the 1099A, it's a 3-part form. You must get these forms from the IRS because they go through a special scanner that needs to read this ink a special way. 1099A, copy A, 1099A, copy B, and 1099A, copy C. Now, this one isn't payer and recipient. This one is lender and borrower. And I don't know if we'll actually get to doing any 1099A stuff today, but we'll get as far as we can. Yeah.
Why is that scan? Should we hold the questions until you have a mic?
Yeah. I forgot we want the questions to be on the mic.
Why are those being scanned? Is that like a high volume item now?
Yeah, all 1099s, whether they're 1099 miscellaneous, 1099 INTs, even all your W-2s, when your employer sends in your W-2s, they're on a red scannable sheet like this. The IRS takes them and feeds them into a computer. That's how they get into the system. And then you take your copy typically and staple it to your 1040 and do whatever you're going to do with it. 1096 is a transmittal form. Whenever you send 1099As or 1099 OIDs to the IRS, you send one of these with it. And this is the transmittal form. Okay? Alrighty. Let's do money. Alrighty. Does anybody know how money is created?
Signatures.
Signatures. And what does the signature create?
Commission of Contract and Commerce.
It's evidence of a debt, usually.
Okay.
So we pass money around. The money we use is debt, right? A check is evidence of a debt. If I sign the check and I give it to you and I write it to you, it's evidence that I owe you money. Okay. So what happens with the Federal Reserve and your bank when you deposit funds is if you endorse a check and deposit it into your bank account, and this is straight from the Federal Reserve, okay, your check goes to the bank, or you deposit your check endorsed to the bank. The bank gives you a, let's say it's $1,000 check. This pen is broken. I need new black. Okay. Thanks. That's cool. I'm going to do the liability side first. So how many are familiar with double entry bookkeeping? Okay, for every asset there's a liability. Okay. Right here is a $1,000 liability for the bank is created. The bank sends the check over to the Federal Reserve. Let's see if we can fit all the ledgers on here. Federal. Okay. Okay, so bank sends the check over to the Federal Reserve. Federal Reserve says, okay, go ahead and put a temporary credit right here. Okay, for every asset, which is in black. Did you give me a new one?
That was the new one.
That was the new one?
Yeah.
I'm good. Don't mess with the mics. Yeah, no, I will need a new one. This one sucks. All right, we're just going to write in red. Stay away from that thing. All right, so $1,000 asset, which is the security, the check itself. Now, what happens is the Federal Reserve holds over here the bank's account. See, the bank itself has an account over at the Federal Reserve. You've heard of reserves, that we're on a fractional reserve system. Well, whatever's over here in the bank's account, this side is a liability to the Federal Reserve, but the Federal Reserve holds an asset over here to offset that, okay? So you have this credit is the same as this liability. It's a credit for the bank. It counts as their reserves, so they can fractionalize it 10 times, okay, and accept loans based on that. So you have your $1,000 in an liability account at the Federal Reserve, which is the reserves of the bank, is the same as the assets over here in the bank's ledger. So on the bank's on their ledger, it's an asset. On the Federal Reserve's ledger, that money is a liability. So now the Federal Reserve gets the check, and they notice that it's from Bank C. Okay? So they debit Bank C's liability account, or the Federal Reserve's liability, Bank C's asset account, which reduces their reserves by 1,000. Whenever a bank's reserves get reduced, it must reduce its deposits by equal amount. So the bank is now put into a position where it must reduce its reserves by $1,000. So what does it do? It reduces your account by $1,000. It says, hey, since you're the guy who authorized that check, we're going to reduce your account down to 1,000. Okay? So, is the check itself money? No. It is. I'm here to tell you, it is. It's got a signature on it. It's a negotiable instrument. It's money. Okay? So, $1,000 endorsed check went in here. The credits got put on temporary hold here. When the bank when Federal Reserve went to this bank and said, hey, we're going to reduce it for 1,000, is that okay? And they look at the account number, they go, yeah, that guy's got $1,000 in there, go ahead. So they reduced the account. Now there would be another ledger over here for Bank C, and Bank C would list this money as an asset, and it would have deposits over there that it just reduced by 1,000. Okay, so that's what happens when you deposit a check. Oh man, and this black doesn't erase either. Yeah.
So it's a number. After the signature, it's a number until it actually hits the place that it's going, and then it turns into money.
It's money the moment you sign it.
So it's a note.
Now remember, all we showed was the bank's ledger.
Yeah.
You have your own ledger.
Yeah.
Okay? Your trust, your corporation has its own ledger. It was on the books of your trust until you deposed yourself of the funds and gave it up to the bank. Okay? Now, whoever wrote you the check, the check itself ends up over at their bank eventually. You remember back before 2000, they used to send you your checks back?
Yes.
When was the end of the last bankruptcy? 1999? Okay, you know why they don't send you your checks back anymore? They're securities. Now, what? So, here, now we're moving over here, we were dealing with Bank A and the Federal Reserve. Now we're going to come over to Bank B and show what happened with that same check. Okay? So over here at Bank B, we're going to put two ledgers. We're actually going to leave the Federal Reserve out of this because you saw what happens at the Federal Reserve for Bank B. So Bank B, this is the deposit account, so to speak. It went negative 1,000 for Brenda when she, or for Dylan when he sent Brenda his child support check. So this account went down 1,000. The check itself is a security. Now, a security is an asset to the bank, okay? So it gets ledgered over here as an asset. However, it is not in the Federal Reserve account. Remember, what they can leverage is what's credit on their Federal Reserve account. So this is being held in an escrow account at the bank, this $1,000 check as an asset. But there's no liability funds over here for it, so it's just sitting there. Now, a bank can sell, when a bank needs capital or it needs reserves, according to the Federal Reserve, there's one way a bank can increase its reserves: selling securities. So the bank can sell the security. Who are they going to sell it to? Federal Reserve. Who's the Federal Reserve going to get the funds from? Treasury. Okay? So, and this, like I said, follow modern money mechanics, and you'll see the flow of funds and how it's moving. Okay, now this check is sitting over here. Your account, you're Brenda, and your account's been reduced by $1,000, right? And your bank is holding this security up here, okay? This security has a face value. The face value of the security is whatever you wrote in on the amount of the check, okay? That security is actually your property. The way the bank gets away with selling it is they have to wait what's called a testing time or a testing period, which is 36 months, according to the IRS, before they can declare it abandoned. Then they can sell it and increase their reserves. Okay? So, because they've got this $1,000 security, at the end of the year, Brenda goes to do her taxes. And she remembers that security she created, and all of a sudden she remembers that the bank never sent it back. She did not get her security back. So, what happened? It's an original issue discount is what happened. The original issue was, Brenda writing the check. Brenda wrote the check to Dylan. Dylan deposited it. So, Brenda wrote the check ended up back in this escrow account. Okay? So, the definition of original issue discount is the redemption value minus the issue price. Okay? How much did Brenda's bank pay her for that $1,000 security? Nothing. What's the redemption value? $1,000. So what's the original issue discount? And if the original issue discount is $1,000, did they give her the $1,000? No. So it's been withheld. Okay? If you look at your if you look at your 1099 OID, there's information for the payer, information for the recipient, an account number. Box number 1 is the original issue discount. Now let's say that that's the only check Brenda wrote that year.
We got some new marks for you.
Okay. If that's the only check Brenda wrote that year, then there's $1,000 in box 1, because that's the original issue discount. Okay? Now, seeing as Brenda's not a financial institution and didn't put any interest terms or anything on the instrument, she didn't write, 5% in 2 years or nothing like that. She just wrote $1,000 on the check. So, box 2 and 3, which box 2 is periodic interest and box 3 is early withdrawal penalty. None of those exist, so they would be zeros on the form. Box number 4, federal income tax withheld. What is the federal income tax withheld on this particular transaction? $1,000. Okay? So the $1,000 of the original issue discount, which is the redemption price or redemption value minus the issue price. Okay, that's the original issue discount. And the amount withheld is how much did they hold on to that they didn't give you? And they didn't give you any of it, so they withheld the entire amount, $1,000. So, box 4 is the same as box 1, the total amount of original issue discount, if it's all been withheld.
Can you explain how that $1,000 is defined as a federal income tax?
How it's defined as a federal income tax?
How is it a federal income tax?
The bank itself is withholding a tax. For instance, if the money is due to you, you're the original issuer, that's the redemption price, and they paid nothing for it. So basically, since they're withholding those funds, they're acting as an agent for Internal Revenue on those funds. And if they wait the 3 years, they get to sell that security. Now, then they'll pay the tax on it. But until those 3 years are up, it's probably just sitting there. Okay? Yeah.
What if you have a joint account? Then what happens then?
If you have a joint account, it doesn't matter because each person is authorizing the funds. It depends on whether you file a joint 1040. Is it?
Wait for the mic before you ask your question.
Oh, sorry. Okay, so what if the joint person passed away? Then do you just file yourself?
You could. How would you file your 1040 as a widower?
No.
See, the thing is, when you have a joint account, typically you're married. Is it a situation where the parties are married or no?
No.
Okay. So it's a joint account. You're married. Some parties are writing checks. Like both parties are writing checks.
Yes.
Okay. So realistically, you're both creating the credit each time. So it depends on how you're going to file your 1040. Is she going to declare original issue discount? And if she is, which checks is she declaring? Is she only declaring the ones she signed? If so, that's fine. Realistically, you can both sign for the full amounts on each, as long as the other doesn't. So if one person's going to file all the OID, that's fine, because you're a signer on the account. Whether it was your signature or not, you're an authorized representative on that account.
So for past checks that she wrote, and we're joint, I can claim those checks that she wrote because I'm joint on it?
Yes. Were you joint on the account at the time?
Yes.
Yes. Because realistically, you're both agents of the account, and you're both trustees on the account. So the funds need to be claimed back if the person's deceased. If the person's deceased, then there's no way for them to claim it back. So you'd have to claim it back. Otherwise, you're letting it sit. See, what happens if you don't claim this back? You just created debt.
In the world.
Yes. Okay, this security outstanding and not coming back to you creates debt. Every time you spend money in public, you're creating debt. If you don't get it back, the debt just gets bigger and bigger. So people, I know, like to ask the question, well, how much is out there that we could get back? And in reality, how much debt have you created? It's at about $10 trillion right now. That's how much debt we've created. Okay? And we've never claimed any of it back. Well, I take that back. Some people have been doing this since the 50s and 60s, getting these funds back in different ways. But realistically, the modern movement, I would say late 80s, late 90s, really, for the OID end of this. So since the late 90s, there's been a lot of people claiming the funds back, but not enough to reduce the debt significantly. Microphone.
How many years back can you go and if you have a box full of old checks? What are those?
What's the testing time?
36 months.
36 months. After 36 months, this shit's gone.
What if you're holding the original checks?
It doesn't matter. Okay. Oh, wait, you have the original checks?
Right, before.
Well, you were supposed to send those to Treasury. See, now you're not in the same position. See, they're doing you a favor by keeping the checks. See, when they sent the checks back to you, well, now you got to send them to Treasury, and it'll credit your account. But it's better for them to hold it and let them deal with the Federal Reserve and Treasury.
So you're talking strictly, is this a physical checks only? Or if you're
No.
paying out of like my auto, like just paying out of my online account to Visa?
Okay. So how did you pay?
I just clicked the box that says pay Visa $500 and.
So what was it, a debit card transaction?
Well, just out of my checking account. Electronic
transaction?
Electronic.
EFT, is that what they call it? ACH? You put your account number in?
Yeah.
Okay.
It's right out of my checking account, so it's
okay.
Union Bank.
Any transaction you authorize out of that account creates a security. Okay. Back in the day, everything literally had a written security with a signature on it. Remember, even to get cash withdrawals before ATM machines, didn't you have to sign to get that cash withdrawal? Right. Yeah, because you're creating a security with a face value on it, and that goes and sits in the asset account. Okay, so and that's why credit cards have the signature on the back. Every time you swipe it, you're signing your name. Every time you enter a PIN number, you're signing your name. Okay, and it creates a security. So all that goes out of the account, really, you're authorizing the issuance of. Even when your bank just says, oh, yeah, we decided to give you a bounce check fee of $45. You authorize the creation of those funds. And that's sitting over here as a security. Okay?
Yeah, sure. So if you get your original checks back, does this affect how you fill out your tax forms?
If you get your original checks back.
Right. Without sending them to the Treasury and you're holding them, I mean...
If you're holding them, then there's no original issue discount. Now you haven't redeemed them, right? There's a redemption value to them, but you haven't redeemed them.
So now, okay, so then say if I do send them into this place within before 36 months, right? Does that affect how and my account gets credited, right?
Right, but it may only be through Treasury. So I don't know if there's any recourse for you to actually get the funds back. You could give it a try. But maybe send a couple of them to Treasury with a cover letter saying, hey, send me the funds.
But are you supposed to fill out your 1099 or forms?
No, because there's no original issue discount. At that point, the security wasn't withheld from you. They returned the security. So now it's up to you to redeem it. So you can choose to go get a redeemed. You're sure they're the originals too, right? Not copies?
This is just hypothetical.
Oh, okay. Because I know they send out copies, but they usually make a big deal now if you want your originals.
Oh, really?
Yeah. Because, like I said, probably something happened at the end of the last bankruptcy that this may have been part of the resolution of the new debt, was that they were going to hold these securities that we're creating and not return them.
But we don't know that for sure.
No, but that's when it changed.
Right.
It was at the end of the last bankruptcy. So I think it's interesting that that those events correlated, but it doesn't mean anything. Give it what meaning you will.
I just had a quick question. So just given the question, how much debt have I created, and that there's a 36-month period, is there a way to settle the debt prior to that, to whenever I started creating debt, like with having a bank, 15, 16 years old, having a bank account, checks, that's like, is there a way, to create an even, flat, because if I don't redeem that escrow from way back when,
right,
there's a gap, right? It's got sold. So is that created? Then is that like complete?
Yeah.
Or is there a way to redeem that to just? I mean, not like I'm going to get funds back, but is there a way to just settle the debt that I've created?
If there's open accounts, like for instance, if you had a checking account that you no longer bank through, or if you have an old credit card account or old loan account or whatever. Those accounts are probably still sitting open with your security sitting in there?
Even if they're more than 36 months old?
Possibly, yeah.
So there's a way. I mean, again, without necessarily getting funds back, but just taking responsibility for closing that escrow account to not create debt in the world.
Right, and you can do that, but that's not through the OID.
Okay.
That'd be with the A, the 1099A.
Okay, got it.
Okay, that'd be what you'd use to go close the accounts. Basically, with the 1099A, you're coming in and you're saying, hey, acquire that asset.
Great.
I'm acquiring that asset. And by you acquiring the asset, there can be no liability.
Okay.
So for instance, you've got an open court case, and you acquire the asset of the court case, there's no more liability, the court case goes away.
Got it.
You acquire the asset in your loan account, let's say it's $100,000 over here that they loaned you, that you loaned them actually.
Yeah.
We'll get into that.
Right.
So there's $100,000 sitting there, it's an asset. And so there's a $100,000 liability over here. You do an acquisition of this asset, which is the promissory note you created. That's a deposit instrument.
10 years ago.
Yeah, if the account's still there, now you're not going to get this money back.
No, I'm just saying
You're just going to close this account. Yeah.
Just creating
Yeah.
debt in the world.
Right.
Reclaiming it, creating a complete
Yeah,
zero
because
balance.
getting rid of the debt. Yeah, getting rid of $100,000 worth of debt in the world.
Okay, cool.
But if it's less than...
Wait, microphones. Where are we at?
Just to clarify, though, if it is less than 3 years old on that home debt, you can get the money back. If you may be able to.
Yes, but why would you? And how would you? See, it wouldn't be with the A, but what happened when you signed the promissory note? Isn't it just like a check? It's got a face value on it and your signature on it. Okay, so it's a security. So when you deposit it, okay, this is actually slightly different than an endorsed check because you actually made it out to the bank. You made it's like as if you walked into your bank with a check from a different bank account, but it's your bank account over at Bank D, and you sign it and you deposit and you write it to your bank. You basically be just giving them $1,000, right? So that's what you did with the promissory note. You basically did a cash deposit, which created $100,000 in asset and automatically created the liability funds in the deposit account. You know what happened to those funds? They went to the seller. So basically you went in, did a cash deposit, they gave you the cash back, it went to the seller, but they're greedy. They're like, we're not going to just do this transaction for free. So they give you some bull about, oh yeah, it was really tough getting you that loan. So we're going to need some money down. And how much do they demand minimum for a down payment?
20-30%.
The lowest, 10. Well, isn't that interesting? So if they got 10%, isn't that reserves? They just got reserve funds in the amount of 10,000. So what can they create out of that? Another 100,000. They got enough out of your down payment to create the entire amount again. Then they get you to pledge your property to you paying in on another security, which they're going to sell because of the future value in that. They're like, hey, we got this security that these chumps are paying in on. So your security may only be worth $1,000 a month, but you staple it to a couple thousand of those.
10 times.
Yeah. So they sell these bundled securities and they're like, hey, check this out. Do you want to buy this? This thing makes $10 million a month. Will you buy it for $100 million? And some other bank goes, yeah, we'll buy a $10 million a month security for $10 million. So now they get $10 million. So they already got the $100,000 back from the new deposits they were able to create when they took the down payment. Then they sell the security on the future values that's going to probably equate to, if not the full amount, close to the full amount of what they loaned you. But what actually happens is, and even according to the Federal Reserve, is you're the one creating the money. When you walked into the bank and deposited the promissory note, you authorized them to set up an asset here and a debt here. Okay? The debt is your deposit account. But because you were buying a house, they said, okay, well, we send the funds over to there. However they did it. Cashier's check, direct bank transfer, however they sent it there, that was the funds you deposited. But the security's still there. So remember, what happens now that this liability's been cleared out? This security's over in this column now. So they've got $100,000 over here that they can't do nothing with until they what? Sell it. And then when they sell it, they have $100,000 more in reserves. Okay? So, How much did they pay you for that? Huh?
We're paying
Yeah, they didn't pay you anything for it. So what's the issue price? 0. What's the redemption value? 100,000. What's the original issue discount? How much did they withhold?
Can we get into the interest or the down payment with that original issue or not?
Say it again.
If they're withholding just the $100,000 amount, but now they're charging us as creditors for the down payment and the interest.
Right.
Is that something we can get an original issue discount for also? Is there a way to create?
Well, remember, the payment in the form of a promissory note, that's an original issue discount that you're due, right? That they're withholding your security. Yeah. However, haven't you been like a sucker making payments?
Yeah.
Okay.
Yeah.
So all those payments you've made, where do those fit in? They don't fit into this ledger. They fit into your other ledger.
Right.
Because you're writing checks out of your other bank account. See, this has to do with the mortgage company, these ledgers. But your ledger with your personal bank, remember, everything that goes out. So all the payments that you paid in on your house payment,
you're getting the interest.
You just get it back from your OID on that bank account. You don't mention the mortgage company. The mortgage company has nothing to do with the payments you made. And neither does the note.
Right. So roughly technically, you're getting the original issue discount back, the $100,000 from the mortgage company, and then also the 1099 OID from every payment you've made out, or at least just because there's a way that it's overlapping is what I don't.
Okay. Run that by me again.
So if, for example, if this is the mortgage company we're talking about,
right,
and we want a 1099 OID the mortgage company for the amount of the $100,000,
right,
and close the account.
Okay.
We'll close the escrow account, so we're getting the $100,000 back because the escrow.
You can close it. If you closed it, you come over here and you grab this asset. There is no more liability.
Okay.
Right.
Right.
Okay. So if you file an A on this, there's no more account. You don't owe anything.
Right, but say that's 3 years.
But you also want to get the money back on the promissory note? You can.
However that overlaps, because like say you paid your $100,000 and it's been 3 years, so you're like, okay, I want to get that escrow account closed and the money back from the mortgage that I've, that note amount, say it's $100,000. Plus, I've now been paying out mortgage payments and interest and all that stuff every month, so you 1099 OID the bank as well.
Right.
For those payments?
Everything that goes out of your bank account just gets reported on 1099 OID for your bank.
Okay, but that's separate from the mortgage company.
Yes. Okay. So realistically, the only OIDs you would ever fill out would be for the bank for your checking account, the bank for your credit card, and if you have multiple credit cards and they're with different banks, there would be one for each.
Yep.
And then if you have a mortgage that you put a promissory note on, it would be the one for the bank that
bank with the mortgage
that you lent your money to. Yeah. Did you have a question? No.
If you had a corporation, can the corporation do this whole thing instead of the person?
Okay. The corporation doesn't have the ability to create a security. Who creates the security for a corporation? Yeah. So the trustees of the corporation, right? The various officers, agents, those are the ones creating the credit.
So I wrote out $1 million worth of checks out of the corporation.
Right.
Is that me?
Yeah, it would be on your 1040. The 1099 OID would be with you, not your corporation.
Wow.
Because you're authorizing the creation of the funds.
Yeah. Well, there was $1 million deposited, and then I wrote out the checks.
Yeah.
So I can OID.
Yeah.
Personally. That's separate from your personal bank account.
Yeah, it would just be its own OID because it's a separate account. Even if they're at the same bank, you'd have to fill them. If you read the OID instructions from IRS, if it's more than one account at a bank, that's what that account number box at the bottom of the left-hand side is for. You put if you're reporting the amount on your business checking account, then it would go down there in the account number, the actual account number.
Okay.
And then, if you guys want, we can go over the details of the form. Any more questions about the flow of money?
I have a question about the mortgage. You're saying when you usually sign, say, a mortgage, they'll have the amount of the loan, but then they also show, like, in 30 years it matures to such and such, and it's... So how does that play into this? Because when you sign it, are you signing for the amount of the house being sold or the mature amount of the loan? Are you creating that also?
Realistically, now this is my own opinion. Okay, I'm going off of the Federal Reserve documents here for a minute. I believe that initial $100,000 has nothing to do with the note you signed. It has to do with the credit application. It has to do with the credit application, because what happens is they come back and they go, oh, you got approved. What happened was they just got money. They just got paid. But they want to try to trick you into paying something totally different, and they want to get as much money out of it as possible. So they come up with the whole down payment, and we're going to have to add more interest, right? We had to add a couple points of interest to it. And so they start changing what the actual application did. The application goes and grabs the funds necessary for the purchase of the house. The note, with all its interest and all that, I believe that's a separate security. Maybe not. They may be tied together. I know the application is a necessary part of this, though, because it's the application that has your Social Security number on it, and that's what's generating the credit. So without the application, the instrument becomes worthless.
I have a great question. Well, at least it's for me anyway. Okay. So the practice of buying and selling people's debt right now.
Right.
So if I signed over for a settlement company to buy $120,000 worth of debt, corporate debt for a company I was closing, my signature allowed them to buy that debt from me.
Somebody came and bought the debt from you?
Well, they took over all that debt for me,
but it was your debt originally.
It was mine, right?
Okay.
Right.
So you assigned it.
I assigned it, but there was this whole legal thing with this signature thing I had to do online to make sure the signature was legit and all this stuff, right? And this has been like 5 months ago, and I was supposed to pay them like $300 a month to manage and negotiate my debt eventually for me, right?
Right.
And they said it may take up to, a year or so because it takes a while, and your account's going to build in our bank account, and eventually all the accounts will be closed for you. And I haven't heard. I've actually stopped paying because I was going to write them a letter should they say I'm late on my payments, because I started learning about this. It's been 5 months. I've not paid them $300. I'm wondering if they used my signature and had the power of attorney to actually OID my $120,000 within their 3-year period, since I abandoned it.
Right. Actually, everybody who's a member of the United States has the authority to use your credit. Anyone with a fiduciary capacity. They use your credit all the time. You just didn't know it.
So good for them.
The county uses your credit.
Yeah.
Whenever you receive a bill that has a payment coupon at the bottom, they actually used your credit to generate those funds in an asset account. What they're telling you is, here's the payment coupon if you want to send us the liability to fill it. And if you did a banker's acceptance on that payment coupon and sent it in, what they should do, I'm not saying they will do, but what they should do is get rid of the asset. Or you could just file a 1099-A on that account, but if it's your electric account, you probably don't want to do that, because then electricity will disappear with the account. Right. That's not a good thing. But if it's an account that isn't a necessary or you want to close, by grabbing the asset, because it's your credit that creates these assets. Okay, here's something I didn't mention that I probably should have. No entities, public entities, can create credit. Only you can. Okay? Only people with signatures can create the credit, and that gives the banks the ability to create the liability on their books. But you're the one always depositing credits, always giving up the credits. They come back with the liabilities. Asset, liability side of the account. They're always over here. And you're always creating this over here. But all you spend in public is what's over here. So this is the debt side, and this is when you get Federal Reserve notes or you withdraw from your bank account, it's coming from over here. The asset doesn't get touched.
So I have the right to find out whether they actually 1099 OID'd on those accounts worth $120,000.
1099 OID'd on those accounts. They couldn't have OID'd them because they didn't.
They just sold them.
There was no original issue discount that they created.
I'll OID them. Okay.
Well, OID who?
The bank that took my credit over, that took all my credit debt, corporate debt.
Did they? Okay. Let's think about this. Okay, so
I opened an account with them.
So they have, but you have a liability with them. You have to pay, right? So all you can OID with them is the $300 checks you're writing, and you would OID it with your bank.
Right. So what happened to the 120? It was
I mean,
it was literally
you can go and close all the accounts.
Yeah.
That's the only thing you can really do with those. Whatever they're doing with it, you have no evidence of what they're doing, so I wouldn't put it on a tax form. That's another thing that a lot of people are saying out there. Oh yeah, just fill out a 1099 OID for it. If you don't have any evidence of something happening, then I wouldn't fill out a tax form on it.
All I know is it disappeared, and I'm just wondering. So I get that it's on my credit accounts,
the accounts could still be open.
Okay.
So you could go through and close them.
Yeah.
Filing a 1099A on them with box 5, which is debtor needs to pay this back. I'm paraphrasing, but that's what box 5 is. Check it no.
Got it.
Okay.
Okay.
And if you check that box no and fill out the 1099A properly, you acquire the asset that's holding that account open. If you acquire that asset, the account closes. They can't hold a liability. Remember, you're the only one who has the ability to create credit, and the only way they can hold an account in public is if this asset's over here. Now, how many of you are going to be blown away when you realize that this is exactly how the courts work too? Except the judges or the bankers.
Just a quick question about what she said. So could technically she ignore the credit consolidation company, 1099 OID her bank account for the $300 she paid them?
She would add one more 1099A.
Okay.
For the debt consolidation company, because they gave you an account number, right?
Yes.
They said, here, we send you a monthly statement, and it's got an account number that didn't exist until you made a deal with them, a contract. You did create a security, and that asset is holding open that account. So you would have to do an A on that account, and it would grab that asset, and it would close the liability.
But it also computed for me and added up the maturity amount of the loan. They actually went out 22 years. If I don't pay them anything, what I'll actually owe them in 22 years or whatever, right?
Yeah.
So
it's meaningless.
Yeah. Okay.
So
if they have an asset now.
Yes.
Well, but here's
your security. Whatever you put your signature on is a security.
I think that's my next business, but yeah. I'm curious.
But just to be clear, so she can 1099 the bank for the money she paid to this credit consolidation company.
Right. 1099 the bank.
Says on.
For the $300 payments. Yeah.
Okay, and then but she'd also 1099 the credit consolidation company. Is what you just said.
The same thing.
No.
What did you just? Okay.
And a 1099A on it, not an OID.
1099A on the consolidation company. As far as the credit cards that she gave to the consolidation company, could she then 1099 OID those, or does that up to the consolidation?
Probably could.
To close
because the accounts are probably still open.
Right.
And there was original issue discount with every transaction you authorized on those credit cards.
Right.
But that's separate from closing it. You might want to do the OIDs first and then close it, because so that the IRS has some books to look at. Because if you close the account and the IRS goes to look for the books,
what
account are they talking about?
What's the difference between 1099 OIDing those credit accounts versus closing them? That's what I guess I'm missing.
What's that?
The difference between 1099 OIDing each credit card account?
All you're ever OIDing is your transactions that go out of your accounts. So when you use your debit card, when you write a check, when you withdraw cash, when you use your credit card, those are all OID events. When you're...
Well, let's say, for example, you have 2 credit cards, and you write them checks. Those are all still through your bank.
That's through your bank.
Okay, so you don't need to worry about the credit card companies at all.
No, not the payments you're making to them. Because the payments you're getting back from your bank, because it's the bank that's withholding the original issue discount with your credit card payments.
Okay.
When you use the credit card, that's when you would OID the credit card company.
I guess if you paid the credit card companies cash, then you would OID. No, you're still taking it out of your bank.
Yeah, it's still out of your bank. Yeah.
You got less than 10 minutes.
I wanted to know if for dependents that you're claiming on your income tax, they have a job, they're working.
Right.
Who gets to do that? Should the children do that themselves, or I'm not sure.
Oh, you mean, okay, so the children have bank accounts.
Right.
And you're
they're
declaring them as a
working.
dependent.
Yes.
It's really something only they can do. Because only they can authorize the creation of funds out of their account. Are you a signer on their account?
No.
Okay. So really, if it has anything to do with their account, then they're the ones authorizing the creation of funds. So they can OID it on their 1040.
Right.
But you're not in the transaction.
So make sure she understands that if she's taking deductions.
You're getting way ahead of yourself.
I found a little flaw here. So if my bank account is closed from that corporation,
right?
Can I still 1099 OID the closed account?
Has it been less than 3 years
Yes.
since those securities were created?
Yep.
The securities are still there. And the account's not closed. Just your access has been cut off. Okay. All right, so real quick, I wanted to give you an example of the same ledger. Now, let's say you're a true debtor, and not only did you refuse to pay your credit card off, but you refused to pay the collection agency they passed it to after that, and now it's in court. So now the attorney for the collection agency files a complaint for money in the amount of $10,000. What is the asset in the bank? A court, by the way, a court is a bank. If you look up the definition of court and bank, you'll find court in bank and bank in court. It is a bank. You're in a bank, and everything's commercial, so they're treating it like banking. So, does anyone know what the asset is that opens up the liability that they're going to try to attach to you? What's the asset that creates the liability that they're going to try to attach to you, the defendant? The complaint. The original signed complaint. The original is, does anyone know where the original complaint is held? In the court. Where in the court? Because you're an attorney. When you take in a complaint, you file it, right? They keep the original, though, right? Yeah. Where does that original go from there? Judge's chambers. The judge has a vault in his chamber, and it's a vault, and it's because these are worth money. They are securities. So the judge is holding the security. So if you file a 1099-A on the asset, and you acquire the asset, the liability goes away, and they can't attach it to any parties. Simple accounting. Okay? Go ahead. Oh, microphone in the back. Who's got the microphone?
Turn it on. Use a marker that works.
You guys can't see, huh? Yeah. I'll try one of the new ones.
I was wondering, when you do that and you 1099-A that in the court, is that all paperwork before you even get into the courtroom? Is that something you file ahead of time, or would you do that?
It's something I would file ahead of time. Well, unless there's no amount. I mean, I've seen cases filed where they haven't attached an amount to it yet. Then it's a little tricky, because there is a security sitting there, but because the amount hasn't been put in there yet, you don't know what to claim.
Could you just put a big one?
You could. and the rule of thumb is 300 million.
Yeah, should cover it.
Yeah. So 300 million should cover it. If you've got multiple federal felony criminal charges, you would actually be talking about a lot more. Probably 400 million per charge.
In order for a check to become a security, you need three things on the check, right?
What are those?
One is a signature, and there's two other things, isn't there?
Okay, so we're talking about a money order, really, because all negotiable instruments are money orders. So, what's essential on a money order?
The date contract.
Oh, that's a good one. You guys got one. It should actually be above the line I'm writing. Okay, so put date, the issue date, date of issue. Date. We'll say Jan 15th. Not me. 2009. Okay, what else? Accounts. We'll put the accounts at the bottom.
The two signatures.
Two signatures. Why do you need two signatures on this instrument?
Between the two.
No, we're just talking about the most basic negotiable instrument.
Signature.
Signature. Okay, well, we'll do pay the amount first. Pay $10. And then you'd write $10. Right? Okay. Who's it going to? Pay to the order of. Pay to the order of. And Todd. He was the first one to claim the abandoned property. Okay. Account, somebody said. Memo. 1, 2, 3, 4, 5, 6, 7, 8, 9. And signature. That's all you need. That is a money order. So whenever you hear me talking about money orders, I literally will write one just like that. Doesn't need to be any fancier than that. Date, pay this amount, pay it to this guy from this account. There's my signature. I authorize the creation of credit, just like I do when I sign a promissory note. You're just authorizing the use of your credit to create an asset. What about a traffic ticket?
Said or a traffic ticket?
Yeah, when you sign a traffic ticket, it's a money order.
Nice.
A traffic ticket is a money order. It's an order for money. What is a law called before it becomes a law? It's a bill. Okay. Yeah, if you guys want to, like where the audio downloads for the classes and stuff will be, it's on my website. And that's great.
You have to write slower, yeah.
It's creditorsincommerce.com. Also, you guys will be receiving, everyone who's signed up on the list, you'll be receiving an email inviting you to have access to our private network. And in the private network, there's tons of educational type documents that I recommend that I feel aren't too misleading. Again, not everything's 100% right. I'm putting it out there that there is nothing for you to get out of those documents. There are no tricks. There are no special documents. There are no special words that you're going to know or memorize that are going to make you a creditor. Being a creditor has nothing to do with the technology, has nothing to do with these forms, has nothing to do with the commercial process. Being a creditor comes from being a creditor or being that giving in life in general. I stress that it happens at the spiritual level first. If you're not coming from being a creditor with all the people in your life, it's trying to do it in commerce is going to be an exercise in futility, because you're automatically going to fall back to controversy. You're automatically going to fall back to adversarial proceedings. You're automatically going to put up defenses. You're automatically going to take a position. And these are all things that debtors do. Being a creditor means being able to come from any given moment to bring a resolution. So no matter what confronts you, no matter the degree or the intensity of the controversy, it is within you to bring the remedy or the resolution. And that's what we're advocating more than anything else. Like, yeah, these are neat technologies and it's neat to understand the accounting and the economic system. But realistically, this is a very, very spiritual venture. If you're not a creditor in your heart, this won't go well for you. It's going to be a bad experience. Okay? So I'm just, there were a couple people outside approached me. They didn't have the benefit of being here at the first class. So I wanted to maybe put down a little more foundation. I think we're kind of moving into it with discussion of creditor. Is there anything that anyone feels that maybe we discussed at the first meeting that they didn't quite get and that they had a question on microphone?
It's actually not that I didn't get it. I just thought it might be really
relevant.
Yeah, it wasn't that I wasn't.
Is it on?
Yeah, it's on. Well, hold on a second.
Nope. It wasn't that I didn't get it. It was just something that really made a big difference in the way you began the program, which was talking about the history of bankruptcy in the United States and the sovereignty, 7 years of sovereignty, and then like every 70 years that, and then also bringing the biblical element of it. That really laid a huge foundation, I think, for me in the first class.
Yeah. So one of the best resources that I would consider for commerce is the Bible. The actual Bible is the commercial manual for everything that's happening. For everything that's happening in commerce. It's basically a manual. Your civilization is based on it commercially. So we can go into a little bit of history. I don't want to touch on the stuff I already did, though. That seems.
Well, it's on the audio, MP3.
Yeah, there are audios and videos available. I just want to make sure that they get something out of the rest of this class. If there's something foundational that we can put in here that'll benefit for their understanding of what we're talking about.
I think what's great is you showing, that the law of commerce is the number one law, the tiers, just like what you started off with. Forms. Just that basic, foundation.
Okay. Yeah, we'll do law forms and jurisdictions. Actually, that's a great place because without understanding that, you really don't understand what's going on. Okay. So, there's a pyramid of law. Okay. The top of the pyramid is what I would call natural law. And natural law is what makes it possible for your various elements of the earth to come together and form the experience that is you. Okay? So there's first natural law. From natural law, you get things like human beings and cats and dogs and things like that. As soon as human beings started interacting with each other, that created the second highest form of law, which is commercial law. Why do you think that that's the second? And actually here, I'll give you a great example of when we transitioned from this to this in the Bible. In the Bible, we started out with natural law in a non-commercial zone known as Eden. There was no debt. There was no commerce. Okay? However, God gave the law. And one of the laws was that if you eat from this tree, you will surely die. Okay? And at the moment they ate from the tree, did God kill Adam and Eve? No. They immediately traversed into a new jurisdiction. And that traversal created commercial law. And not only did they traverse, but it really was the foundation of what we call admiralty law. Okay? Because in admiralty, you can discharge a debt. There is no execution on a contract in admiralty. Okay? In what is commonly known as common law and law of the land, there's always execution on the contract. Whereas in admiralty, there's discharge of your debts. So God gave them the option to discharge their debts with the blood of animals. That was the money of account that he accepted. Oh, we didn't go into money of account, money exchange. It's actually money of exchange. Okay? Your current forms of money of exchange are Federal Reserve notes, checks, credit cards, debit cards. That's money of exchange. Okay? When you write a promissory note, it's a credit instrument and is money of account. Okay?
Say that one more time. When you write
A promissory note and put it in, that's money of account. Okay? So basically, they were given the opportunity to, and rather than die for their sins immediately with execution on the law, the option to discharge their debts. Now, does discharge get rid of the debt? No. It sets it off to a future date. Okay? And that's what you're doing in commerce right now. You never really pay anything. You're always discharging a debt. You're offsetting you're discharging the debts and your sins to be paid for at a future date. Okay?
That's not how we got the problem in the first place.
So then the next on the pyramid, whoa. I guess would be common law.
Where's admiralty law? Is that commercial law?
It falls into both of these, actually. See, admiralty is more of a jurisdiction, not a law form. But admiralty is where we've operated in and out of admiralty throughout history. Admiralty became really popular in the 1500s when we started sending ships out across the sea, and things like insurance and stock and all forms of negotiable instruments. That's really when admiralty came into being the common law. And it was officially declared common law by Lord Mansfield in 1753. He said basically, yeah, admiralty is part of the common law now. There's too much of it going on for it to not be considered common law. And then, as through the 15 and 1600s, they realized during this spiritual evolution of humankind that all people are vessels in the sea of space. And there's no more appropriate law form for vessels in the sea of space than that of admiralty. So they basically, your body's a vessel, but you are not your body. You're the captain of the vessel, but you don't physically exist in this world.
Is that what Jesus taught us showed us when he walked on water?
Walking on water, I would say it's also a metaphor for having a command of admiralty. Mm-hmm. I walk on water, I don't sink.
Mm-hmm. Can we be spaceships instead of boats?
It's a vessel. I didn't say anything about it being a boat. You associated it with a boat. Okay, so after common law, next step down on the ladder would be good old, I'm thinking, statutory law. Now, statutory law, well, first, actually, we didn't really go into common law too much. Common law is like a group of people get together and decide this is how things are going to go. And common law is also how things have been done in the past. So common law is kind of an amalgamation of what we generally agree as a society and how we've based our judgments of commerce in the past. So that's really common law. Whenever you hear like reference to past court cases. They call that case law. That's part of the common law. It's not that it's necessarily written in a book anywhere. They're just saying this is the maxims of law for our society. This is generally accepted. This is how we do it.
Eye for an eye.
Eye for an eye. Common law of the land. See, now because common law has kind of been mixed with admiralty, you've heard of the law eye for an eye. Okay? And that was the old biblical law, the Old Testament, the old contract, which was execution of contract, which used to be known as common law, but now because common law involves admiralty, it's to distinguish between the two, we'll call it law of the land versus admiralty. And the law of the land was when you owed, you paid. You couldn't discharge it to a future date. It happened now. If you can't pay now, well, then you're working for me. You become my involuntary slave until the debt is paid.
So then that would be part of natural law or natural law forms? Is that the jurisdiction of natural law forms?
No. Law of the land? Law of the land is a common law. It's
Okay.
what we decide as a people to participate in.
Common law would then have two subdivisions, law of the land, law of the sea.
Possibly. There may be more to it. But you could divide those up, but you could also do the same with commercial, And then statutory law is laws recorded in code, in statute, in the various, let's say you get a society of people or an association of people, and let's call that association of people the United States. The United States decided that we were going to publish the general guidelines of operating within the United States, and we call that the U.S. Code. And then each of the states have their own code forms, and we've got government code and tax code and all these different codes, and that falls really way down here on statutory law. Now, because you have unlimited right to contract, you originally were up here in all your dealings with people. I mean, really, the original jurisdiction is up here, but contract doesn't happen up here. As soon as you get into contract, it happens here. Okay? Exactly. Interaction even. Doesn't even involve language. Because it's really contract. See, people think a contract is written or signed.
That's the last language.
No, that's just a memorialization of the contract.
Right.
Contract is by agreement and is by performance. If I say to you, you're going to pay me $20. Anyone hear a rebuttal? No, she just agreed to pay me $20 because she didn't respond at all. The fact that she stayed silent means that she agreed. That's a maxim of law.
Isn't that like an invisible contract?
Yeah. But again, remember, contract is strictly by performance. If you're accepting a benefit of the United States, you're in contract with them, whether it's signed on a piece of paper or not. The fact is, you're operating a trust known as a U.S. citizen, and that trust receives benefits from the U.S. corporation, and because you're accepting the benefits, you've agreed to be part of these laws right here, or to act within the bounds of those laws. They didn't have to get you to sign the statutes. That's the application. The application for live birth. They're saying, hey, there's this new commercial unit in the world, and we need to get it a berth, B-E-R-T-H, in admiralty. It needs to be able to sail the seas of commerce as all the other vessels can and do business. Can you please register our vessel? They said, sure, we'll register your vessel. And they gave you a birth certificate. Okay? And then the last form of law, I would say, is political, or the lowest on the totem pole. It's political law. And the example I used last time was soccer. Soccer, and the reason I like soccer is because, one, I play it, and I loved it, and I played it for my whole life, but I also refereed it. And being a referee in soccer, you're trained to be a judge. And as a judge, you're only concerned with the laws of the game. However, not one of the laws is black and white. It's all interpretation, which is exactly what you're dealing with in the courtrooms. That's why things never quite seem to go the way you think they're going to go, because the judge is a referee. He's looking at your intent. He's looking at your action. He's not only looking at the act, because the act could be harmless, whereas if the intent is harmful, he's looking at that. And remember, I used the example of Solomon, King Solomon in the Bible, when the two women fighting over the child came before him as the judge, and his only responsibility is determining who's the creditor, who's the debtor, because the creditor is going to get the remedy, or the creditor is going to get the benefit of his decision, because the creditors win, debtors lose. That's just how it is. Creditors control, debtors are controlled. Okay? So he said, how about we just chop the baby in half? And the one lady's all, no, don't do that. Give it to her, that's fine, but please don't cut the baby in half. She can have it. Who got the baby? She did. Because she was willing to risk it all. She's a creditor. Creditors are willing to risk it all. Okay? So
settled the matter.
Yeah, she brought resolution. Yeah. She brought the remedy. Yeah, so that makes her a creditor as well. So you see that being the creditor isn't always the one who brings money. You bring remedy, you bring resolution, but it doesn't mean you bring Federal Reserve notes in your pocket.
I have a question.
Mm-hmm.
You said judges are the referees.
Yes.
Isn't that in a perfect ideological world?
Yes, because really they're bankers in our world.
Right. Well, so, but like for example, in the Winston Shrout stuff, if you call which jurisdiction they're in, you can actually, being a creditor, you can ask them what jurisdiction they're operating in, and it will force them to own whether being a referee or a banker. Isn't that, I'm not being rough about it.
But do we need to go there? Because no matter where they're at, we're there as creditors to bring a resolution. So if they're there as a banker, good. Here's my money order. Take care of this. I'm out of here. Okay. If he's there as a judge, well, I'm not there to argue anyway. So here's my evidence. I agree and accept everything they say. Here's the remedy. Or here's my evidence. But if you're going in there for controversy, adversarial, anything to oppose anyone in there, you're a debtor. And you're going to lose.
And even then.
Yeah, and even then. Okay, so let's do a little what I like to call jurisdiction A, jurisdiction B, because I always talk about that, but I know that it's because I've listened to so much Jack Smith. To me, it means something, but to most, it probably has absolutely no meaning. Okay. So, jurisdiction A would be the equivalent of de jure. Jurisdiction B would be, and there's actually a space in there, de facto. Jurisdiction A would be the republic. Oops. Jurisdiction B would be the democracy. Come on, work with me. Jurisdiction A would be, what's another way of breaking it down? Private. Jurisdiction B would be public. Yeah, well, that's the trust. We can do a breakdown of the trust again, too. All right. So, jurisdiction A, which is where the United States originally, in 1776, existed, we'll say. Okay? Now, since then, everything that's public or part of the government is over here in jurisdiction B. The only remnants of the republic in jurisdiction A, post office, Secretary of Treasury, and really the post office is on both sides. Well, actually, the post office is over here. The Postal Service is over here. The Secretary of the Treasury, the Secretary of State, and the Attorney General all sit over here in jurisdiction A. They actually had to expatriate their citizenships to serve in those positions. And it's because they're the last remnants of the Republic.
That's the exemption of foreign sovereign. Sorry, I'm screwing it up. Isn't that the Foreign Sovereign Immunities Act? Is what they did for A is to become expatriated?
No, they just expatriated. I don't know if it had anything to do with the Foreign Sovereign Immunities Act, because their positions have existed a lot longer than the Foreign Sovereign Immunities Act. So the Foreign Sovereign Immunities Act has to do with foreign sovereigns, but what's a sovereign? Anyone know what a sovereign is?
Well,
It's actually really simple.
an emancipated person who knows their rights or free.
Are you taking a position that anyone can take those things away from you? Or that anybody has control over you?
No. No.
Okay, so
Originally, no.
Okay, well, are you
sovereign
suggesting that now that you don't have that?
Ask me the question again. Ask it again.
Give me your answer again.
Okay, so sovereign is free, emancipated from myself and others.
Free from others.
Yeah.
Okay. And what is evidence of that? What demonstrates that?
My will, my knowledge, my faith.
So don't you always have your will and your knowledge and your faith?
Yep.
No matter what?
Yep.
So what makes you a sovereign?
Isn't it free from the system that was created to...
Who created it?
Our environment, our city, or wherever we are functioning, created this system that we have to supposedly follow. So when we're sovereign, we don't follow that, but we also gain benefit from that.
Who created it, though?
Man, people.
Aren't you one of those?
Yes.
Okay.
But sovereignty in that sense, is that what you're talking
are you
about?
saying your creation controls you?
Yeah.
Are you taking a position that your creation can control you?
Yeah. In this case, yes.
Okay, so you believe that your creation controls you. Okay. Sovereignty. So being a sovereign would be not being controlled? Is that your position?
Yeah, not being controlled.
Okay. Basically, my simple definition of what a sovereign is in control. You control your property. If you don't control your property, you're not sovereign.
Yeah.
Okay. If you don't control your property, somebody else does. So what's that make you? Debtor in possession. Right? Right. So you're debtor in possession. So you really have no sovereignty. Sovereignty is just about control. Do you control your life? Do you control your body? Do you control the things in your life? That makes you sovereign. And you have absolute control. We like to pretend like we don't, because that's a whole lot of responsibility when you look out at the world and you say, oh, this is what I created. This is what I'm responsible for. And that's why it's really easy for people to go, no, it's the devil, and it's the Rothschilds, and it's the Bushes, and well, I mentioned a couple of them.
So own no thing and control everything?
Own no thing and control everything. That's being truly a sovereign. So, how many people think Rothschild controls the world? What? Good. Because he doesn't. He's chosen to take a much higher level of responsibility than all of you, but that's it. That's the only difference between you and the Rothschild family, is that they take a very high level of responsibility. That's it. Same with the Queen of England. She takes pretty high level of responsibility. Pope, high level of responsibility. Brandon?
What were the three secretaries? There was the Secretary of State, Secretary of Treasury, and what was the other one on the A side?
Attorney General.
Attorney General.
And I mean, we can go into that and how and why they are what they are and how they operate. But easiest way to put it is they're foreign agents. And jurisdiction A is always foreign to jurisdiction B. And jurisdiction B is foreign to jurisdiction A. However, B was created in A. So B is the creation of A. Can a creation control its creator? No. So ultimate control in commerce comes from which jurisdiction? A. You can't control over here in B, because B is a creation of A. So B is always controlled by A. So who controls the country? Who controls jurisdiction B?
Creditors.
The creditors. And who represents the creditors in the United States? Secretary of Treasury? Secretary of State? Attorney General. They represent the interests of the creditors. Who's the IRS collecting money for? Creditors. Do creditors pay taxes? No, they get your taxes. You pay the taxes, creditors receive them. Creditors don't pay taxes. And when you learn to be a creditor to the United States, you'll never owe them another tax dollar again. They'll be paying you big bucks because they'll be returning your principal. That's their job. They're there to work for any creditor. That's the beauty of it. IRS is your best friend. Love them. Because if you're a creditor, they're out there working their butts off for you. Revenuing. That's the internal revenue service. They're revenuing from private to public, from public to private. That's their job, moving the funds from one side to the other.
Just a quick question. Is the reason that Secretary of State, Attorney General, Secretary of Treasury, foreign agents, is that the way that they can then communicate with jurisdiction B because they've expatriated?
Well, if they can communicate with B before they expatriate.
But it's creditors and debtors that there's a gap in communication.
But everyone in B can communicate with each other, and everything in B is public.
Right.
So they were there before. So who couldn't
so they
communicate?
expatriated from B into A.
Because?
So they could communicate because they're creditors. And because they can then...
No, they're not the creditors.
They're not?
No, they represent
the
the creditors.
Okay.
So they needed to talk to people in what jurisdiction?
B.
No, where are the creditors at?
Well, A.
So that's why they had to get out of here. They had to get out of B. But they can't interact with these people over here.
Okay, but they're B who became A, but then they can communicate with both.
Right. Okay. But they'd actually, if they were over here and in acknowledging what's over here, they could be hung. That's why a judge in jurisdiction B can never recognize jurisdiction A because he's committing treason against jurisdiction A. Right. Okay?
Right.
So that's why you can't bring your private process into a public hearing and expect anything to happen, but you're delusional. Because he's protecting everyone in that room. His job, the judge's number one job, protect the public. And if you go in there and start talking about stuff over here, yeah, he ain't going to listen to a damn word you say, and he'll probably throw you in jail real fast because you're damaging the public. He can have you can say something that gets if he says the wrong thing, him and every attorney in that room could be hung.
What was that acronym?
Hanged.
What was that acronym we had with people like it's something reality disorder or alternate reality disorder?
Right, alternate reality disorder. Yeah, you walk into jurisdiction B talking about jurisdiction A, you have what they now call alternate reality disorder.
Was there a year that these Secretary of State, Treasurer, and Attorney General was required for them to expatriate themselves? I mean, was that always from the beginning of our country?
No,
or was
it wasn't
that
from the beginning.
Like 1933?
It would have either happened in 1859, the end of the first bankruptcy,
right,
or 1929, the second bankruptcy. See, in 1859, who lost their sovereignty? Well, let's go back to the first bankruptcy. Who lost their sovereignty in the first bankruptcy?
The entire country.
The national government. No, not the entire country. The national government, which had just been created. It was only 7 years old. Yeah, 1782 was when the national government was created. Actually, you may consider, officially created in 1782. 7 years later, no one would pay the debt. They went into the first bankruptcy in 1789. International bankruptcies run for 70 years. Fast forward 70 years, we get to 1859. What happened in 1859? The Civil War. Who lost their sovereignty? The states lost their sovereignty during the Civil War. So it may have happened then, but probably more likely it happened in the beginning of the third bankruptcy in 1929, fall of the stock market, the New Deal, and you're about to get a new Deal, and this New Deal isn't going to be as good as the last one, if you consider the last one good.
I was just going to say, okay, so 1859, the states lost their sovereignty?
Yes.
And then in 1929, the people lost their sovereignty.
The people lost their sovereignty in 1929. But they gave you something in exchange. Remember, they can't just take something from you without giving you something of equal or greater value in exchange. And they gave you the power to create money.
Okay.
They said, we're taking away all your legal titles, which creates what? Fascism. If the government has all the legal titles, that's fascism. However, they gave you something in exchange. They said, but you're in charge of creating all the money. So we're going to take away your gold, we're going to take away your silver, we're going to take away your legal titles, but here's the benefit. You get to create all the money.
To become bankers.
Yeah.
So then in 1999. Who lost sovereignty?
1999. Well, I don't know. We're moving into a new Deal. I guess we'll see. But I don't imagine it's going to get any better for the debtors. It's not going to change for the creditors because it never does.
I think we lost who we are.
Well, if you're a creditor, no matter what stage in history you're in, you're a creditor. And none of those bankruptcies or fictions or insolvent entities have any effect on you. You operate outside of them. You're feeding them. You're the one helping them out. You're coming with the solution.
But I think it's becoming. I think in 1999 it became a spiritual loss.
You think
really,
so?
like
Spiritual sovereignty?
People losing who they are.
Well, what did we lose? What did we lose control of? Realistically, I think probably what happened in 1999. I think you got to look at what was really going on with the Clinton hearings, because it probably has something to do with that, because that's what was happening. Remember, in history, it always seems like something else is happening, whether it was their signing of the Constitution in 1789, or the beginning of the Civil War in 1859, or the crash of the stock market in 1929. Let's look. What was happening in 1999?
Well, the trade towers was shortly thereafter, too.
Right, they were, but that was probably more about destroying documents, evidence, titles.
Yeah.
Because I noticed something interesting is the Queen lost her crown on Canadian money for a little while after the towers came down. She lost her title, right? Doesn't the crown represent title? She probably lost some title documents.
Well, the Enron documents and the investigation supposedly.
Yeah, there was something there. But remember, War of 1812, when we refused to renew the Bank of the United States. Yeah. The British soldiers came over here and went into the federal courts because that's where we hold title. They wanted the titles. That's all it was ever about. That's what the Constitution's all about. We gave title to the national government to foreign creditors. And people want to stand behind the Constitution like it's a great document. It's a debt instrument. It's a negotiable debt instrument. That's all it is. It says somebody else, this country owes somebody else a lot of money. Yeah, and the states are the sureties because they signed on as sureties. Remember, each person who signed the Constitution was representing a state. When the states refused to pay the debt, they lost their sovereignty with the beginning of the Civil War. Then we became the sureties. Somehow, some way. Must have been the 14th Amendment, which created U.S. citizens. So in 1929, the people lost their sovereignty. No longer, and what's sovereignty? What is sovereignty? Control. So we can no longer control the titles to our property because they took away the gold and the silver, so we can't execute on contracts. We can't actually carry around portable property as money of exchange and exchange it for the legal title. State has the legal title to everything. We get the equitable title.
And the Federal Reserve is supposedly the fourth central bank in United States history, right?
Yeah,
okay.
probably.
So how does that
Sounds about right.
affect, since it's the fourth one, how does that affect the bankruptcy that the U.S. has been operating in for all these years? Because there's been a creation and a collapse of these three other central banks. I mean, how does that play into this whole bankruptcy thing, or did it affect it? Did it not affect it?
How did the bankruptcies affect the central banks?
How did the banks? How did the nullifications of these central banks?
The nullification of the central bank. You mean like in 1811?
Yeah. Well, there were three other ones before the Federal
Okay. Well, there was
Reserve.
the initial Bank of the United States was established in 1791. Had a 20-year charter, ran out in 1811. Was renewed though in when? Anyone know? Right around the end of the War of 1812. 1816, I believe. 1816, we get the second Bank of the United States. But then we got Andrew Jackson as president. He said, no, screw those central bankers, get rid of that piece of...
Yeah, he killed them, right.
But less than 20 years later, we had it again. It was like 1836.
So what was the United States, how was the United States operating in those 20 years?
In the Jackson era?
Right.
It was the first time in history we operated a surplus and we weren't in debt. Go figure.
So we weren't bankrupt. We weren't.
But it doesn't mean that we weren't in debt, though. For all I know, Andrew Jackson paid off all the debt. But I don't think he did, or else we wouldn't have come to the point we did in 1929. I'm thinking maybe he was just being a belligerent debtor. And nobody likes a belligerent debtor. Belligerent debtors get their countries invaded, like Iraq. And I'm not saying I don't have anything against the Iraqi people, but it's their belligerent dictator and his commercial affairs that got them where they're at. It's not like the United States is some lone nut that invaded that country. That's a commercial decision. And the central banks and everyone else is right behind it. Because if we can't perfect a security interest in someone's country, if the rule of law is not the ultimate authority in a nation, then that nation is belligerent, and we cannot do business with it. We cannot allow it on the international stage of commerce because they're a risk. They're an uncalculated risk. We don't know what they might do. And they're not letting us hold titles. If they're not letting the foreign creditors come in and take title to things, then why do we want to do any business with you? If we can't secure our business dealings, then there's no point in us doing business with you. And if we lock them out and isolate them, that's going to be much more damaging to the people. You try to isolate them in a world community, in a world economy, and realistically, the way I see it, the evolution of human beings and the human race has more to do with us being one community. Like realistically, this whole idea of, go USA, I'm over it. I'm not a nationalist. I love my country, and I love the place where I live, and I love my community. But nationalism, it's a dangerous thing. Remember, all the Nazis were hardcore nationalists. Okay? So nationalism is a very dangerous thing, and I believe that the evolution of this planet is getting out of it. If we have no division among the people, and we see ourselves as one community, we see ourselves as one community without division, without controversy, then we'll have what I believe to be a balance, at least.
Isn't that congruent with the loss of spirituality?
I don't think you can't. How can you lose spirituality?
Well, because it becomes a spiritual conversation. If you're losing that, it's not contractual.
Oh, microphone. It's gonna be me sitting here listening to silence on the video.
I'm saying, isn't that congruent with the loss of spirituality in 1999 because there's not any paper or other person that is governing the loss? It's individuals reclaiming who they are, and as a result of reclaiming who you are, we're all one. And if you don't, you become sick or diseased.
I would say if the debt was not paid in 1999, what happens since here's what probably happened. Remember, they took legal title, right? In 1933, we can no longer have legal title. And what, with the new bailout, is the government able to do?
Homes.
No, what can they do? They can buy, what are they doing with that bailout money? They're buying stock in the companies, right? So now, not only do they have legal title, what else do they have?
Commercial title.
Equitable title. So now we've gone from fascism to communism. In a communist government, they control the equitable and legal title of property. So it looks like that's where we're heading. If we don't step up and be creditors, you already have a communist country, but it'll only get worse.
Well, I think Rome fell because there was just a lot of laziness, and the caterpillar finally burst. And I think it was an attempt to do it without God. And in a sense, we're doing that now. We're attempting to operate as individuals without our own sense of God and our own sense of control over our own domain. So everyone's now looking to see, what can I do? I'm losing my house. And
everyone's been victims for all this time.
Yeah.
We've all said, no, you do it. I'm not responsible for where this world is at.
Yeah.
The government needs, it's almost comical to me how everyone thinks Obama is going to save the day. It's like, really? You really expect a politician to swing in and save the world? And it's funny because you look at a lot of the politicians who try, and I think Kennedy was a great president, but what he was doing, he wasn't looking at the bigger picture, because he was trying to bring back the silver standard and really trying to disrupt the commercial system. And if the rule of law isn't governing, and you don't want to be in law of the land and execution of contracts. You don't want eye for an eye. Yeah. Remember, we've got the New Testament, the new contract. And the new contract is everything's prepaid. There was no sin. There was no debt. Jesus prepaid it. And isn't it interesting that the symbol of Christianity is a freaking double entry ledger? Isn't that interesting? That's the symbol, is the double entry bookkeeping. We got assets, liabilities, and he prepaid your debt. So now we're dealing in a different system of commerce. We're no longer executing on contract. I say let the government have all the legal title. But you take control of the government. Stop letting things run amok. It's not because there's one guy who's sitting there with his computer or his master board with switches and levers and buttons controlling the world. I mean, literally, imagine controlling the world would be like trying to herd 7 billion cats. Okay? Attempt that. And that's about how much control you can have over the world. You can't control the world. Nobody can control the world except for me. Nobody can control my world. I'm in complete control of my world. And when I choose to disregard that and be irresponsible and step back into being a victim, completely disempowered. I have no power to make any changes, to do anything. I'm standing back here as a victim to the world I created. A victim to my own limitations, my own belief that I have limitations. You're refusing to pay your own debts. Remember we were talking about being a spiritual creditor? Okay? Well, there's nobody harder on you than you are. And if you're constantly dragging behind you all those things that you can't forgive yourself for, those debts, those sins, you need to learn to discharge. Because if you can't get rid of those debts, good luck doing anything in the commercial world. Because if you can't step into being the creditor spiritually and giving, what does a creditor do? A creditor gives. If we got a world full of takers, what the hell do we have? We have a mess. Yeah, a bunch of takers. And that's why there's no balance. I'm not saying get rid of the debtors. We need debtors. Without debtors, there's no commerce. Commerce is fun, admit it. Commerce is fun. We like commerce. It's what created this great world around us. If we wouldn't have had all this fake money that they came up with, do you really think the world would be where it's at? No, we would still be in the Stone Age. The fact is, this whole hypothecation and creation of money out of your signature is what's made this world. And it's a great thing. It's just there's not enough people stepping up and taking responsibility and control of it. And that's an imbalance. That's all it is an imbalance. We work to balance it. As creditors, we're going to become creditors, and we're going to teach those around us to be creditors. We're going to bring it to balance.
Growing up.
Yeah, we are. Because really, America was kind of, the debtor nation. From the very beginning, we said, fuck you, right from the beginning. Yeah, just like little kids. Yeah, and then, and here we had the opportunity to be a truly sovereign nation. And we blow it in the first 7 years of us being a nation. That's how childish we were. We were like, no, screw them. Debtors, refusing to accept and pay. And that's really everything that we're going to go into. If the spiritual end of being a creditor isn't with you on all this, you're going to create your problems. You know why? Because you can't forgive yourself of your debts. If you can't forgive yourself of your debts, guess who's going to be punishing you for them? You are. You're going to create the situations around you to punish yourself for the debts you refuse to discharge. Right? So,
Can you outline kind of what the different steps we'll go through, what we'll cover over not necessarily, week by week, but just overall, like what we're going to cover?
Yeah, we'll discuss all the taxing, how to interact in jurisdiction B. Okay, so we'll learn everything we can about the operations of jurisdiction B. That includes the courts, which I said are just like banks, dealing with the IRS. 10 minutes? Okay. Dealing with all the different agencies that you'll be dealing with in jurisdiction B. Okay? We'll learn titles, dealing with titles, taking legal title, how to establish legal title. Okay? Then we'll talk about the most powerful part of commerce, and I want to save this more near the end of the course because I feel like you need a very solid foundation when you start stepping into the power of commerce from jurisdiction A. Because remember, I'm saying all it takes is for you to step up and be responsible, and literally when you find out how things work and how effective and powerful you can be, you'll see that you think there's somebody corrupt out there, then you take care of them, because it's that easy. And that's what I'll call loosely call it the administrative procedure, which is basically perfecting claims and security interests. That's all it is. When you learn to perfect a claim and perfect a security interest and liquidate, you can make a lot of stuff happen. A lot of stuff happen. It's really, you're unlimited. But we're starting with the easy stuff. And what I consider is like the jurisdiction B stuff. That's why all the educational materials you're going to get are all from the government. Because they're the best. They're telling you how it works. They're not trying to hide anything. They put it right there in black and white so that you can, if you decide, take responsibility for this mess. But the fact is, we've all chosen to make them responsible. And when I say them, the politicians, their whole, I mean, I'm not going to make any judgments or take any positions on that, but they haven't done a too great a job so far getting us where you want to be.
Aren't they just manifestations and mirrors of what we haven't dealt with?
Exactly. 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 Everything that, remember our list of what's wrong in the world? Exactly. That's what's wrong in us. It's what we're missing. You'll never see an end to war until you see an end to war inside you. And trust me, the war inside you is the worst war of all. I mean, the fact is, people join the military to go kill other people who are also over there to kill other people. The fact is, there's people who want to go out and kill people. That's what's in our world.
Because they want to kill who's inside them.
Whatever the reason may be, there's people killing each other. I'm not saying it's bad. I'm not saying it's good. It's just what is. It's just the condition. Yeah, it's a balance actually, because if there wasn't complete freaking psychos out there, we wouldn't know what the opposite of being a complete freaking psycho is, right?
Well, we will.
If there wasn't evil in the world, then benevolence would have no meaning. If there wasn't suffering in the world, joy would mean nothing. The fact is, there needs to be a balance, and there will always be a balance. Right now, as creditors taking responsibility, it's up to us to rectify the imbalances we see. And if you see an imbalance in the world, you have the power to adjust the accounts. And it's funny because I have a lot more of a spiritual message to give, but it coincides and overlays so nicely with commerce. And I know that's really what people want to know about. Because really, you already know the spiritual stuff. I'm not giving you anything new. It's all there. You know, we all know the nature of our universe, but the commercial end of it is where we make up these elements of lack. You know, we make up that there's not enough money, that there's not enough food, that there's not enough peace, there's too much war, and there's not enough of this, and there's not enough of that. So we create all these conditions by literally making them a distinction. If you make them a distinction, if you can distinguish something, it means it exists in you. Because if it doesn't exist in you, it's not part of your reality. Just like, I don't know how many of you have seen the movie The Secret, and how the Indians, when they first saw the ships coming over the horizon, they couldn't see them. Because it wasn't part of their reality. They didn't exist in their reality. So, made no connection.
I just wanted to continue the conversation. So, at some point, maybe 2012, I don't know, won't there be an end in the duality? Supposedly, it may be then, it may be sometime in the future.
What does that mean to you? What does end of duality
mean? It means that we do, because I think that we are actually creating that we have to have good, bad, right, wrong, psychos, non-psychos, so you think, so that we can measure our good by the bad that's out there.
Okay, so
that's what I think.
So your position is that we can live in a world with only one side of the account, the asset side.
That's what I'm thinking. I mean, maybe as a possibility.
Well then,
the end of duality. That's just one way to look at what would that be like.
I suggest that it would be non-existent.
Okay.
That's like saying, yeah, we want light, but you know what? We just don't like darkness. Okay, so let's get rid of darkness. Does light exist anymore? No. There's no contrast. If you don't have a contrast, it ceases to exist.
No, I understand what you're saying, but isn't there somewhere in between where there's no emotional charge to...
That's just a choice.
Right.
You choose to give it an emotional charge. I choose to get pissed off about George Bush. Right? It's a choice. You can emotionally charge anything, or you could step up and be a creditor. No matter what controversy faces you, leave your past behind you. Because the only time you're going to create a controversy or go to adversarial proceedings is when you're not leaving that bullshit. You haven't forgiven your debts. because you're going to bring forward some past judgment, something that's going to make you a debtor in that situation, instead of just accepting it and bringing a remedy or solution.
Just a point, you talk about your message being mainly spiritual. What I get from, I'm talking the overall, I have to learn all of this other, is that you can observe the debtor position, you can observe the physical position of duality, but you rise above that and you live as a spiritual being, which there's oneness there and there's wholeness there, but you are observing the other. You're not either denying it or blanking it out or being ignorant of it. You're accepting it.
A creditor.
And moving up higher. That's what I hear you saying.
Yeah.
Yeah.
Yeah. That's a very good analogy.
Thank you.
Can I add something really fast? I always been referencing the Stately Conversations with God. Actually talks a lot about the duality, and if you really the way it explains it in there is that God, or on a spiritual level, there's no denial of anything that happens, like she just described, because there is oneness, it is all. And so, but in order for all to exist, you're also what you're not, and so you can't get rid of the duality.
Yeah, remember somebody wanted me to put nothing on the list? I said, let's let the background be nothing, because I want a list of things here. And you can't have a list of things without the no thing in the background. And that's who you truly are, the no thing. That's why when you walk into a court and they say, are you the defendant? No, I'm not the defendant. The defendant's a trust. It's a vessel. It's got all capital letters. Well, you look like the guy on this ID.
What's your name?
Are you suggesting or taking a position that I am the photo likeness you see before you? Are you taking a position that I am fused or somehow inseparable from the body? Because in reality, you're the captain of the vessel. The vessel itself could be the body. That's one vessel. The trust is another vessel. And they have titles. But the no thing cannot be distinguished. You can't hold it out in front of you and say, that's me. That's who I am. What is this? Does anybody know what this is? What is this? A pen? Marker? Wrong. Wrong. Nope. That's what it is. Those are all words and nouns. Okay? The reality is, the distinction, the things that we distinguish, what we are is the thing making the distinctions. And the thing making the distinctions can't be distinguished. It can't be separated. You are God. You are the one. You just refuse to believe it. You like to pretend like you're not, because it's a fun game. It's a fun game getting down here and then wrapped up in all the drama, isn't it? Would you really want your life any other way? You may think you do. You may think you do, but guess what? If you had the option, oh, you know what? We need to switch tapes. Why don't we go ahead and switch? All right. If you had the ability to dream an entire lifetime every night, from birth till as old as you wanted to live to be, and it would be exactly what you think you want. After a few nights, you'd be like, after the first night, you'd be like, wow, that was great. It was exactly the way I wanted it. Everything turned out the way that I wanted it to. Right? But after a couple nights of that, you'd kind of get bored, because you're like, okay, well, nothing really exciting going on, because I know it all in advance. I'm planning it out before it happens, and that's not that fun. So tonight, I want there to be a surprise. Something that arises that I don't know is going to be there. And then you'd want there to be obstacles. You're like, yeah, okay, that was fun, but there's no challenge to it. So, what's that? Groundhog Day, exactly. Keep living it over until you get it right. Eventually, the perfect life in your dream would be the life you're living right now. That would be the ultimate of where you would achieve after creating this, doing this exercise with yourself of dreaming the perfect dream every night, because all the obstacles you put in your way are the perfect obstacles for you. They're there for you to get something out of it. They're there for a reason. You're distinguishing them and bringing them to the foreground for a reason. It's to learn something. You're your own worst enemy. You're the only one throwing up the obstacles. You choose to have the life you have. That's the power you have. That once you're actually taking that responsibility, and then, learning this stuff's actually pretty simple. It's like, okay, we all have free will and we can do whatever the hell we want. So let's figure out some of the minor details of some of these parties that I'm acting with, namely the United States and the state of California and all these parties who are out there, and I interact with them, and I just want to know how they work. Because if I know how they work, well, then I know how to improve them. Because if I have a problem with the United States, I'm like, United States, not all it's cracked out, or not all that it can be, right? It can be more. It can be better, which is just a judgment on your personal part or my personal part. There's no truth to it at all. But if you don't like it, fix it. Because I'm right there with the people who want to put nothing is wrong in the world on the list. It's where I'm at. It's perfect the way that it is. Because the way that I see it, whatever imbalances I see, I'm doing something about it. I'm here with you now. And you're here. You're doing something about it. So you've chosen consciously that, you know what? I do have the power to change the world and make it what I want, and that's what I'm here to do and what I'm here to accomplish. And there's going to be the obstacles. You just got to learn how to navigate through the seas of commerce. And it's not as difficult as you may think. Microphone?
In the game of commerce, who's responsible for bringing remedy?
The creditor. Creditor always brings a remedy. That's why you ask questions. You've heard the saying, creditor asks questions, debtors answer questions or make statements. It's because the creditor is always looking
with an image of President Trump. The shirt is being printed now in Texas. It'll be shipping out to you in 1 week. Political prisoner with Trump on the front there in a mugshot jail background. It's a fundraiser shirt. It says Infowars.com on the back.